ಇದರಲ್ಲಿ ಎರಡನೇ ಮ್ಯಾಟ್ರು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕು ಬಂದ್ಮೇಲೆ ಕೇಳ್ಬೇಕಾ ಅಥವಾ ನೀವೇ?
committee.
ಅಯ್ಯೋ ಏನು ಉಂಟೋಯ್ತಲ್ಲಪ್ಪ ಇದು
ಮಾಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ
ಏನು ಗೊತ್ತಾ
ಹೌದು
ಎಲ್ಲಾರ್ಗು ಅರ್ಜೆಂಟ್ ಈಗ ಎಲ್ಲಾರ್ಗು ಅರ್ಜೆಂಟ್ ಎಲ್ಲಾರ್ಗು ಇದು ಎಲ್ಲಿಂದ ಬಂದು ಸಾಹೇಬ್ ಕೇಳ್ಬೇಕು ಟ್ಯಾಕ್ಸ್ ಎಲ್ಲಿ ಏನಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ನಾಳೆಗೆ ಆದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ ನಾಳೆ ನಾಡಿದ್ದಕ್ಕಾದ್ರೆ
ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಫೈಲಿಂಗ್ ಸಿಕ್ಕಾಪಟ್ಟೆ ಇದೆ ಮ್ಯಾಟರ್ ಹೌದು ಇಟ್ಕೋ ಎಲ್ಲ
ಸರ್ ಇದು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರು
ಕೊಡಿ
ಮಾಡಿ ಈವನ್ ನಂಬರ್ಗೆ ನಮ್ದು ಹೆಸರು ಜಡ್ಜ್ಮೆಂಟ್ಗೋಸ್ಕರ
ರಿಪೀಟ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ ನಾನು ಇಲ್ಲಂದ್ರೆ ಸಿಕ್ಕಾಪಟ್ಟೆ ಇದಾಗ್ಬಿಡ್ತು ಅವ್ರು ರಿಪೀಟ್ ಮಾಡೋದು ಮಿಸ್ ಆಗಿರೋದು
ಕೊಟ್ಟಾರೆ ಸಾಹೇಬ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಂಬರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬರುವಂತೆ ಇಲ್ಲ ಸರ್
ನಾಳೆ ಮಾಡ್ತೀವಿ ನಾಳೆ ಏನ್ ಬೇಡ ಗೊತ್ತಾಗುತ್ತೆ
ಅಪೀಲ್ ಆಗ್ತದೆ ಅಂತ ಅಯ್ಯೋ
ನಾಳೆ ಲಿಸ್ಟ್ ನಾನು ಮಾಡಿಸ್ತೀನಿ 2494 ಹುಡುಕುಡು ಫೈಲು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಅದು ಗೊತ್ತಿಲ್ಲ ಅದು ಇದು ನಾನು ಮಾಡಿಸ್ತೀನಿ
ಈಗ ಬಾರಿ ಕಷ್ಟ ಗೊತ್ತಿಲ್ಲ ಸರ್ ಎಲ್ಲ ಎಲೆಕ್ಷನ್ ಡ್ಯೂಟಿ ಅಂತ
ಇದೆಯಲ್ಲ ಊಟ ಇರುತ್ತೆ ಚೇಂಬರ್ ಇರುತ್ತೆ ಇಲ್ಲೇ ಇರುತ್ತೆ ರಿಪೀಟ್ ಮಾಡಿಸಿ
ವಿನೋದ ಹೋಗಿದ್ದಾರೆ
ಲಿಸ್ಟ್ ಬಂತು
recall sir
told yesterday even I have been allotted
ಎಲ್ಲ ಮ್ಯಾಟ್ರ್ ಕೊಟ್ಬಿಡಿ ಸರ್. ಏನಾಗೋದು ಹಂಗೆ ನಾವೇನ್ ಮಾಡಕ್ ನಾನು ಹೇಳಿದೆ ಎಲ್ಲ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟೇ ಮತ್ತೆ ಇದೊಂದು ಇಷ್ಟ ಆಗಿಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಹಂಗೆ ಮಾತಾಡ್ತಾರೆ ಆಮೇಲೆ ನಾನು ನೋಡ್ಬೇಕು
ಸರ್ ಪೆಂಡಿಂಗ್ ಮಾಡಿದ್ರು ಬರುತ್ತಾ ಯಾವಾಗ ಬರುತ್ತೆ
ಟೈಮ್ ಗೊತ್ತಿಲ್ಲ ಬರುತ್ತೆ ಟೈಮ್ ಗೊತ್ತಿಲ್ಲ.
ಆ section 42 ಇದ್ದಲ್ಲ case
ರೀಚ್ ಆಗಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಅವಾಗ ಮಾಡಿಸ್ಬಿಡಿ 43 ಅಲ್ವಾ ಮಾಡಿಸ್ಬಿಡಿ.
section 42 expert order sir ಅದೆಲ್ಲ ವಾಪಸ್ CS certificate ಕೊಟ್ಟರೆ they will consider their submission.
ಕವರ್ ಬೈ ಜಜ್ಮೆಂಟ್ ಯಾವಾಗ ಬರುತ್ತೆ
ಸದ್ಯ ಇರೋದೇ ಮಾತ್ರ
ಫಿಲ್ ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ
ಒಂದ್ ದಿವಸ ಬರ್ತದೆ ಮಾಡಿಸ್ತೀವಿ ಅಲ್ಲ ಈ ಕವರ್ಡ್ ಅಂತ ಬರ್ದಿದ್ದೀರಲ್ಲ ಟ್ಯಾಕ್ಸಾ
ಅಲ್ಲ ಅಲ್ಲ ಇದು BDA ಅಲಾಟ್ ಮಾಡಿರೋ ಸೈಟ್ಸ್
BDA
ಇದು ಮಾಡಿ
ಸರಿ ಆಯ್ತು ಮತ್ತೆ ಕ್ಲಾಸಿಫಿಕೇಶನ್
ಸರ್ ಈ ವೀಕ್ ಅಲ್ಲಿ ಬರ್ಬೋದು
ಖಂಡಿತವಾಗ್ಲೂ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ ಆಯ್ತು ನೋ ಪ್ರಾಬ್ಲಮ್ ಥ್ಯಾಂಕ್ ಯು
ನೋಡಿ ಸರ್ ಮೇಡಮ್ ನೋಡಿ ಬರುತ್ತೆ ಸರ್ ಒಂದ್ಸರಿ ಬರುತ್ತೆ ಹಾಗೆ ಬರುತ್ತೆ ಎಲ್ಲ ಒಂದ್ಸರಿ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ವೇಟ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕಲ್ಲಿ ಅಲ್ಲೇ ಹೇಳ್ಬೋದು ಅಲ್ಲೇ ಮಾಡಿಲ್ಲ
ಹೋದ್ಮೇಲೆ ಈ ಕಡೆ ಇರ್ಬೇಕಲ್ಲ
ಅದೇ ಅದೇ ನಂಬರ್.
Yes.
My lord, fresh matters for Thursday or Friday. My lord,
Fresh matters, you write on top fresh matters and give it, come immediately.
Lords, a fresh matter, lords, tomorrow if it can be taken up.
my lord,
Highway has have acquired my landlords without there being any notification.
Are being spoken to my lord.
Put it.
my lord, fresh matter, my lord.
Yes.
My lord, fresh matter, it's a tax matter. There is a high pitched demand and there is apprehension of coercive steps being taken for recovery.
Tomorrow.
If it may be taken tomorrow.
My lordship, tax matters.
Grateful.
The respondent authorities have initiated recovery proceedings
Give it
for tomorrow, my lord.
tomorrow. Fresh matters, you write on top of the memo fresh matters and give it, come immediately.
My lords, tax
Lords,
matter.
the four tax matters, if it could be posted on Thursday, there's a little urgency in the matter. This
Either
Thursday.
Has to come tomorrow or next, on the next tax day.
Tax day is Thursday, my lords, if it could be
No, no,
posted.
Tuesday and Wednesday is tax.
Today is Tuesday, my lords.
Tomorrow.
Tomorrow.
Give it.
ಅಷ್ಟೇನಾ?
Tomorrow. Tomorrow. Now who's the respondent? You serve on, no, correct. You serve it on Krishna.
Yes.
And tell him that it's coming tomorrow.
Yes.
To take instructions for the Indian prayer.
Yes.
Just wait. Give it. Give it.
Tomorrow,
What is the urgency?
the urgency is that, my lord, the respondent is at the stage of completion of the project in the federal property.
Okay, let us see.
It is
Fresh matter.
Give it.
2023 matter, lordship, land acquired in the year 1991.
Give
Till
it.
now, lordship, any day in the next week.
Give it.
My lord, media matter. My lord, I'm filing impleading application.
Give it.
Fresh matter.
Put it.
My lords, fresh matter, my lords, LA KADB. My lords, the SLO has passed an award, my lords, during the pendency of a partition suit in favor of a subsequent purchaser, my lords. Award has been passed, will be taken up tomorrow, my lords.
Give it. Let us see.
My lords, it's a tax fresh.
Give it.
My lord, fresh matter, tax, my bank account is being frozen.
Give it.
The matter be listed tomorrow, my lord.
Tomorrow.
My lords, the tax matter. This thing, my bank account is being attached.
Give it.
Let it be listed on the top of the list, my lords. Twice we have moved the memo. It's not listed. We have complied with the office objections as well.
Fresh matter is listed.
Top.
tax old matter. However, the deadline to file a GST 80 appeal is before June. So matter may be listed because there is a question of pre-deposit
Give it,
involved.
give it,
And the second matter involved is, it is already covered by your lordship's judgment.
give it.
Thank you.
Assignments, list 1, page number 1, serial number 1, page number 2, serial number 2, page number 3, 3 to 7, page number 4, 8 to 14, page number 5, 15 to 23, page number 6, 24 to 31, page number 7, 32 to 40, page number 8, 41 to 47, page number 9, 48 to 56, page number 10.
My lords. 55, your lordship.
55.
Can we have it on either 15th or 21st, your lordship? Some difficulty today. 55.
That request, relist on 21st.
Same stage, your lordships. Fresh match.
Page number 10.
Deeply appreciated.
My lord, serial number 48, my lords.
48.
Yes.
48, my lords. It's a tax matter where the issue is section 42 of CGST, my lords. Similar matter, the same as is listed tomorrow, my lords. If it may be had tomorrow.
Yes.
Obliged.
Page number 10, 57 to 65. Page number 11, 66 to 74. Page number 12, 75 to 78. Page number 13. Page number 13, serial number 79 to 81.
My lord, I appear for the respondents in serial number 79. The matter is rendered infructuous because there's a section, arbitral tribunal is constituted. It's a section 9 petition. My learned friend is also here.
She was relegating us to the tribunal. Let that interim protection continue.
I have no difficulty.
Until the tribunal decides the matter.
Till interim.
A section 9 petition was filed. Interim protection was granted. In the meanwhile, tribunal has been constituted. The order is placed before your lordships. So I'm agreeable to my learned friend's suggestion that we may be relegated to the tribunal. He may be protected till he files an application and all contentions being.
Till the disposal. Till the disposal of the application.
Yes.
File a memo. Both of you file a memo.
My friend will have to
give the memo.
Third
counsel. Huh?
We'll file the memo at 2:30, my lords. It may be taken up at 2:30.
2:30.
Yes, my lord. Great.
Page number 14, 82 to 88.
Please, my lord. My lord, may I mention serial number 82? My lord,
82?
my learned friend or the respondents will, I think, join me. My lords, can this kindly be fixed on 21st at 2:30? Because both of us, my lords, have an important issue. They on maintainability, me on merits. And the matter has been pending since November, my lords. Would my lords take it on 21st at 2:30?
That's a pay for respondent for Madhu and Rao. Maybe taken up on 21st minutes at 2:30.
List on.
Serial number 8.
But then it will be taken up after the parted matter. I'll have it at 2:30, but it will be taken up on that day after the parted matter.
Very well, my lord. We'll take our chance.
List.
My lord, interim orders to continue, my lord.
Interim orders in operation would continue till the next day. Yes.
Page number 15.
May I please, my lord?
89.
May I please, my lords? Item 88.
Item?
88, my lords.
Yes.
My lords, item 88 is a fresh matter, my lords, but it has moved to list 1, my lords. I've not been heard on this matter at all.
List tomorrow in fresh matters list.
Greatly obliged, my lords.
Page number 15, 89 to 95. Page number 16, 96 to 97. Page number 18, 98. Page number 19, 99 to 102. Page number 20, 103 to 107.
103 is a fresh matter. It has not been granted or considered.
103. List tomorrow in fresh matters list.
Tomorrow, I'll come online.
Yes, that's good. Yes.
Page number 21, 107. Page number 22, 108 to 111. Page number 23, 112 to 115. List to 2. Page number 1, 1 and 2.
My lord, serial number 2, my lord. It may be taken up next week, my lord. Serial number 2.
Srinivasa.
This same society, I think government has taken it over, isn't it? So then you have to Get instruction. Relist. Then you will have to come relist on the
21st.
same stage.
21st, 21st.
Page number 2, serial number 3 to 7.
My lord, I am appearing for serial number 3. I'm respondent. I seek a short accommodation for filing of the rejoinder, my lord.
You
I
informed the
appear
other
for
side.
respondent.
Yes,
I appear for the respondent. I have no objection.
Have you informed the petitioner?
Yes, my lord. He has appeared virtually, my lord.
Have you informed the petitioner? You are the petitioner.
No, I am the respondent, my lord.
Correct. Have you informed the petitioner?
Yes, my lord.
At request, relist.
Page number 3, 8 to 13. Page number 4, 14 to 17.
Till number 10, my lord.
Till number 10.
10, my lord.
10.
2 weeks to comply with the office objection.
2 weeks time granted for compliance of office objection.
Serial number 9, my lord, for respondent, my name is shown, my lord. The petition copy is not served on me, my lord. After serving the copy, it may be.
Okay, so let it come today. At least when it comes, you take a copy.
Page number 4, serial number 15 to 17. Page number 5, 18 and 19. Page number 7, 20 to 24. Page number 8,
24, my lord.
24.
Petitioner, short accommodation, my lord.
There are other matters also. So let us see when it reaches the other connected matters.
Page number 8, 25 to 27. Page number 9, 28 to 33. Page number 10, 34 to 37. Page number 11, 38 to 40. Page number 12, 41 to 43.
My lord, serial number 43. There's an extreme urgency in this blood. We are laying the pipe for irrigation projects for drawing water to all the villages. My lord, out of 16 kilometers, we have already done the entire line except 140 meters. Well, the stay is there. I'm not
Just
at 2:30 minutes.
You make a mention at 2:30.
2:30 minutes.
Inform the other side.
Yes, ma'am.
Inform the other side
I'll inform.
that there's a likelihood of it being taken up at 2:30.
2:30. Yes, ma'am. Much obliged.
Page number 13, 44 to 47.
My lords, 46, my lords, for petitioner, my lords. My lords, there was one more connected matter which has to be listed, my lords. Kindly list the matter tomorrow, my lords.
List along with
Connected matters, my lords.
have you informed the other side?
We are for petitioner, my lords.
Have you informed the other side?
Yes, my lords, I have informed the respondents, but the connected matters has to be listed.
List along with the WP number so and so.
Page number 14, 48 to 50. Page number 15, 51 to 56. Page number 16, 57 to 60. List 3. Page number 1. Page number 2, serial number 2.
My lord, list 3, serial number 1. The pleadings have to be completed, my lord, in all the 4 matters. 2 weeks time, I will complete the pleadings, my lord. The petitioner counsel is.
Your Lordship, the interim stay may be extended.
Interim order earlier granted is extended till the next date. List after 2 weeks. Responding to complete their pleadings. The next
Lordship, a date may be.
2 weeks.
My lord, serial number 1 in list 2, my lord.
Just 1 minute.
My lord, my learned friend is here, my lord. Maybe taken up today, my lord, at 2:30 or my lord, that yesterday, my lord, twice it was taken up, but it is list number 2, serial number 1.
Okay, 2:30.
Obliged.
List 1, fresh matter, serial number 1.
Serial number 79 is mentioned for 2:30. I'll have my client sign it, my lords, to have it on.
Not required. Why you want your client signature?
We have it on Friday, my lord.
Relist.
Friday.
Relist. In fresh matters list on 10th. Now you are ready for me recording your oral submission.
Please, that is, no, in writing, my lord,
That's why I asked for writing.
We have it on Friday.
Yes.
List 1, fresh matter, serial number 1.
Yes.
My lord, this is the order passed under NCLT.
Yes.
My lord, my submission, one submission is specifically is though I'm aware that it has to go back and they cannot enforce the order, assessment orders, which were challenged quite some back on. Now the issue is that on the free deposits made pursuant to the court orders, those have to be refunded. I have not crystallized those figures. So what does my learned friend has got to say so far as the refund is concerned? I will crystallize the figures and give it. Because there is a the Rajasthan High Court judgment also on this point, saying that if there be any pre-deposit, all the pre-deposits have to be refunded with interest.
You're correct. Normally, the practice we are following is when we set aside the order and remand it for fresh consideration, we say whatever amount is paid would be subject to adjudication. That's the normal procedure that we are following.
Subject to that is adjudication of the NCLT.
Correct. So you appear him.
I appear.
So we normally say whatever pre-deposit has been made would be subject to adjudication order to be
Here is a
passed.
case, my lords, where assessment orders have already been passed. I think a demand was also made before the NCLT. And my lords, while passing the order, the court, my lords, has observed that what is the procedure that is to be adopted at page
Except I've got the memo with the NCLT order. Filed it separately. Yes, that should be good.
Huh? No, this is the petition.
Not
Srila.
Do you have a copy?
I have my copy.
No, what we are saying, suppose upon remitting of the matter, and the matter is taken up, obviously the authority will look into whatever contention you have raised.
there is be a slight problem. My lords. If the matter is remanded, we will not be able to pass fresh orders. Because these are all the assessment orders were already passed and the demand was created.
No, orders will not go. The only thing is demand cannot be enforced and any pre-deposit has to be refunded.
No, correct. If you are relying.
If demands cannot be enforced also, my lords, it cannot be enforced against the company. That is what the NCLT said. My lords, liberty is still there for us, my lords, if we are able to demonstrate that we can recover that amounts from the personal assets of the director, we can do it. There is no bar for that.
Correct. The legal position insofar as IBC code, unless you are a part of the resolution plan, if you are not, then you will have to then seek for.
We were part. I think we were part of the resolution plan, and in fact, page 27.
Yeah,
Page 27, my lords.
Yes.
The last paragraph number 34.
Yes.
My lords, from para 30, it deals with taxation. I'll not get into the income tax issues, my lords. Page 30, paragraph 34.
Innೊಂದು case ಇದೆ. Connected case.
This is at page?
Page 27, my lords, in page 27.
Now I see, I've seen Tirumalesh's markings. Yes.
He'll be reading the same paragraphs, my lords. Paragraph number 34.
Yes.
My lords, with regard to all other taxes, this is what the NCLT has observed, my lords. Necessary directions, instructions be issued to the CBDT, customs, value-added tax authorities, central sales tax authorities, GST authorities, entry tax and other tax authorities, where central or state to exempt income, gain, profits, if any, arising as a result of giving effect to the resolution applicant under the provisions of the Income Tax Act, value-added tax, customs, octroi, excise duty, service tax, goods and service tax, including but not limited to any income tax and MAT liability arising on capital reduction in the corporate debtor, waiver, write-off, write-down of current amounts due to employees, vendors, operational creditors, financial credits, value of assets, value of inventories, etc., without any impact unbrought forward tax and book loss, depreciation, and waive all liabilities, whether crystallized or not, in respect of taxes, so, including interest and penalty, arising in respect of periods up to the appointed date and arising out of the implementation of or sanction of the resolution plan. But it's left to the CBDT to do it. Now, my lords, all that I can say is, my lords, the assessment orders will have to stay as it is. because those are all orders that are, the demands were crystallized before this resolution order came to be passed. Whether we are able to recover that amount or not, Malaj, the NCLT has said, no, it cannot be done. It is left to the CBDT to issue appropriate instructions. Now, Malaj, with regard to the other options that are available, Malaj, that has to be kept open, Malaj. That cannot be closed. Because if we are able to demonstrate, there is a provision under the VAT Act. I think all these matters relate to VAT demand. There is a provision under the VAT Act, Malaj, where we are not able to recover from the company, or the company has gone into liquidation. We are at liberty to recover that amounts, Malaj, from the personal assets of the director, provided we prove that the director was in charge of the day-to-day affairs of the company.
No, correct. But for that, it must be permissible under the IBC code and in terms of the order pass.
No, it's not necessary. My submission is, Malaj, not necessary for the reason that IBC or NCLT, Malaj, will only deal with the company. They have nothing to do with the personal assets of the director.
No, but then
And the court, Malaj, are rightly following Supreme Court judgment in Ghanshyam Das and other matters. So NCLT has rightly held, Malaj, that we cannot recover it from the company. That we cannot do it because the company itself is dissolved now. We cannot do it.
no. So now, what is the main relief now?
Look, what I'm submitting is that I've produced the NCLT order and the resolution plan, which has been approved. As per the resolution plan and the order, of course, the demand cannot be enforced as against the company. And your lordship is aware and have passed similar orders. Now, what I am also submitting is that I am entitled for refund of the pre-deposits.
That, my lords, that is done by way of an order of this.
As per the Supreme Court, judgment of the
Okay. The pre-deposit made where?
Made in pursuance to orders passed by this honorable court, my lords, while passing an interim order.
Here, before this court.
Yeah,
I think-
demand which has any payment made after the demand is created. Because the demand itself is unenforceable. So all payments subsequently are entitled, we are entitled for refund.
In fact, my lords, in one of the writ petitions, 573.
Last paragraph may kindly be seen.
If my lords kindly see the.
As a consequence, page 27, as a consequence, the consolidated impugned order dated so-and-so passed by Rajasthan Tax Board in appeals filed by the petitioner is set aside to the extent of the application filed by the petitioner for refund of pre-deposit amounts with interest were rejected. The amounts deposited by Benani Cement as mandatory statutory obligation.
Now, correct. Now, if the writ petition is being disposed of, unless there is any subsisting liability of the company in terms of the NCLT order.
Liability is still there, my lords.
No, but I'm saying insofar as the order of the NCLT, insofar as the company is concerned, whatever pre-deposit is made, obviously
There, my lords, again, my lords, it is not the pre-deposit, it is not, I don't use the nomenclature pre-deposit, my lords. It's a deposit made in pursuance to order passed by this honorable court or by the Supreme Court. Because in one of the writ petitions, my lords, 57544 of 2018, if my lords take the cause list itself, my lords, my learned friend should explain in detail. It says, my lords, non-filing of acknowledgement having deposited 30% of the demand made in so and so and so.
No, what?
And they refer to a Supreme Court order also, my lords.
Yes, we went to the Supreme Court again, the interim order passed by this law on this court, and then the Supreme Court has passed some order. Pursuant to that, we have made some protection.
That's what deposit has been made in pursuance to a conditional order passed by the Honorable Supreme Court, my lords. That cannot be.
No, but if the writ petition goes, what happens? Now, suppose.
Well, writ petition to the extent of we initiating fresh recovery proceedings on the company, my lords, has to go in view of the judgments of the Honorable Supreme Court. Insofar as pre-deposit is concerned, my lords, that was done in pursuance to an order passed by this one. In fact, I think if I recollect properly, this honorable court asked them to deposit 50% of the amount, against which they carried the matter to the Supreme Court, and Supreme Court modified the interim order.
Correct. Now, if the impugned orders are going to remain, and what is extinguished is only liability by virtue of the order of the NCLT, You examine the legal position, make submission, look at the legal authorities under the IBC code, and you assist the court.
Those are all, my lords, I accept, my lords, pre-deposit. Because against an order of assessment, if an appeal is filed, it was necessary to pre-deposit 10% or 30% as the case may be for the appeal to be entertained. Courts, my lords, said such pre-deposit you have to refund. But this is, in fact, paid in pursuance to an order passed by.
That pre-deposit has already been appropriated
Yes.
by the respondent. Then you examine the legal position and make submission. Let us see. If there's any other authority you place, let us see.
There is an order in the plan itself. I'll just read it out.
Point out.
The inner page.
How much is the amount now?
Inner page 84.
How much is the amount?
Amounts are running to a few crores.
Page?
The inner page 84 of the second document. It is a plan. Some subsequent.
Paragraph?
Paragraph 5.5.4.11.
No, page number differs, sir. Page?
At the bottom, there is a page number.
Yes.
39. At the bottom.
Yes.
Here, any assessment, reassessment, penalties, appellate or other proceedings pending in the case of the corporate debtor shall stand terminated, and all consequential liabilities, if any, shall be waived and shall be considered to be not payable by the corporate debtor by virtue of the order of the adjudicating authority approving this plan. Further, any amount deposited by corporate debtor in any of the abated proceedings shall be refunded to the corporate debtor.
Those are in cases which are pending. Any assessment, reassessment, revision, penalty, appellate or other proceedings pending in the case of corporate debtor.
No, but then you examine this.
Please.
Abated, these are all abated proceedings.
Let him give a list of what are the amounts deposited in each and every case.
Now you make a small write-up. If there's any other authority, you place it on record.
Yes.
We'll have it next week here. They will see. Land counsel for the petitioner submits that in terms of the resolution plan at 5.5.4.11, amounts paid pursuant to amounts paid in proceedings which subsequently have abated are required to be refunded for consideration of such contention. Realist on
14th, 15th, or later on.
The tax day.
15th.
15th. You see if any other authorities are there, we'll see. Yes.
Serial number 2, Rajiv Chennappa.
And place the Supreme Court order also.
Yes.
Yes.
Preparing for the petition. Actually, the base judgment order under section 63 was passed against the petitioner. The petitioner is an overseas citizen of India and resident of America, Your Lordship, owns a commercial property which was let out to different tenants for commercial purposes through a GPA holder of the petitioner. Then the first show cause notice was issued to the petitioner in the name of the petitioner for deriving the rent receipts from the commercial building without the GST registration. The first show cause notice was issued on 16/9/2019, against which I have replied on 3/10/2019. Then there was no process against this reply and no adjudication also. Subsequently, and this information was totally from the third party information. Based on third party information, they have issued the first show cause notice. Then subsequently, they have issued second show cause notice on 1st October 2021, Annexure B, against which I have replied on 13/10/2021, Annexure B1. Then against this also, Your Lordship, there is no proceeding of adjudication. And subsequently, again, they have issued third show cause notice on 11/2/2022. That is Annexure C. It is that which I have replied and asked for a personal opportunity of being heard, which was not considered. And subsequently, on 26/4/2022, they have passed the base judgment order under section 650. against which I have filed the appeal. And in the meantime, Your Lordship, I have also filed a letter saying that kindly grant a temporary registration, and also I'm ready to deposit 10% of the total demand, which was not granted to me, Your Lordship. And subsequently, appeal also under section 107 also got dismissed. Following that, this third notice was valid, and also, there is no lack of opportunity.
Fresh matter, is it?
In the meantime, Your Lordship, when the appeal was pending, on 31st/7/2022, they have credited the entire amount of 41 lakhs, Your Lordship, from my bank account.
What happened to the appeal?
Appeal got dismissed, Your Lordship.
Now they've recovered the amount.
Yes, Your Lordship. They recovered when the appeal was pending, Your Lordship. When I'm ready, I have filed a letter saying that I'm ready to pay 10% of the deposit.
Now appeal is dismissed.
Dismissed, Your Lordship.
So your liability is crystallized. You have challenged it here.
I'm challenging the refund, I'm challenging for refund, Your Lordship, and also asking for one personal opportunity of being heard before the adjudicating.
So now that appellate order you have challenged here.
Yes, Your Lordship, I've challenged it.
Yes, Kumar.
Against the appellate order, it has to be entertained, Manoj. Insofar as refund that they are claiming, Manoj may have it tomorrow, Manoj, I'll
relist and
In the same stage, Your Lordship.
Kumar accepts notice for respondents.
for
All the respondents.
all the response.
The relist tomorrow in same stage.
Much obliged.
3, still number 3, Ravi Shankar, Sanmati.
Yes.
My lords, this is a case where the notice issued under 148 is barred by limitation for having been issued beyond 6 years, my lords. It listed yesterday, the revenue was asked to clarify on that point.
Your Lordship, yesterday they have relied upon section 149 prosio, my lord. Your Lordship, section 149, my lord, page number 1.1019.
Is it?
149, 1, my lord.
We have prepared a short synopsis, my lords.
149.
149, 1. Your Lordship, section 149 deals with the time limit for issuance of notice under section 148, my lord. No notice under section 148 shall be issued for the relevant assessment year. First, my lord, if the 3 years have elapsed from the end of the relevant assessment year, unless the case falls under clause B. If 3 years, but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession of books of account or other documents. Or
correct. Now there are two things.
Yes, my lord.
One is November 21.
Yes, my lord.
Isn't it?
Yes, my lord.
On that point and the division bench, this is the same matter.
Yes, my lord. Your Lordship, the proviso to this section, my lord, may I read the next part, my lord. Provided that no notice under section 148 shall be issued at any time in the case for the relevant assessment year, beginning on or before the first day of April 2021, if a notice under section 148 or section 153A or section 153C could not have been issued at the time on account of being beyond the time limit specified under section under the provisions of clause B of subsection 1 of this section.
Read it once again.
Your Lordship, provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or before first day of April 2021, if a notice under section 148 or section 153A or section 153C could not have been issued at that time on account of being beyond the time limit specified under the provisions of clause B of subsection 1 of this section or section 153A or section 153C, as the case may be, as they should immediately before the commencement of the Finance Act 2021. Your Lordship, in this case, the assessment year is 2015-16, my lord.
No, correct. I'm saying we
Yes,
need not enter into this now.
Yes,
This is, of course, on merits. Now we just record the division bench and close it.
Yes, my lord. Your Lordship, that's correct, my lord. Division bench has held against revenue, my lord. But only for clarification, I'm submitting, my lord. The provision, my lord, state that if at the time of the prior to amendment, if time was available to me to issue notice under section 148, then I can issue. If there was no time available to me before this amendment, then I cannot issue. In this case, the assessment year is 2015-16. I had the time to issue 148, therefore I have issued 148, my lord. 6 years was the time limit, my lord. Before 6 years, my lord, the 31/3/2022 is the last date, my lord. And in this case, I have issued, my lord, initiated the proceedings, my lord, by
1st April.
1st
April 2016 would be the end of the financial year.
Yes, my lord.
From then, how many years?
6 years, my lord.
So 1/4/22.
1/4/22, my lord.
Now the date now.
Your Lordship, now I have initiated the reassessment proceedings well within by the starting procedure for initiating reassessment is 148 AB on 33/22.
Okay, let us see. Now, without entering into this.
Yes, my lord. That division bench judgment is against me, my lord.
Division bench order.
Vibhu, Chief Justice judgment, my lord.
Nene ಕೊಟ್ಟಿದೆ.
Nene ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
My lords, on that point, may I give us?
No, we need not enter into that. I'm saying we need not enter into that. We just refer to this and close it.
Yes, ma'am.
F.
Yes, my lord.
F, para F.
Please.
Huh? The petitioner.
I also don't have copy.
Has sought for setting aside of the proceedings under 148 which has culminated in a order passed under section 147 read with section 144 at annexure A3 and penalty proceedings. It is the case of the petitioner that proceedings under section 148 were sought to be initiated as regards the assessment year 2015-16. It is submitted that such proceedings are time barred. Full stop. Reference is made are time barred. Full stop. It is submitted that the time limit prescribed for initiating proceedings will have to be read in terms with the observation made in the case of Union of India versus Rajiv Bansal. 2024 INSC 754. Full stop. Attention is drawn to para 19E and 19F of the said decision, which are extracted as below. Extract from page 7 of the order. It is submitted that in light of the observations made and the concession of the revenue that for the assessment year 15-16, all notices issued on or after 1st April 21 will have to be dropped as they will not fall for completion during the prescribed period under capital TOLA.
Yes, Lord.
Close inverted comma, full stop. Next. The identical question was a subject matter of consideration before the division bench in writ appeal 612 of 2025 in the case of income tax officer and others versus Venkatala Ayyappa Rajanna. Full stop. The division bench considering the identical question regarding time limit
Given slip of paper.
for notices of the assessment year 15-16 after referring to the observation made in Rajiv Bansal's case as extracted above, has observed that the concession made before the apex court has been taken note of even by in subsequent proceedings, including by the Supreme Court in the case of Deepak Steel
Yes, Lord.
and Power Limited versus CBDT, Civil Appeal 5177 of 2025, decided on 2/4/2025. The division bench, relying on the observations made at para 5, 4 to 6 in the aforesaid order, as well as observations made in ITO versus RK Build Creations Private Limited, special leave petition bracket civil diary number 59625/2024. Dismiss the appeal affirming time barring of the notices. Observations of the division bench at para 9 to 10 reads as follows. Next, in the present case, it is not in dispute that the proceedings under 148AB itself were initiated as per the notice dated
3322.
3322. Noticing the notice issued is beyond 1st of April 21.
Yes, Lord.
Accordingly, in taking note of the orders of the observations made by the division bench as well, the impugned proceedings are liable to be set aside on the sole ground that the 148 notice was issued beyond the time permissible. Accordingly, the order at annexure
A3, my lords.
A3 and is set aside, as well as consequential proceedings as culminated in
My lords, A2, A3, A4, till A5, A6, my lords.
A4 to A6.
No, A1 to A6, my lords.
Huh? No. What? No. Assessment order and the other rest we did.
Everything goes.
Huh?
Assessment as well as penalty, everything goes.
The assessment order at annexure A3 and consequential proceedings at A4, A5 and A6 are set aside. Accordingly, petition is disposed of.
Oblige, my lords.
Serial number 4.
Oblige.
One extra copy.
Your Lordship, matter may be adjourned to 14th of this month.
Realist.
My lord, in this matter, I would take notice for R2, my lord.
Learned counsel. Arvind Chavan accepts notice,
Notice for R2, my lord.
R2. Then the others?
My lord, R1,
R1 I am appearing, my lord.
R3 Union of India, someone has entered already appeal.
Anupama, madam.
I appear for R3, my lord.
Realist at request. On. Yes.
Serial number 5. Giridhar SB.
Yes.
My lords, the order has been passed based on the consolidated show cause notice. The show cause notice at page number 51, my lord, Annexure C.
Page?
51, my lord, Annexure C. General notes. Please find and enclose show cause notice issued for the period April 22, March 2023, my lords.
Where?
Annexure C, page number 51, my lords.
Yes.
In the first general notes, please find and enclose show cause notice issued for the period April
Yes, yes.
22, March 2023.
Yes.
Yes, my lord, yes.
In light of the contention that the cause notice, single show cause notice is issued as regards multiple tax periods spanning between April 2020 and March 2023, and Reliance placed in the case of Pramur Homes and Shelters versus so and so, there would be stay of.
Annexure A, B and C, my lords.
Yes, yes.
What happened, my lord? We have got the enforcement report, my lord. In that report, we are authorized to pass an order.
No,
Since
correct.
there was no stay,
No,
we
those-
passed an order.
No, those matters are being heard. The
Posted
single
for orders.
Single show cause.
Oh, that's posted for orders, the entire batch.
There would be stay of.
Annexure A, B and C.
For orders.
Is reserved. Stay of annexure A, B and
C, my lords.
A, B and C.
Obliged.
Serial number 6, Lakshmi.
Lords, appearing virtually, my lords.
Yes.
My lords, this was a case where my goods were confiscated under section 130, my lords. An application and IA was filed, my lords, seeking directions to release the goods, my lords. My lords were orally had remarked on the last date of hearing, my lords, that my lords, on payment of 25% of the demand, my lords, that the goods may be released, my lords. But the only issue that we are facing, my lords, I have filed a memo before this honorable court, where my lords, a letter which has sent by me to the commercial tax officer, the respondent number 1, regarding clarity on how the said amount has to be paid, my lords, because in the order there is no clarity. It mentions in a certain part regarding conveyance, it has to be paid under CGST, IGST, and regarding the penalty and amount to be paid in respect of the goods itself, it mentions CGST, SGST, my lords. My lords, we have written to the commercial tax officer, respondent 1, to seek clarity by letter dated 30th March 2026, my lords.
Where is that?
My lords, I filed a memo, my lords. It's quite voluminous at page 323 of the memo, my lords. Almost the very last page, my lords, of the memo.
Memo dated?
My lords, we have filed this on 2nd April, my lords. An entire compilation, my lords, along with affidavit stating that we are carrying on business since 2023, along with all the returns.
Page?
Page 323, my lords.
It's
quite a voluminous memo, my lord. The last page of the memo.
323. You have it, madam?
Yes, my lord. They have submitted this letter, my lord.
So they want some clarity on that.
My lord, they have mentioned in the table, my lord, bank guarantee of 75%. If they provide 25% cash and bank guarantee, we will release and let them go before the appropriate forum is there.
My lords, your lordships have passed an order, my lords, that in WP 5037 of 2026, where bank guarantee is
interim
not
order
required,
will not absolutely not applicable in this case, my lord. I have filed a statement of objection with regard to this, my lord. Even I have a
No, correct. Now, what is the terms you tell?
My lord, your lordship may be seen page number 323, my lord. The memo, same memo, my lord.
No, I don't have the memo.
Tagodi. 25% of cash table, exactly. And 75% of bank guarantee, my lord. They mentioned in the table, my lord.
My lords, this is the computation given by the department that we produced before the officer. My lords, we have sought guidance in regard to the deposit of 25%, whether in the form DRC 03, whether it should be paid under CGST, SGST or IGST, because my lords, the petitioner is located in Salem the goods were supplied to Bangalore. So,
Just
my
a
lords,
Just now, madam, you ask him, now let him meet you, the council. You just instruct him, that's all.
Let him come, my
I'll
lord.
have it tomorrow.
Yes,
Let him meet you.
Yes, ma'am.
Upon instruction, you just clarify it, that's all. And
My
then
lord, your lordship just now gone through the table,
Yes,
my
yes.
lord. That table.
and this thing is not working. Yeah, court hall is left message.
Fast.
Serial number 6, Lakshmi Menon. 6.
My lords, there was some technical issue, my lords.
No, now they're saying in terms of the table, what you have offered of 25% cash, 75% bank guarantee.
Please, my lords. My lords, that calculation was provided by the department. Your lordship in a matter had held that where an affidavit is provided by me, and where in that matter where the petitioner was engaged in business for a long period of time, there was no requirement for the bank guarantee to continue, my lords. In this particular memo, I have attached my affidavit as well, my lords, stating from 2023, my lords, I've been conducting business, and my lords, and every month, my lords, my turnover is quite huge, my lords. I'm not a fly-by-night operator, my lords, where there
My
is
lord,
no
that
risk for the department.
interim order is absolutely not applicable to this case,
It
my
is
lord.
not an interim
Because
order.
in that case, already they had been to first appellate authority and they already sought a relief. In SMR has reopened the case. In those circumstances, this honorable court interim order is suitable, but not in this case, my lord. In this case, directly he violated rule 55 of the act.
No, is there any previous history of default of this person?
No, my lords.
My lord, it is a
This
clear
is the only
case
We are on the
only
point.
particular case, my lord.
We are on the point. Now, suppose 130 order is affirmed subsequently. Question is whether there's going to be any difficulty in recovering.
very, my lord, if your lordship permit me, I'll read section 130, my lord. Kindly be, because why we are asking bank guarantee means in this type of cases, we are unable to recover.
Why I'm asking whether now you have a history of this person, isn't it?
Yes, ma'am.
He's an SSC since how long? He's given affidavit.
He is from out of state, my lord.
No, that's okay.
Yes.
Now if he's an SSC with you for the past 10 years, 15 years, whatever, you look into his record and you make submission. If there's any previous instance, we'll definitely not permit him to furnish bank guarantee. If you find out his history, how long he's been there, whether this is his first case, any other case, you find out and then we'll take a call.
Tomorrow, ma'am.
Please, my lord. Obliged.
What we have done is, in some matters, we have relaxed it depending on the history of the litigant.
Please,
Realist.
Seven, Rajiv Chennappa.
Your Honor, this is an income tax writ petition wherein I'm seeking a direction through writ of mandamus, wherein I filed an appeal. This is the second round of appeal filed before the CAT appeal. The appeal is for the assessment year 14-15, and appeal is filed on 6th of May 2022. And till now, I have not received a single hearing notice.
Faceless, is it?
Faceless, Your Honor.
Your Lordship, they have to file request application before the authority and they will consider it and pass orders, my lord.
Your Honors, if I have to file a request to authority also, there is no opportunity for me. The window is not it's not available. They have to issue me one hearing notice, and it's been 4 years they have not issued a single hearing notice.
Income tax, is it?
Income tax, Your Honors.
Your Lordship, they have to file a request, my lord. It will be considered. My learned friend is simply saying that there is no window available. It is there, my lord. They have to file request. The faceless authority will take up the cases on the basis of 3 points, my lord. High pitched assessment, early hearing request.
Yes, Tirumalesh. In that delay in disposal of appeals.
Yes, that matter.
When is that? When is that?
15th.
15th. We post it on that day.
Yes, ma'am.
Now we have asked the
Yes,
department
to get the details, ma'am.
So let us
Yes, ma'am.
relist. Relist. Same question. Relist on 15th. When that matter is taken up, you make a mention. Same stage. Wherein we have asked the details of from which year it's pending, so that we can find out if they're taking it according to chronology.
Your Honor, if I have to mention, this is the second round of appeal. First, it had gone to the ITAT. ITAT gave a direction according to how to be the assessment order has to be passed. They haven't passed according, and these are not the assessees, other brothers, other siblings. Their orders were passed in according to the guidelines of the ITAT. Only this order was not passed, and we went on an appeal, second appeal. And that appeal is from 4 years, they have not issued a single hearing notice. That's all my grievances.
Let us see. Let us see. Meanwhile, if you can find out, you find out.
Much obliged.
Sanmati.
Yes, sir.
Relist on 15th.
Yes.
Much obliged. Ajay Prabhu, Akash Shakti.
In this matter, my lord, by the annexure A, my lord, the respondent has sought for refund of the amount, my lord. As they say that, my lord, there is violation of notification.
My lords, during the last date, my lords, lordships have directed to furnish shipping bills, my lords. Same has been submitted. It's on record, my lords.
No, it is not on record.
It's not on record.
Though, my lord, the notification says that, my lord, all the requirements has to be fulfilled by the recipient. I am the supplier, my lord. My lords have directed me to, my lord, produce the bills. My lord, I sought it from the recipient and producing it, my lord. Actually, in terms of notification, I have no role, my lord.
Reverse charge mechanism.
My lord,
The liability must be borne by the recipient.
recipient. I am the supplier.
Then you.
And my lord, the main allegation is that, my lord, the shipping bill doesn't contain, my lord, GSTN number. My lord, actually, my lord, shipping bill is produced by the customs themselves, my lord. And they have not mentioned because of human error. I have submitted before the, my lord, the respondent. It was not considered.
No, then you have to examine and then you have to say.
My lords, about 7 shipping bills have been submitted, my lords. It's like the matter requires consideration, my lords. It's
And out of 9 bills, my lord, 2 bills, my lord. 1 bill is cancelled. And the one is export has not taken place, my lord. And I have stated it clearly in my memo, my lord.
Now, it has to be remitted or what?
Remitted, my lord. They have to consider it again, my lord.
Please.
So you are saying what is your, just repeat your contention now.
Miss Lord. Lord, as per Lord, the notification, the whatever the contentions raised by the Lord, the allegations raised by the respondent has to be complied by the recipient.
Which is that notification?
Lord, I produced it along with my annexure P, my lord.
Annexure
P.
Page
number 177, my lord.
Just read relevant.
Relevant, my lord. They say that, my lord, there is violation of condition number 3, 5, and 9, my lord.
Of this notification.
Of this notification.
In the assessment order.
Yes, my lord. It is raised. It is raised for only when first time in order in original, my lord. Stating that specifically.
3, 5, and
3, 5, and 9, my lord.
Just point out.
Please, my lord. 3, my lord. Roman number 3. The registered recipient shall indicate. Registered recipient shall indicate the goods and service tax identification number of the registered supplier and the tax invoice number issued by the registered supplier in respect of said goods in the shipping bill or bill of export as the case may be.
Yes. Then.
And then, my lord, 5. The registered recipient shall place on record or place an order on registered supplier for procuring goods at concessional rate, and copy of the same shall also be provided to the jurisdictional tax officer of the registered supplier.
Yes.
And 9, my lord, when goods have been exported, the registered recipient shall provide copy of shipping bill or bill of export containing details of goods and service tax identification number and tax invoice of the registered supplier along with proof of export general manifest or export report having been filed to registered supplier as well as jurisdictional tax officer of such supplier.
Now, so you are saying that obligation is with the recipient.
Recipient, I am the supplier, my lord. Lord, they say first notice is that, my lord, they themselves state that I am supplier. Kindly see, my lord, page number 167. 167. Annexure J. May I read now?
Now, what is this?
It is the first notice which is served to me, my lord.
Yes.
They say that you have supplied goods on payment. Pay them 167. My lord.
Yes.
They themselves say, my lord, I am the supplier.
Yes.
And one more thing is, my lord, shipping bill is issued by the customs, my lord. They have missed, my lord, mentioning the GST number.
Now, where is the show cause notice?
My lord, show cause notice at, my lord, page number 179, my lord. In this they say, my lord, there is violation, but they don't specifically say what is the violation.
Okay, now you go to the order in original.
Please, my lord. Annexure A, my lord, page number 18.
Page
18. In this, for the first time, my lord, they specifically say what conditions have been violated.
So you are saying this notice itself could not have been issued to you?
Yes, my lord. Entire proceedings is misdirected.
You have replied to the show cause notice.
Yes, my lord, I have stated. Yes, my lord. Recipient, I stated that, my lord, it is recipient. I am the supplier.
You have stated.
Yes, my lord. And
so we'll ask them to reconsider it.
Please, my lord.
But what is the finding now here in the order in original?
They, my lord, kindly see, my lord, in para number, page number, my lord.
Page 26, para 11, my lords.
Para 11, in that page number 30, 11.11, my lord.
11.11. Page
number 30, my lord.
Read.
I believe that taxpayer have agreed to GST number and supplier invoice were not mentioned in the shipping bill. The taxpayer is relying on the linking in tax invoice.
10.10 you read.
10.10. Before that,
No,
10.8.
11.10, sorry.
11.8 also, my lord.
Read.
The taxpayer have also submitted shipping bill copies and related tax invoices along with replies so and so. Here it has to be noted that as per condition mentioned in the serial number 5 of the notification so and so, the registered recipient shall place an order on registered supplier for procuring goods at concessional rate, and a copy of same shall also be provided to the jurisdictional tax officer of the registered supplier. Also, as per the condition mentioned at serial number 9 of the notification so and so, when the goods have been exported, the registered recipient shall provide copy of shipping bill or bill of export containing details of goods and service tax identification number and tax invoice of the registered supplier.
Will remit it back for reconsideration, recording a submission.
Please.
And then in the event it is found necessary, the recipient can also be issued notice in the proceedings.
Please.
The petitioner. Where is your reply? Page
number, my lord.
My lords, also my lords, the memo that was filed today, my lords, that also be brought on record, my lords, because
yes,
consent contains about 7
Page
shipping bills.
which is point to page, which
page number 183, my lord.
183
reply. I was clearly stated, my lord, it is like the receiver has exported the goods which is supplied by me, and it can be seen by my lord comparing the goods which I have been exported, my lord.
No, I don't think they dispute you being the supplier, but they found that the recipient has not followed. That's how they have treated it. Anyhow, that you establish it there.
Please, I will.
The petitioner has sought for setting aside of the order in original at annexure A dated 31/7/2024. With the contention of Lord Counsel Shri Ajay Prabhu appearing for the petitioner that the impugned order fastening liability on the petitioner, who is the supplier, is not legally correct. It is his contention that the order in original is on the premise that there has been a violation of clause 3,
5 and 9.
5 and 9 Roman dated 23rd October 2017. Vide notification number 41 of 2017 dash integrated tax within bracket rate at annexure P. Full stop. It is submitted that the answering party to such violation is the recipient and not the supplier, and on such sole ground the authority ought to have dropped proceedings against the petitioner. Full stop. It's further submitted that in response to the show cause notice, reply at annexure R had been placed on record, which has not been taken note of appropriately. Petitioner also has filed a memo along with documents which consist the shipping bills and submits that even otherwise the recipient has also, the documents of the recipients have also been placed on record.
Please.
Land Council appearing for the revenue, Sri Akash Shetty submits that default in the notification relates to certain relates to furnishing of documents which may eventually lead to liability of the supplier. Full stop. However, Land Council for the petitioner would dispute such contention. Next, peruse the order at annexure A. There is a reference relating to the violation of clause Roman 3, 5 and 9 of notification number 41 of 2017. Full stop. The counsel for the petitioner further submits, authority has not looked into the documents and material on record in a proper perspective, and that if the matter is remitted, the petitioner would also demonstrate that the documents in terms of the notification are available. Full stop. Taking note of such contention, though it is noticed that the petitioner has made out reply and participated in the proceedings, it would be appropriate to remit the matter back for reconsideration, directing the authority to relook into the matter, particularly in light of the submission of counsel for the petitioner that the documents are available to demonstrate that clauses 3, 5 and 9 of notification of 41 of 2017 are fulfilled. Full stop. Further, the authority may call upon the recipient in course of its proceedings, if found necessary, for getting further documents that may throw light on the adjudication. Accordingly, the petition is disposed of, setting aside the order at annexure A, remitting the matter for fresh consideration. In terms of observation made above, petitioner is entitled to make out an additional reply to the show cause notice and produce other documents in his possession that may assist the authority in adjudicating the matter. Petitioner to appear before.
Let them issue notice.
Huh?
Let them issue notice.
Why unnecessary?
This has already been issued. Let them appear.
Please
appear before.
On date be fixed.
R1 match.
The respondent without further notice on. Ajay says he'll get fresh fees.
Yes. Srihari. Serial number 9, Srihari. Shishir Amarnath.
My lord, this is a case where despite amendment of the address in the GST portal, the order is perpetually sent to the old address. My lords may kindly find the original order at page 99, the order in original. The order in original, page 99, my lords. My lord may kindly come to page 108 now, which is the last page. (108), my lord.
Page
108. The last page of the order.
Yes.
My lord would find that the order is signed on 29th of January 2025, and it is sent to, my address is given below, my lords. Number 309, first floor, Venkatesh Complex. Number 309, first floor, Venkatesh Complex. Now, that is the address to which it is sent. Now, my lord may kindly come to page 115, my lords. My lord.
Yes.
That is the pay. That is the history of the amendments of the addresses as reflected in the portal. My lord may once come to page 116. It goes from down to up. Page 116.
You have been changing frequently.
Only two times, my lords. So, my lord would see that the number first floor 309 Venkatesh Complex was changed to, I shifted from that address to the first floor Akshaya Building, 100 feet Indiranagar in 4th of February 2020. And now my lord may come to page 115, and that address too got changed in the year 2023 to 3rd floor 55 Nomads, where I continue to operate till now.
You're a nomad.
No matter.
So now when notices
Uh,
were
now-
not sent to this address.
My lords, the order is purportedly sent to the old address. I was not aware. Once I came to know the correct the receipt. Now, my lords may kindly come to page 117. When I was intimated about the order having been passed, but I was not aware.
So you are saying that the notices also may have been sent to that address.
No, I'm not. I contended that on the last hearing, I contended that the notice is bad at law because it was issued under section 74, and without there being a suppression, there cannot be a 74 and there can be only 73. But my lord asked me if I can, if that contention is better explored in an appeal. To which I responded that I had tried an appeal, but the appeal was dismissed because the appeal was filed belatedly. Because I filed within 3 months of the actual service. The actual service, my lords, is on 18th of August. My lords may see 18th of August is page 117. I got to know about the order on 117, 18th of August. Within 3 months from there, I filed an appeal, my lords. But the appeal was dismissed in limine, stating that the appeal has been has exceeded 4-month limit.
Appeal was filed on which date?
Appeal was filed on 21st of November 2025, which my lords will have it at page 120.
Appeal was filed on
21st of November 2025. In fact, my lords may for a moment come to page 119, a previous page, where I had requested, page 119, my lords, for a moment, where I wrote a letter intimating them that it is only upon receipt of the intimation that I got to know that the order is passed, and therefore the limitation has to be computed from that end. And with this covering letter, I filed the appeal, but the appeal was dismissed, my lords, which will my lords would find at page 1156.
They don't make a reference to this letter.
No, they don't. It's dismissed in limine without even. It's not. It's a non-speaking order.
No, they don't make a reference to this letter.
No, they don't do anything, my lords. It's a non-speaking order, page 11156. It simply says delay in submission of appeal. That's it.
So 3 days delay according to them.
No, not the 3-day delay, my lords. The order is dated January 2025. So according to them, it should be filed by the month of April 2025. But I received it in the month of August 2025. So 3 months from there, it's November, which is what I have filed. But according to them, it's delayed by 8 months. From the 8 months from the date of the order.
It's beyond the 3 months also.
It's well beyond the 3 months, even after being intimated.
18th of August is the date of receipt. 3 months will be calculated from that, my lords. 25th of November, my lord will file my submission here. The said intimation was received by us on 25th of August. My lords would come to page 119. Page 119. May I read, my lords? Respected sir, may I read, my lords? This is to inform that our company Algo Vision Technologies India Private Limited received your intimation dated 18th of August 2025 regarding arrears confirmed VD order in original number so and so dated 29th of January 2025. The said intimation was received by us on 25th of August 2025 at our current address. So and so. We submit that the order in original referred to above was neither served upon us through email or nor physically received by post. It appears that the order might have been sent to our old address mentioned in the departmental records, though our current address is duly updated in the GST registration.
Just so you are saying it could be sent to the.
It can be sent to the
appellate authority.
No, my lords, it can be sent to the show cause notice stage, because I will raise the contention of the 74 issue also, because 74 is not applicable at all. This is clearly case. My lords, may if I can just refresh my contention, my lords may kindly come to the show cause notice, which is at page 89.
No, correct. Now suppose. Then you must point out what is the defect in the order in original.
I will do that, my lords. My lord may kindly come to the show cause notice.
If you want it to be remitted back.
I want it to be remitted back to the stage of reply to the show cause notice, because the contention here is that the 74 is not applicable at all. Therefore, if I can persuade the authority to that there is no suppression, he can do it under 73, and my lords may direct accordingly.
Order in original?
Order in original, my lords would find it at 99, my lords. But before that, my lords, I would urge my lords to kindly come to page 89, which is the show cause notice. My lords have page 89?
Yes.
My lords may kindly see in the bottom end of the page, after issue number 1, non-payment of GST on RCM under import of services for commission paid to the agents located outside India. Below that he writes, my lords, during the course of audit for the period July 2017 to March 2018, it was noticed that the taxpayer has shown expenses of rupees 41.08 lakhs against the commission paid to Messrs. Zalcom Track Technologies UAE and Cross Border Technologies Korea for marketing and effectuating the sales of the products. My lords may now kindly come to page 90. The second paragraph, my lords, fifth line from below, the statutory auditor. My lords have it, my lord? Fifth line from below, second paragraph. The statutory auditor has also given remarks in the GSTR 9C returns that the assessee has appointed Zalcom Trade Technologies and Cross Border Technologies Korea as the representatives for sales and marketing support services in UAE and Korea respectively for effectuating sales of their products as commission basis. Having himself noted that the statutory auditor has duly declared in the GSTR 9C, which much precedes any proceedings for that matter, he then goes on to invoke the ground of suppression by stating that I have not disclosed, when he himself is admitting that the statutory auditor has declared, and as far as I am concerned, it's a non-taxable service. Once it is not taxable, it cannot form part of my GST returns. Therefore, this contention, my lords, it can be, I would urge this honorable court to kindly consider that since section 74 is not applicable, the suppression itself is not applicable. Therefore, that forms the absence of a jurisdictional fact. Presence of suppression is a jurisdictional fact for invoking section 74.
Now, in the reasoning you point out, what is the error now? If you want a reopening of 74.
Yes, my lord.
They mentioned in para 4.
Para 4, my lords. He having he himself noted that the statutory auditor has declared in his GSTR 9C report that the assessee has appointed 2 foreign-based entities. He then goes on to say that I have not disclosed. Para 4, I will read it, my lords. The GST is payable on a self-assessment basis. It appears that the registered person does not disclose the fact of non-payment of IGST to the department at any point of time. The fact of non-disclosure of details clearly shows that the fact of registered person has suppressed the facts with the intention to evade the payment of IGST. It was only after the detailed examination and audit conducted by the audit of team of Central Tax Audit 1 Commissionerate that it came to the notice that the registered person has suppressed the facts. Therefore, it appears that the above emotion and commission on the part of the registered person amount suppression. He himself notes that the auditor has duly declared it. There has been a declaration from the company's end. Having said that, he cannot now in the same breath say that there is no disclosure and only by the audit team it was discovered. The discovery has happened pursuant to my own disclosure in GSTR 9C, and therefore there cannot be any case of suppression. Number one. Number two, this is a case where I have appointed foreign entities to carry out sales promotion outside India. They constitute intermediary. There are various judgments to this effect, my lords. Therefore, once they are intermediaries, the GST is not applicable to them.
But where is that point? Where have you raised? Where is it considered?
That, my lord, that point, my lords, I have read in my reply to the show cause notice. My reply to the show cause notice is at page 93. Page 93, my lords.
Yes.
I'll read from para 1, my lords. This transaction is not import of services on account of grounds mentioned hereunder and consequently not liable to GST. The commission charges paid to Zalcom Track Technologies and Cross Border Technologies Korea is towards identifying customers in UAE and Korea respectively. Copy of the agreement with Messrs. So and so have been shared during the course of audit. The nature of services rendered by Messrs. Zalcom Track Technologies and Cross Border Technologies for whom commission was paid are intermediary services as defined under section 2 subsection 13 of the IGST Act, which reads as follows. Intermediary means a broker, agent or any other person by whatever name called who arranges or facilitates the supply of goods or services or both or securities between 2 or more persons, but does not include a person who supplies such goods or services or both or securities on his own account.
On this, no finding is recorded.
No finding is recorded, but he has not adjudicated on how it is suppression. It is not a case of tax.
Suppression is one part.
Suppression is the ground for invoking 74. He can very well examine the taxability or non-taxability of it under 73. My quarrel is not with the examination of it, but he has to prove it is suppression for him to invoke the extended jurisdiction, extended period of limitation.
That's one part. Now, insofar as intermediary, is there any finding recorded?
My lords may kindly come to page 99 is the order, and findings, my lord, will find at page 104.
Has he recorded anything on intermediary aspect?
He has very briefly recorded, my lords, without there being any concrete finding. he has basically disagreed with the submission. The findings, my lord, will find at page 104.
Yes.
Para 8.2, my lords. In the present case, the supplier of service, that is Zalcom Track Technologies and Cross Border Technologies Korea, are located outside of India. Further, they are providing service to the SSC on commission basis, and the SSC is located in India. Further, the overseas agents, Zalcom Track Technologies, UAE, and Cross Border Technologies are doing marketing and effectuating sale of their product, and hence place of supply of services is in India. This is incorrect. This is incorrect, my lords. The statutory auditor has also given marks in GSTR 9C returns that the SSC has appointed Messrs. Zalcom Track Technologies and Cross Border Technologies Korea as their representative for sales and marketing support services in UAE and Korea, respectively, for effectuating the sales of their product on a commission basis. My lord, he himself says that the statutory auditor has disclosed. Once there is a finding.
I'm not on that point. I'm asking you insofar as your contention of intermediary, is there any finding recorded?
Para 8.4, page 105. On perusal of the reply submitted by the taxpayer, it is observed that the taxpayer has entered into agreements with Messrs. Zalcom Track Technologies and Cross Border Technologies, which is in Korea, covered under the definition of intermediary service. As per definition 2, subsection 13 of the IGST Act, intermediary means a broker, an agent, or any other person by whatever name called who arranges or facilitates the supply of goods or services or both or securities between two or more persons, but does not include a person who's.
I'll take instructions on these points, my lords. With respect to service of notice, my lords, section 169 is amply clear, my lords. It's or one of the modes of communication. It can be by speed post, it can be by email, it can be through, in fact, uploading on the portal, my lords. In fact, they admit to the fact that it's been uploaded on the portal.
Let us see, that is insofar as the.
Note, with respect to 169, my lords.
No, in case 74.
Yes.
It can be relooked into because under his 9C. He has declared,
it was already declared.
He has declared it. Then we can send it back for reconsideration.
Well, may I get a short accommodation with respect to this, my lords? I'll clarify on the same, my lords, on the next day.
Relist the matter in the same stage on
21st.
21st.
Right.
Okay. 10, to Malaysium, SCGP, 10.
Yes.
Lords, the appeal before the Karnataka Appellate Tribunal was dismissed for default for the second time. And actually the counsel who was there, he has returned the file to the concerned CA, and appellant could not follow up the appeal. And in the meantime, the appeal has been dismissed for the second time. And there is a prohibition under the Karnataka Appellate Tribunal regulations under section regulation 28A.
28?
KAT regulations, saying that we cannot file a second application for a miscellaneous application for restoration of the appeal. And since this is being a bona fide reason, I request that the appeal may be restored.
Yes. Some cost.
Certainly, my
government.
For this reason, my lords may kindly see, assuming they have not appeared, admittedly they have not appeared before the tribunal, my lords, and the matter has been dismissed twice. And my lords may kindly see page 31. My lords. The certified copy of the order dated 25/4/2024. Page 31, my lords, the last page of the petition. The order is dated 25/4/2025.
Yes.
The certified copy is obtained on 2/5/2025.
No, I'll clarify that.
The writ is filed in.
No, I'll clarify that.
February. Writ petition is filed in 2026 February.
No, I'll clarify that. I have already filed IO.
No grounds, mother, no reasons assigned in the petition whatsoever as to why they didn't appear.
No, I will submit that. We have
I know
already,
they don't have an alternative.
No, one second, let me clarify your point. We have obtained the certified copy long back. We have filed a miscellaneous petition. Already it is pending before the tribunal. But the tribunal, after I did not know. I only filed the application. I did not know what is the position that already one miscellaneous petition had been dismissed. So we filed an application and that is pending now. I've been seeking adjournment and I was pointed out that it is not maintainable. So I just kept it alive and pending. And since I am coming before this honorable court, I filed one more application and produced before this court. That is how.
What other terms?
No, my lords, this is a government, my lords.
Huh?
This is Nirmiti Kendra is also a government. This amendment is there. We have already filed the application. It is pending miscellaneous. I have also mentioned it in the petition that it is pending.
And the last occasion itself I mentioned, my lord, their turnovers runs to crores of rupees.
Some deposit let them make now.
Please, whatever my lords feel reasonable.
How much? Then
They would have made a redeposit before the tribunal, my lords. I think 30% or 50%, depending on when they have filed.
30% is it?
30% that is deposited.
Free deposit would have been made before the tribunal.
So let him pay some cost.
Please.
My lord, this is a government, state government.
We'll give it to some good cause. Yes.
Or we'll deposit, direct deposit it before the tribunal itself.
No, some cost let them pay for whoever has to. Now that cost must pinch also. No? So some mistake has happened. Now this amount will go to the to your account. Let it be paid. The petitioner has called in question the validity of the order dated 25/4/2025 passed by the Karnataka Appellate Tribunal, whereby the tribunal, noticing that the petitioner was the appellant before it had failed to appear on more than one opportunity, and noticing that the appeal was of the year 2021, had dismissed the appeal.
It was first dismissed on 11/12/2023, Annexure C.
Dismissed the appeal, noticing that the petitioner had failed to prosecute the case from 19/2/2025 for about 6 hearing dates. It is to be noticed that insofar as the same appeal, that is STA 19 of 2021, on a previous occasion as well, on where is that order?
That's
11/12/23. Is it
11/12/23? Page
on 11/12/2023.
Page 28.
On 11/12/2023, the appeal came to be dismissed for non-prosecution. Full stop. Thus, it becomes clear that the order dated 25/4/2025 is the order dismissing the appeal for the second time upon restoration.
Yes, actually, my lord, the tribunal cannot dismiss for default, but the learned members over there, why they dismiss is because so that we come back to the court and then otherwise, if they dismiss it on merits, then we will have to come.
Going by, again, I agree with the statement made by Mr. Tirumalesh. Tribunal, my lords, usually does not dismiss the appeal for non-prosecution. Even if it is an ex parte order, they proceed on merits.
They have to proceed on merits, but because they want us to come back, they will dismiss it.
On 11/12/2023,
yes,
it was dismissed, then restored, then again dismissed.
Again, the counsel, what happened? He retired from the case, or rather, he did not properly retire, and therefore, everybody was in dark.
Next, learned counsel for the petitioner submits that the counsel on record had not prosecuted the proceedings diligently, and due to some lapse on part of the counsel, the petitioner ought not to suffer. Next. It's further submitted that though a second miscellaneous application has been filed by virtue of amendment to regulation 28 of the Karnataka Appellate Tribunal Regulations 1979, there is a bar for restoration on more than on the second occasion by virtue of the amendment made to regulation 28.
Actually, that applies to revenue appeals, not to
That is accordingly it is submitted that the ignoring the miscellaneous application filed, this court may take a lenient view of the matter and restore the appeal. Full stop. Next. Facts referred to above. The detail the lapse on the part of petitioner in diligently prosecuting the proceedings. Next. However, it is to be noticed that the second miscellaneous application stated to have been filed would meet the fate of dismissal in light of amendment made to regulation number 28, as admittedly the appeal was filed on an earlier occasion and dismissed and subsequently restored. Full stop. If that were to be so, the second order of dismissal cannot be set aside by the tribunal by virtue of amended regulation 28 of the KAT regulations. Full stop. Next. No doubt petitioner has been negligent. No doubt petitioner has not prosecuted the proceedings with due diligence. However, in light of the undertaking that the petitioner, if given another opportunity, would prosecute the proceedings with all diligence and not seek for any adjournments on the date fixed, the petition may be allowed, putting the petitioner on terms. Taking note of the prejudice that may be caused to the petitioner if the appeal order, if the appeal is not permitted to be heard on merits, and putting the petitioner on terms, the order dated 25/4/2025 is set aside, matters remitted for fresh consideration. The appeal would now stand restored and to be heard by the Karnataka Appellate Tribunal. Full stop. Petitioner to mark his presence without further notice before the Appellate Tribunal on 11th.
On the next date of hearing.
Huh?
There is a miscellaneous petition filed.
No, don't. We'll leave that. I'll make an observation. Now we'll have to on 11th of May 2026. Full stop. Needless to state, the petitioner is to withdraw the miscellaneous petition pending before the tribunal filed against this order of 25/4/2025. Full stop. Petitioner to pay costs of rupees 15,000 to so and so.
10,000.
No, it's okay. It's okay. Yes.
11, serial number 11.
Now that miscellaneous petition is for this 25/4 order, isn't it?
Yes, yes.
Pertains to assessment here 10/11.
Huh?
10/11. Interest, it's running to 10 crores. I think this is
11.
Appearing for petitioner, your lordship.
Yes.
This is for. See,
Petitioner is the company for the assessment year 21 and 22. Return of income with the delay of 15 days to claim the benefit.
Yes.
Return of income with the delay of 15 days to claim benefit under 10 IC of the Act, your lordship.
10
IC. Due to COVID and the software was affected with the virus, your lordship.
1192B.
We have filed an application.
Take notice. Land Council Delhi accepts notice for the respondent. Relist on.
Let's after 2 weeks.
Did good. in same stage. Yes, next.
11, till number 12. 12 Srihari, Akash Bisheti.
My lord, this is a case where show cause notice is issued under section 76, my lords. My lords could recall on the last occasion it was explained to the court that section 76 is a provision which envisages.
Is it the copy today, my lords? I'll have to file objection. I just gone through it. I'll have to file my objections, my lords.
There is no interim order in this case. My lordship may kindly grant me interim stay, my lords. Because this is a case, my lords, if I might just briefly explain, my lords. Section 76 has been invoked. Section 76, the precondition is that, my lords, there has to be tax collected and remaining with me and not remitted to the GST department. Whereas this is a case where I had, at the time of filing of annual return, duly discharged the liability. So liability stood discharged and there is no tax amount of belonging to the government lying with me. In the absence of that requirement, section 76 could not have been invoked at all. They could have very well done 73. Section 76, my lords may kindly take to section 76 for a moment, my lords.
The counsel for the petitioner would contend that the proceedings under section 76 could not have been invoked as petitioner had already paid the tax.
Yes, my lords.
Counsel for the respondent respondent revenue submit statement of objections would be filed. Next, subject to further consideration, there would be stay of
KG-G1.
Annexure
K, my lords.
K
KG
G
G1.
G1.
That's it. KG-G1.
Respondents are at liberty to seek for modification of the interim order upon filing statement of objection. Yes.
13, Samir Gupta.
I'm appearing for the petitioner in this matter. My lord, this slight inconvenience may be put up for tomorrow. He's traveling from Delhi, my lords, for this matter. Sir.
No, it's better that he stays there and comes online. Tomorrow, if you're not able
my lords, there are other matters also.
Release tomorrow.
Tomorrow, kindly.
But you always advise whoever you are briefing that I am comfortable with online, because you come here, matters not taken up, then it's difficult for. Yes, next.
This seems to be a consolidated order.
Which one?
Previous matter, my lords. Orders are passed by the central authorities. It seems to be a consolidated order for 2018-19 to 23-24. In pursuance to which, my lords, the state authority, my lords, has for 1 year issued summary of the order. I think they are aggrieved by that and before this court. Consolidated notice is before the bench, my lord, is heard and reserved.
So we'll stay.
Much obliged.
Have you read the file?
I'm not aware of the facts.
Why? Should read, isn't it? Where is the order?
It's annexure A, my lords.
Annexure?
Annexure A starts from page 28. At page 30, my lords will kindly see.
The
financial year 2018-19 to 23-24.
Petitioner contents.
And my lords, the next summary of the order is at page 90.
Page
90, my lords.
Nine zero.
Yes. This seems to be issued by the state authorities, my lord. It says it is a summary of the order.
Okay, let us see. Now this multiple tax period. Suppose that order is some order is passed. Again, we'll have to revisit.
My lords, if that is the only ground that is taken up, in fact,
usually it will be multiple.
My instructions are, my lords, the councils, my lord, there has sought liberty that in case that court were to hold against the associates, sought liberty to file replies or independently adjudicate the matter.
The counsel for the petitioner What's your name?
My lords, my name is Chetan, my lords.
Chetan. Appearing, Chetan. You filed wakalat or appearing on behalf of?
No, my lords, my wakalat is there.
Chetan, appearing on behalf of the petitioner, submits that the order is passed on a single show cause notice for as regards multiple tax periods spanning between 2018-19 to 2023-24. Reliance is placed on the judgment in the case of Pramur Homes and Shelters versus Swans. It is submitted that there are other contentions as well. In light of the contention regarding single show cause notice as regards multiple tax periods, matter requires consideration. In the interregnum, there would be stay of.
Let's say short for stay of annexure.
My lords,
A and
annexure
B.
A and B.
AJ M. Kumar accepts. Respondents are at liberty to seek for modification upon filing their statement of objections.
14.
Much obliged, man. Great.
Serial number 14 is a case where 148 is issued by the jurisdictional assessing officer as opposed to the faceless. That was the ground, my lords. But the 148 is issued by an authority of Uttar Pradesh, Sonabhadra, Uttar Pradesh. My lords had on the earlier occasion directed emergent notice. The said officer contacted me and I had shared the details of Mr. Sanmati and Mr. Tirumalesh. As to what the instructions are, they have to submit before this court, my lord.
Who's there?
Sanmati.
They have already taken instructions as far as the respondent 3, 4 and 5 are concerned.
14.
Your Lordship, in this case, I am raising objection regarding the maintainability, my lord, territorial jurisdiction, my lord.
On the last occasion, my lords, my learned friend had given a judgment of the
Supreme Court, my lord.
Supreme Court
in case of Balak Capital.
Yes.
Your Lordship, in the second paragraph, my lord, the Honorable Supreme Court has followed its earlier order in the case of ABC papers, my lord, and has observed, my lord, it has been extracted, my lord, para 45 of the judgment. In conclusion, we hold that the appeals against every decision of the ITAT shall lie only to the High Court within whose jurisdiction the assessing officer who passed the assessment order is situated, even if the case or cases of an assessee are transferred in exercise of power under Section 127 of the Act. The High Court within whose jurisdiction the assessing officer has passed the order shall continue to exercise the jurisdiction of appeal. This principle is applicable even if the transfer is under Section 127 of the same assessment year. Your Lordship, the initiation of the proceedings, Your Lordship, it is not in Karnataka, my lord.
Now the order that is challenged
Yes,
is passed by.
Your Lordship, it is
order is passed by the faceless, my lord. May I explain, my lords? We have to distinguish the Balak Capital and as well as ABC. I will also submit before this court the judgment of the Supreme Court which was relied upon, ABC papers.
First respondent ITO Ward 33, Uttar Pradesh, my lord. Sonbhadra, Uttar Pradesh.
That was the original order.
Original order. He initiated the proceedings.
Now that order is assessment order, is it?
That is the assessment order, my lord. In fact, if I may explain, my lords.
I'll just come to that. Let's have a look at that order.
The assessment order would, my lords would find it at annexure D1, page 52. That is an order passed by the faceless authority, whose office officially is New Delhi.
Annexure D1, my lord.
Annexure D1. It is a faceless authority.
Page?
Page 52, my lords.
Now, in case it's, is it faceless, is it?
Faceless, my lords. As would be
signed by
the assessment unit, my lords.
Page?
It would be signed by the assessment unit whose location is kept secret as per the policy. Whose location would be secret as per the faceless policy, my lords.
So still, only point you may have a good case, but if we were to open the floodgates, It'll become a mess.
No, my lords, the point is different, my lords. The challenge is more to the assessment under notice under section 148. May I just make out my case, my lords?
So that may be so, but it can't be that the nexus, geographical nexus, if we were to overcome, then there will be problems.
Your Lordship,
His file may be maintained there. In UP, his file would be maintained, isn't it?
Annexure A 148 AB is issued by the jurisdictional layout, that is Uttar Pradesh, my lord. Page number 44. That is the starting of the reassessment proceeding.
That is
Annexure
issued by
A.
ITO.
Annexure A, ITO, my lord, Sonabhadra, Uttar Pradesh, my lord.
Question, my lords, is that my lords may kindly appreciate. I am staying in Mysuru since the year 2016. My portal, income tax portal, was also duly updated, reflecting Mysuru address, which my lords would stand evidenced with the annexure N, page 145. Prior to the issuance of the proceedings by the Sonabhadra authority, a investigation was carried out as to the income that is purported to escape.
140.
Page 145. Now, the investigation was carried out by the Mysuru authority. The department was very much aware that I am a resident of Mysuru. Therefore, my local jurisdiction investigating authority carried out investigation into the sources of my receipts. Page 145, my lords. My lords have it, my lords?
Yes.
My lords would see it's a notice issued by the investigating authority of investigation DDIT, ADIT investigation Mysuru. And address is given to my local address, Mysore. The notice is dated 7th of December 2021.
Your PAN is registered where?
My lords, when the PAN was originally registered, it was in Sonabhadra. But subsequently, I shifted myself to Mysuru in the year 2016. I intimated the department about all those things. Department is aware. Therefore, when they carried out investigation into the sources of my funds, it was the appropriate authority of the Mysore jurisdiction who conducted the investigation. He conducted the investigation. He issued summons. I filed reply. Data was collected, and when the data was populated into the system, my lords, it was auto populated into the system of the authority who held jurisdiction as per the PAN records. Therefore, Sonabhadra authority, without application of mind as to whether I reside within his jurisdiction or not, automatically issued the 148 notice, 148 AB notice electronically.
Correct.
However,
it may be one with.
That I will distinguish, my lords.
Where the assessing officer is, there is the jurisdiction.
That is not. In the case of ABC papers, which has been relied upon in the Balak capital, deals with the jurisdiction in an appellate jurisdiction. Under the income tax system, we have assessment order, which is to be challenged by the appellate authority, which is to be further challenged before the ITAT, which is against which the statutory appeal lies before the High Court. The Supreme Court was deciding which would be the appropriate.
What jurisdiction?
Because, my lords, the undermining factors to be considered at the time of determining the cause of action is that the cause of action should have occurred in the jurisdiction of this honorable court.
No.
I am a resident of Mysuru.
That may be so. That may be an order without jurisdiction, but you have to go before the court there, get it set aside, and then it comes back.
I cannot go there, my lords. Not only do I not have the means of going there, I fall squarely within the jurisdiction of this honorable court. I rely upon the judgment of the Supreme Court in the case of Rajendran Chingaravelu, my lords. One copy, Ali.
Now you make a write up and give the judgments. Let him have a look at it. We'll hear both sides. You refer to
My lord, item 15.
substantiate regarding jurisdiction. Copies of authorities relied upon to be served in advance to Council Sri Sanmati, and a note be prepared on the judgments sought to be relied upon. Now you have first relist on 15. You address 226, 227, ABC, and the other.
In the same stage, my lords.
Yes, same stage.
15, Venugopal P. Akash Shetty.
You come
My
prepared,
lord.
Sanmati, the judgments.
Please.
Then we'll hear.
My lord, item 15,
Yes.
I'm challenging the rejection of the amnesty application filed by me under section 128A, my lord, on two grounds. Your lordship may kindly take rule 164, sub rule 13, my lord. Rule 164, sub rule 13 of the GST.
Just 1 minute. CGST rules, is it?
GST rules, my lord. It prescribes the time limit within which the order has to be passed.
Just
164.
One
164, sub rule 14. Shall I read, my lord?
Just 1 minute, just 1 minute. The rules ಇಲ್ಲ ನೋಡಿ.
Or it is reproduced in my
164 or 154?
164, my lord, 164. It came in 2024, my lord, so it may not be there in an old book.
ಇಲ್ಲಿ ಇದು ಹಳೇದಿದೆ.
I'm just seeing whether
Rule
it is reproduced in my.
Read
Yes,
it,
my lord.
read it.
Yes, my lord. It says, if no order is issued by the proper officer within the time limit specified in sub rule 13, then the application in form so and so as the case may be shall be deemed to be approved. So it has to be passed within the time limit prescribed under sub rule 13. Sub rule 13 says a notice will be issued if I file a reply within 3 months from the date of reply.
Just 1 minute.
If I do
Just 1 minute. Just 1 minute.
Yes.
Rule 164 sub rule
14, my lord. 14.
Yes, read.
If no order is issued by the proper officer within the time limit specified in sub rule 13, then the application in form GST SPL1 or SPL2 as the case may be shall be deemed to be approved and the proceeding shall be deemed to be concluded. So the time limit is specified under sub rule 13. I will just say the time limit, my lord. As soon as I file an application, they will issue a show cause notice. If I file a reply to the show cause notice, the order has to be passed within 3 months from the date of reply. If no reply is filed, the order has to be passed within 4 months from the date of the show cause notice. Now, kindly come to page number 40, my lord, of my typeset. The impugned order. Page number 40. 40.
Now you have made out your reply, is it?
Yes, my lord. No, I'll come to that. Both cases it is time barred. Your lordship will find it page number 40. The show cause notice is dated 11/7/25. Lordship got it?
Yes.
Table in page 40.
Yes.
The reply date is 14/7/25. Actually, it is not a reply. It's only an adjournment request. Be that as it may. From the reply date, the order should be passed within 3 months. That is 14/10/2025. Or if this is not considered as a reply, from the show cause notice date 11/7/25, the order should have been passed on 11/11/25, whereas the order has been passed on 14/11/25. This is my first ground, my lord.
Yes, you check.
Even if it is treated as that I have filed a reply, it should have been passed within 3 months from the date of reply. Actually, that is not a reply, which your lordship will get it in page number 37.
No reply, then within
4 months from the show cause notice. That is 11/7/25. 4 months will expire on 11/11/25.
the order is passed on.
The order is 14/11/25. 14/11/25.
Yes.
This is one ground, even on merits also, my lord.
Let us see, let us see. Now you'll get instructions.
I'll file my pleadings.
The petitioner, counsel for the petitioner would submit that the order passed at annexure A1 is beyond the time prescribed under Rule 164, Sub-Rule 13.
14.
Submitted that
14, my lord.
within the time prescribed under Rule 164, Sub-Rule 13. It is submitted that the show cause notice dated 11/7/25 ought to have been, the show cause notice is dated 11/7/25. An order ought to have been passed within 4 months if no reply was filed. That is by 14/11/25.
No, 11, 11,
Whereas
25.
11/11/25, whereas the order is passed on 14/11/25. This matter requires consideration. The Learned Counsel Akash Shetty requests time to file, take a stand in writing. In the interregnum, there would be stay of
A1, A and A1, my lord.
stay of annexure
Annexure
A
A and annexure A1.
A1. Respondent is at liberty to seek for modification of the interim prayer upon filing statement of objection. Yes.
16, Aryan.
Yes.
Service tax matter, my lords, where the show cause notice is issued based on third party data. My lords may find it at page 26, my lords.
Could you go?
Chinmay has annexed, my lords.
Page?
Yes.
Where is
Page
the-
number 109. Oh, page 26 is the show cause notice. My lordship's order is at page 119.
Show cause notice now has resulted in order, is it?
Order in original as well as an order in appeal, my lords.
Appeal also.
Order in appeal. Annexure C and D.
Now, what happened in the, now on merits, what is your stand?
My lords, they've not gone by the work. We are providing works contract service, my lords, and we have a very good case insofar as limitation is concerned.
Limitation.
Yes. And eligibility of exemption notifications also can be scrutinized once again properly, my lords, in terms of my lordship's order.
Now, what happened in appeal?
Yes, my lords, at annexure D, the appeal was dismissed as time barred.
As time barred.
As time barred.
Yes.
But they are liable to pay the service tax, my lord. Only thing is that they may have to reconcile, my lord, to what portion that service tax they are liable to pay, my lord. In appeal, it has been dismissed on delay, my lord.
In some of the appeal orders, that's I think income tax. They just say, simply they say time barred one.
Income tax matter.
But
GST, they.
But that some reason must be given, isn't it? Now it will be a non-speaking order if they simply say.
My lord, in GST they say that because he's a statutory creature, he cannot go beyond the time limit which is prescribed under the Act.
Yes, the petitioner has challenged the validity of the order in original at annexure C, whereby the authority has assessed the petitioner to service tax in terms of provisions of the Finance Act 1994. Petitioner has also challenged the order in appeal at annexure D, whereby the appeal came to be rejected on the ground that the delay, on the ground that the appeal was filed beyond the time limit prescribed for filing the appeal, and the authority could not entertain appeal after the prescribed period. Counsel for the petitioner would submit that the order is passed on the basis of inputs received from the Central Board of Direct Taxes, and in such cases, this court in WP 1154 of 2023 had set aside the order and remitted the matter back for fresh consideration. It's ex parte, is it?
No, my lords, we have participated in the first round of orders.
It is further submitted that petitioner had raised various contentions, including that the proceedings were initiated after prescribed period, and also regarding eligibility of exemption, which requires reconsideration. Learned counsel appearing for Sri Arun Chavan appearing for the revenue, however, would dispute such aspects. Next. It is to be noticed that this court in WP 1154 of 2023 and connected petitions had considered the aspect of demands being raised under the Finance Act 1994 on the basis of inputs received from the Central Board of Direct Taxes, as well as on the basis of declaration made under the income tax returns, and has laid down certain guidelines and remitted matter for reconsideration. Next. It must be noticed that admittedly appeal has been dismissed without entering into merits of the matter on the point that appeal was filed beyond the prescribed period of time. Next. Insofar as the order in original, this court is required to take note of observations made in 1154 of 2023. Repeat para 10. 10. Next. Taking note of the same, the order in original at annexure C is set aside, and matter is remitted to the stage of
reply to show cause.
Reply to show cause notice. Petitioner is at liberty to make out additional reply to the show cause notice. Authorities to take note of the observations made in the order dated 3/7/2024 passed in WP 1154 of 2023 and connected petitions as extracted supra in specific to the observation para 10 of the order as may be applicable. All contentions are kept open. Petitioner to appear before the respondent number.
Respondent number, my lord.
Date may be given.
Which respondent? With on
First respondent.
First respondent on 11th of May 2026 without waiting for any fresh notice. Accordingly, petition is disposed of.
Serial number 17. Pradyumna.
Yes.
Lordship, what is challenged in the impugned order, difference of ITC between 2A and 3B, it appears to be an ex parte order, Lordship. Service of show cause notice is doubtful, as can be seen from the screenshots of the list of notices served, which is on page number 29.
You are also in doubt.
But
you are also in doubt.
I feel because my friend
page 26,
29 is the screenshots, Your Lordship. It's not served as per, it's not uploaded as per the screenshots. Intimations are also not done. Various other notices like ASMT, etc., have been uploaded.
Yes.
Issue on merits is covered by Lord's decisions. He can verify the documentary evidence, Your Lordship. I pray that the matter may be remanded.
Yes.
Which, they have appeared before the assessing authority and filed a
No,
reply.
it says, Your Lordship, even I saw it on page number 25, it says, auditee replied to
26
show
month.
cause notice. Page number 25, it said auditee replied to show cause notice, but one page. Then next it says, yes, filed, not filed a reply. Page number 25, Lordship, the opening para. In response to the show cause notice, taxpayer submitted reply and this office provided opportunity to attend personal hearing on 3/8/2024, 15/2/2024. Auditee furnished reply dated 29/10/2024 and 13/11/2024. Then, Your Lordship, later in the later. Auditee has not furnished any reply, that is recorded on page number 27. Some contradiction in this order, Lordship.
At page 26, my lords.
Yes.
Record of personal hearing, reply.
Page 20?
Page 26. I think the page number might not tally. Internal page 3 of 6 months. Of
25.
annexure A.
25, page number 25.
Here it is 26. Record of personal hearing, reply.
No, where is, yes. Correct. That is
First,
yes.
head note. my lords.
Yes, that is there.
Then the second one, my lords, the findings and reply filed by the noticee is discussed as below. I have carefully gone through the records of the case, contents of the show cause notice, reply to the show cause notice, and submission made by the auditee during the course of personal hearing. I take up the issues of demands made in the show cause notice, applicability of interest, and penal provisions invoked in the show cause
No,
notice.
just go to 5 of 6.
Please.
27, page number 27.
Page 5, my lords.
5 of 6.
In view of the above discussion, notice
No,
is like
evaluation of auditee reply.
Page number 27. 27, petition 27. Top pair.
Please.
Auditee has not furnished reply.
Auditee did not appear for personal hearing and did not furnish any documents.
Page number 27, it says that not furnished reply pertaining that some kind of mistakes, errors in the order, Your Lordship. Sentence is not proper. Pertaining stating that they are producers of breakfast cereals and grains based on products and payment of goods is made immediately upon receipt and auditee furnished ASMT 10 issued to the auditee. Some contradictions. Matter has to go back, Your Lordship. He has got the evidence, he will produce it.
10% of the tax amount, my lords.
I mean, normally, the case where Lordship clear in ex parte order, SCN also, the show cause notice also not served. So
In
it can open
16(2)(c) cases, my lords have entertained the writ petition subject and granted an interim order subject to deposit of 10% of the amount, tax amount. And this is an order passed in the month of May 2025, my lords.
But services on recently.
What is the demand?
The demand is at
I've summarized it in
internal page 5, my lords.
petition with the Lordship.
10 lakhs, sir.
77,000 CGST, IGST of 77,000, CGST of 4,71,000 and SGST of 4,71,000.
10% I'll deposit. Small amount.
The petitioner.
10% of all these three amounts.
Tax amount.
The petitioner.
I'm not asking for penalty amounts.
Yes, sir. Sought for setting aside of the impugned order of adjudication dated 20th February 2025 at annexure A. Is the case of the petitioner that a full opportunity was not granted before the authority to demonstrate that there was no discrepancy insofar as the ITC claimed, as also between the GSTR 3B vis-a-vis GSTR 2A.
The circulars may not apply to this particular assessment year in question.
Yes, yes. Full stop. It's submitted that if an additional opportunity is granted, petitioner would be able to demonstrate that there are no alleged discrepancies between GSTR 3B as well vis-a-vis GSTR 2A. Full stop. Peruse the order. The authority under the caption evaluation of auditee reply within inverted comma has noticed that the petitioner has not placed all requisite material before the authority. Full stop. Next, in light of the assertion of the petitioner to take stand on merits and demonstrate that there are no discrepancies regarding ITC claimed, and noticing that the adjudication is based heavily on documents, it would be appropriate to set aside the order at annexure A and remit the matter to the stage of reply to show cause notice. Full stop. The petitioners put on terms by directing the petitioner to pay 10% of tax demand, which would be subject to adjudication proceedings. All contentions and merits are kept open. Petitioner to appear without fresh notice before respondent number.
Sole respondent.
Sole respondent on. Accordingly, petition is disposed of. AG M. Kumar accepts notice for the respondent.
18
for the year 21-22, Lordship, identical. But only difference is, Lordship, here the proceedings were initiated by the central tax authorities also for a higher amount. So while he had not received, the contention that he had not received the notice in respect of the demand raised by the state authority, in respect of central authority had passed in proceedings, adjudication proceedings. For more than 48 lakhs, the demand was raised and it was dropped around 6, except for 6,77,000, rest of the demand has been dropped for very same area, Lordship. So that order has been challenged by filing an appeal before the appellate authority for very same area, Lordship.
Central tax.
Which order is challenged?
It is on the order passed by central authorities, page number 51, Lordship, beginning from page number 51. And page number 53 gives the table, Lordship, that is for the year 2021 and 22. Page number 53.
Page number
53. 21-22.
Petition, idu adu ulta agidare.
There are a number of other, now this is not the order in challenge, this is not improved order, this is the central authorities, order passed by central authorities. Page number 65 is the operative portion, Lordship.
You should number the petition properly and give it to me. This is a different petition altogether. Adrad idike hakidira, idru adಕ್ಕೆ hakidira. ನೀವು ಬರ್ಕೊಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ಕೊಡ್ಬೇಕು. ಇದು ಬೇರೆ ಸರ್, ಇದು ಹಳೆ ನಂಬರ್ ಇದು.
Shall we have it tomorrow?
No, my lords. What has happened is numbering, because it was the petitioner probably
Interchange of the petition in his copies.
change the number to the in the copies given to me.
So that order has been challenged, Lordship.
The central tax order?
Central tax order has been challenged. That's the appeal papers have given, Lordship. Now, he had raised the demand for a higher amount had been raised, and that was dropped after appreciation of the documentary evidence, except of 6,77,000 rupees, which is under challenge.
Correct. Then let them look into it.
I'll verify, my lords, because we have to see who has initiated the proceedings.
M. Kumar accepts notice for the respondents. Relist on?
Next week, my lords.
Relist in same stage on
15.
Same stage.
19. Balaram R. Rao, 19.
My lords, appearing on behalf of the petitioner, this is arising out of a search assessment wherein there are 11 other petitions that need to be connected and heard, my lord. That is what prayed before this bench. If the same may be extended to serial number 23 and 95 in the same list, we would be grateful, my lords.
20?
23 and 95, Your Lordships.
All can be clubbed there.
Yes, and the list of club matters will be given to the court officer.
Learned Counsel Dilip accepts notice for the respondent. Stop. Same order in 23 and 95.
95, my lords.
List serial number 95 and 23 along with serial number 19.
My lords, a date may be granted for this.
All these matters to be listed along with WP number so and so on.
Lords, on 21st.
On 21st. The same stage. Please. Yes.
Number 20, Mohammed.
Please, Manoj. I beg to appear virtually, Manoj.
Yes.
This entire proceeding is vitiated on two separate grounds. The first ground is that the DRP has not actually done anything. DRP has simply remanded the entire matter covered by the judgment of this court, this honorable court in GE. Second ground is natural justice. And on that, I'm squarely covered by two judgments of the Delhi High Court, and I'll just show the facts. So the officer himself in the draft, I'm just summarizing in 2 minutes. Just summarizing, and I'll just show the documents. The officer himself in the draft order and the final order says, I don't have the data myself. So why don't you get the data? And he has made an addition under section 69C on the basis of customs data, which he says he's got, but he doesn't have the complete data himself. So Lordship may see, and I show the pages now. First, I come to the natural justice ground. Lordship may see assessment order itself starts at page 56. Your Lordship may see 138. This is the final assessment order.
Page
138. The assessment order starts otherwise at 56. I am reading 138. 138.
Yes.
Lordships may see para small d, which is the second para. Assessee has submitted that during the course of the assessment proceedings, it has repeatedly requested to provide the invoice-wise, bill or bill-wise, entry-wise import details as appearing on the CBIC Insight portal to enable the company to reconcile the same with the imports in its books. Assessee has stated it has asked for it in the show cause notice as well. Assessee has also applied to the customs officer itself. And he says, however, then he says at the next para, above explanation, facts of the case has duly been considered, though the complete invoice-wise CBIC data could not be retrieved, so he can't retrieve it himself, in spite of repeated efforts by the department. But it is also a fact, assessee was also aware of the discrepancy, and it could have got the certificates from the concerned custom authorities long back to support its claim, which has failed. And then he says in the last 4 lines, however, considering the fact that the assessee has applied, so it says you go and apply and you reconcile. In the meanwhile, I'll make the addition. However, considering the fact assessee has now applied for month-wise, invoice-wise data for the year under consideration, on receipt of the same, assessee is free to submit the certificate. And just quickly, if your lordships will see, DRP also does nothing. DRP says the data is not in front of us, let the AO do it. DRP says at page 277. 277. So the admitted position is neither does he have the complete data nor do I have, but he's making an addition of 83 crores. 277. If your lordships will 277 minutes.
Yes.
Lordship may have the para under bold discussion and directions of the DRP. AO has made an addition of huge addition of 83 crores odd under section 69. 69 is unexplained. Of the act on account of difference between purchases as per the books of accounts of the assessee and the data as per the records of the CIC. Despite assessee's request, AO has not provided, admitted fact, the source of the data and the data since there was some technical problem. Considering the short time, AO made the protective addition. And then they say, however, assessee will be allowed an opportunity to reconcile during the course of giving effect. So lordships have said DRP cannot remand matters. Here the DRP says neither do I have, nor does the AO have. In the course of the final order, let the AO do it. We are doing nothing. And they say, in view of the remarks, panel directs the AO. So this is vitiated by the judgment in GE where lordships have said DRP cannot remand matters, it can only get an inquiry report from the AO. Now on natural justice, this case is squarely covered by another High Court in Bosch and Lom, the Delhi High Court, at page 317. This is annexure N. There are two separate judgments of the Delhi High Court, identical facts. 317, Bosch and Lom. Justice Bhakru's judgment, is a matter of fact. 317. And relevant portion is at para 2 onwards. The assessing officer has added, am I there, Malaj? Para 2, 319.
Yes.
Caution law. Assessing officer has added a sum of here also 70 odd crores to the total income as unexplained expenditure under 69C, same section under my case. In addition, imposed penalty. The controversy essentially relates to declaration of purchases made by the assessee during the year so-and-so. Assessee was called upon submit detail having done so. It is the assessee's case that its entire purchases were imposed, details of the same were. However, assessing officer found that the declaration was incorrect, assessee is not declared. Then he says, Malaj may see para 3 last 2 lines, last 3 lines, the assessing officer, para 3. The assessing officer based the said conclusion entirely on information received from the Central Board of Indirect Tax and Customs to the effect goods purchased during the relevant previous year was so and so. And thereafter, your lordships may see the reasoning given is in the CBIC note, which is the same as mine, para 6, CBIC import data. This is the information. Assessee has submitted, it has not made the purchase of so and so as informed by the CBIC. As assessee has submitted details of its purchases, which is my case. I have made my purchases, I have disclosed them. And then they say on the next page 320, CBIC has provided month-wise data where it reports clearly. This is the assessing officer's order. Reported. Which para? Well, I am reading para 6, 320, page first line, 320. This is the assessing officer's order which has been reproduced by the High Court. CBIC has provided month-wise data where it has clearly reported goods worth so-and-so. Indian Customs Department is the apex body which deals with all imports made and keeps tab of every single import. Data is shared by apex body. Hence, it has been concluded, this was his conclusion. Hence, it has been concluded, assessee has not shown the goods worth so-and-so. Assessee was clearly told in VC that Indian Custom-wise Department has provided month-wise data for imports along with number of bills. So in my case also, there is some month-wise data, which neither he has complete nor I have complete. He has to give me, to confront me first during the course of assessment with the invoice-wise data so I can at least reconcile what he's talking about. Now this comes in para 7 at page 320. It is apparent from the above that the assessing officer relied solely on the assumption that the information provided by CBIC was correct, notwithstanding it had not disclosed the details of any import bills, so invoice bills, and no reconciliation was carried out. Assessing officer has faulted the assessee for not reconciling the information regarding the quantum of purchases made as recorded from the CBIC as disclosed by the assessee. Learned for the respondent submitted the data was shared with the assessee. This is the department's contention. It is seen that the said data is in the form of a tabular which indicates cumulative invoice values. Your lordship read my assessment order. There also I am asking for invoice wise, and they say invoice wise we don't have. The cumulative assessable value of each month. The figure meant that all cumulative figures do not refer to any bill of entry or particular date of entry. It is thus apparent, para 9, it is thus apparent the assessing officer also had no knowledge. So they demand the entire matter on natural justice back to say first you get the data, then you confront the assessee with the data, and then you make any addition if you have to. This is the ground on natural justice. On the fact that the DRP has done nothing and the DRP
just read para 9. Just read para 9.
Absolutely. Para 9. It is thus apparent assessing officer also had no knowledge of which import or purchases made was not disclosed by the assessee, as assessing officer also had no such information. We accept the contention apart from stating it had not imported the goods. It was impossible for the assessee to dispute additional purchases. Assessee could not be faulted. Sorry, this is the correct part. The assessee could not be faulted for not reconciling the data as the information was wholly insufficient for carrying out any reconciliation exercise, it is obvious that the reconciliation exercise can only be carried out if the details of, Lordship may read this, invoices of bill or entry were available. Without such information, it is impossible to identify the alleged purchaser or import that was subject matter of dispute. If any addition was proposed to be made on the basis that the purchaser reflected in the assessee's books is not correct, and it has made certain imports that had not been recorded, the least that the assessing officer was required to do was identify the entries that ought to have been made in the books of accounts of the assessee, which it had failed to do. Merely proceeding on the CBIC is an apex body, therefore information cannot be doubted without even identifying or meaningfully analyzing such information is wholly insufficient to proceed to make addition. If the relevant details of import were not available of the assessing officer and not possible to identify the expenditure made by the assessee, it was impermissible for the assessing officer to make an addition on account under section 69C. Plainly, if the assessing officer could not identify the expenditure made, it could not make an addition on account of unexplained. In view of the above, we find, I'm reading the next paragraphs, we find merit in the contention that impugned order is unsustainable, has been passed. Now, just to show my own case quickly, just to match the facts, Lordship may just come back to the assessment order I showed your Lordships at page 138. Lordship may see 138 B, which I had read to your Lordships, and match it with the judgment on all fours. Assessee has submitted, I'm reading B 138. Assessee has submitted during the course of the assessment, it has repeatedly requested to provide the invoice-wise or bill of entry-wise import data as appearing on the CBIC Insight portal to ensure the company to reconcile the same with the import in its books. Assessee also stated it has asked for in the show cause notice. The assessee has also applied to the jurisdictional. So I have independently tried to get the data myself, but that cannot be the test. So I have independently, however, it would be highly difficult to procure such certificates from Customs Office, and the company will share as and when. Then he says in the next para, above explanation has been duly considered, though the complete, he says, this is his admission, complete invoice-wise could not be retrieved in spite of repeated efforts by the department, but it is also a fact, assessee was also aware, so he should have got the data. So this is on fall four. Just to match it further, in the draft order also he says at 227. So the case has always been, he also doesn't have it completely. But he proposes to make an 83 crore addition on this, 227. Lordship may see just the last para on 227. This is the draft order. In this regard, am I there, Malas? 227, yes, last para.
Yes.
In this regard, assessee has explained that it has requested for OE entry-wise or invoice-wise details of import purchase to facilitate the reconciliation of the import value. However, the same are not provided to it. Assessee has also argued difference in import purchases as per CBIC data as per books of assessee may be due to duplication of entries in the CBIC data. Along with this, assessee has furnished its own purchases. And thereafter, your Lordships may see there, it is a fact that due to, hence there is mismatch. Just the next slide. Hence there is mismatch in number of entries also in the data by the AO. It is also a fact that due to technical problems, CBIC import could not be uploaded from Insight portal, hence not provided to the assessee. And DRP, I showed your Lordships. DRP says, yes, we are doing nothing. We also don't have the data. Let the AO do it. And that is vitiated on a second ground. DRP order, just very quickly, 277. 277. So besides natural justice, on jurisdictional ground also it is vitiated. DRP has to carry out the entire inquiry itself. It cannot delegate it to the AO. 277 as per the act itself. 277. Discussion and directions of the DRP, bottom of 277, 16.1. The AO has made an addition of so-and-so under 69C on account of difference between purchases as per books of accounts and the data as per, despite assessee's request, AO has not provided, admitted fact, not provided the source since there were some technical problems. Considering the short time, AO made a protective. And AO said, however, assessee will be allowed an opportunity to reconcile during the course of giving effect to the DRP. So the DRP proceedings become illusory in my case. And the assessee, in view of the above remarks, panel directs the AO and the assessee to reconcile said difference. So DRP does nothing. And on this second ground, there's a direct judgment, your Lordships are aware, in GE by this High Court at page 337. So it is vitiated completely actually. It is not even a case for remand today. 337. This is the judgment in the case of GE, and the relevant portion your lordships will find at page 342. 342. I am reading para 11 at 342. Where Roman 5 para 11, the alternate plea.
Page?
Well, the judgment of G starts at 337. I am reading 342 of the judgment of G, division bench of this High Court.
Yes.
Well, it's 342 para 11, Roman 5. The alternative plea. Roman 5, small one. The alternative plea of the assessee was it is engaged in providing engineering design services. No details have been given regarding income earned, if any, from this segment. This is the DRP direction in this case. The assessing officer may examine this claim of the assessee and submit necessary information showing that it has earned income from engineering design, same qualify for deduction. Assessing officer should decide the claim in this regard on merit. Insofar as, this is the court speaking, insofar as direction number 5 regarding alternate plea that the assessing officer should decide the claim in regard to the material is wholly without jurisdiction in view of the provisions of 144C6A, wherein the power of the DRP is not extended to any proposed variation or issue any direction for further inquiry and passing of the assessment order. If such directions and orders are permitted to be allowed, the same would defeat the very object with which the alternate dispute resolution mechanism is provided, and therefore direction number 5 is wholly without jurisdiction, liable to be set aside as the said direction suffers from inherent lack of jurisdiction. And on the next page, the provision is also reproduced just to assist your lordships. 144C8, your lordship may see at 343, middle of the page it's reproduced, 144C. 8. If I'm there, let's 144. Yes. The dispute resolution panel may confirm, reduce or enhance the variation proposed in the draft order. However, it shall not set aside any proposed variation or issue any direction, or this part, or issue any direction under subsection 5 for further inquiry and passing of assessment. My case, the DRP has done absolutely nothing. It has said AO doesn't have the data, I don't have the data, let the AO do it. What is the problem here? Why is it called inherent lack of jurisdiction? Because otherwise this DRP mechanism becomes completely otious, because I can't come back to the DRP now. Therefore, it is incumbent on the DRP to get a remand report. It can ask for a remand report from the AO. Under 144C, there's another provision which directs it. It can get a remand report, but it cannot send back the entire.
In the present case,
yes.
What has the DRP done?
Yes, please see 277. Nothing. Nil. Nothing. DRP has done absolutely nothing in my case. 277. It has said let the AO decide the issue. We don't have the data. AO didn't have it. Assessee doesn't have it. Let the AO decide. 16.1277. Bottom of the page, I'll read again. AO has made an addition of so and so under 69 on account of difference between purchases of the assessee data as per record, despite assessee's record. Admitted fact. AO has not provided the source data since there was some technical problem, considering AO made the protective addition. However, assessee will be allowed an opportunity to reconcile during the course of game, which means in the final assessment order, for which I can't come back to the DRP. Now my only recourse will be to go and appeal. So my DRP procedure becomes meaningless.
No, if we were to set it aside and remit it back,
I would have been satisfied, but otherwise it is, as per your lordship's judgment, it is inherently without any jurisdiction. It is an assessment in which the DRP has acted like a standby mechanism that we are well, in Delhi High Court sometimes as a matter of in a lighter way, people say DRP is a pass-by body. Here they have called themselves a pass-by body. They have done nothing.
In 16.1.2, the DRP sends it back, isn't it? It asks the EO.
That's what the DRP cannot do. Just come back to the judgment of GE. Just come back to the judgment of GE at page 342. No power to remand for further inquiry. Only thing you can do is you have to decide the issue yourself. 342. 342.
Correct. Now, if we were to set aside the order of the DRP, then what happens?
DRP, if it's inherently without jurisdiction, your lordships would not perhaps send it back. In this case, the entire, in GE, which is a division bench order, the entire proceedings were held to be vitiated. GE held the entire proceeding on ground number 5 to be vitiated.
Just 1 minute. Now suppose we were to set aside this order at annexure J.
Yes.
Then it has to be restored to the same position prior to the impugned order and DRP to re-look into the matter.
Well, it's one, I mean, I have two independent grounds. One is natural justice. If it is natural justice, it has to go back to the AO to examine the matter. Second ground is that the DRP lacked inherent jurisdiction. If the DRP lacks, as per your lordship's judgment, the division judgment in GE.
No, I'm trying to understand.
I've understood. I'm just answering the question. If it lacks inherent jurisdiction, how can it have a fresh limitation? It is understandable if it is a procedural irregularity, the matter can be back. But if it is inherently without jurisdiction, can the court possibly confer the DRP with a fresh limitation when it did not have inherent jurisdiction to do what it did? Just see what the court says at 342 months. Inherent lack of jurisdiction to do what it has done, which is different from a curable defect in law, which would be curable under 292B, in which case it could be sent back. 342.
Now, just 1 minute.
Yes.
Now, if we were to set aside annexure J,
I leave it to your lordship. If you want to send, if your lordships wish to send it back to the AO to do a proper job, that also is. Though DRP has become time barred. I mean, as an officer of the court, I must submit that the DRP has become time barred now, and it inherently lacked jurisdiction. Otherwise, let me just submit one thing. Otherwise, even in GE, it should have been sent back. It was not sent back by the division bench. 345. Well, just look at 345 minutes. 345, item number 3. Direction is set aside. The matter is not remanded. After calling it inherent lack of jurisdiction, the direction is set aside. The court does not confer it with fresh limitation to issue a fresh order. Because it is inherent lack of jurisdiction, how can the court confer jurisdiction? How can the court confer limitation when today it is time barred?
Let us see.
Yes. In case of inherent lack.
Just one. Yes,
yes.
Your lordship may kindly see, my lord, the DRP order at annexure J has been acted upon. Now the final assessment order has been passed by the assessing officer, my lord, as per the directions of the DRP at annexure A, my lord, order dated 29/1/2026, page number 56. Your lordship, as per this order, my lord, your lordship may kindly come to the addition in question, my lord, that is at page number 129, para 8.3.
No, I just want to know, are your instructions complete? You're ready?
Yes, my lord.
Page?
Your lordship, page number 129, my lord, this addition, my lord, para 8.3, my lord. Page 129, my lord. This is the addition, my lord. Addition for difference in import purchases, CBIC data versus books.
Which
Your lordship, para 8.3, my lord, page 129. Your lordship, the assessing authority has made this addition on the basis of the CBIC data, my lord. Your lordship, as per the directions of the DRP, my lord, the assessee has also furnished some details, but could not give the entire details. Page number 138, my lord, para B.
No, now the DRP could not have ordered for any inquiry.
Yes, my lord.
What do you say
Your
regarding?
lordship, without going to that question, my lord, your lordship may kindly send the matter back to the assessing officer, my lord, with the direction to either to direction to both the parties, my lord, to assessee as well as the assessing officer to reconcile the entire data and pass order.
We are pressing that ground.
Order of the AO, annexure?
Your annexure A, my lord. Because your lordship may kindly see, if the matter is sent back to the, your lordship has to set aside the DRP order.
Yes.
Yes, after that, the matter will go back to assessing officer. He will pass draft assessment order. Again, they will have one more chance to approach DRP if they are aggrieved.
Now the order at annexure A could be set aside
for redoing, my lord. But he has to pass draft assessment order, and there will be an option for them to, if they are aggrieved against the draft order, they can approach DRP.
My learned friend is not answering your lordship's question on the question of DRP.
Without going to question whether the DRP has power or not.
But I am pressing that question, sir. You will have to answer.
Now, the DRP did not have power. That appears to be the correct position, plain reading.
Yes,
So
sir.
if the direction of the DRP were to be set aside,
Yes, sir.
then what happens is what I'm asking.
Your Lordship, if
Under
we
the
are,
scheme of the act,
then automatically this assessment order will go, my lord.
it will have to then go back to the stage of draft assessment.
Draft assessment order, but your Lordship has to remand it by setting aside. Your Lordship has to direct the AO to pass draft assessment order by considering the submissions of the assessee.
So just tell me the procedure. I'm not very familiar.
Your Lordship, in this case, my lord, the first step is passing the AO has to take up the assessment, and he will if there is any international transaction, he will refer the matter to transfer pricing officer. On receipt of the transfer pricing officer order, he will pass draft assessment order. The draft assessment order, my lord, if the assessee is agreed, my lord, either he can approach the Commissioner of Income Tax Appeals, First Appellate Authority by filing appeal, or he can approach the dispute resolution panel by filing objections.
Now, in the present case,
They have
objections
approached the
filed.
objections were filed, and
that's how it went to the DRP.
DRP has passed the order by giving directions to the AO to pass final assessment order.
So now the DRP's order is one without jurisdiction, it goes.
Yes, my lord.
So then the matter, then again the EO's order then will have to be.
Then
So
the draft
AO
assessment.
become let me just submit, the AO's order will become without jurisdiction today. Today, this assessment or this entire assessment becomes without jurisdiction if the DRP's orders are without jurisdiction. As in the case of GEP, if your Lordship just turn to page 344, bottom line. They say the entire thing lacks jurisdiction and they set aside the order without any remand whatsoever.
Your Lordship,
Apparently without jurisdiction, how can the matter be remanded? I ask myself.
Your Lordship, page number 326, my lord, there also the matter has been remanded back by the High Court, my lord. Delhi High Court, my lord, page 322.
My learned friend is answering two separate questions.
Now
One
the
is
draft
natural
assessment order.
Yes, ma'am.
Where is the draft assessment order now?
That is
Annexure A.
That is at Annexure A, page 56.
Now that is again.
That is 217, my lord, draft assessment order 217. Annexure H, my lord.
229.
That is the first original order, my lord, 217.
Now again, no. 229 is the direction.
Direction 217, my lord, draft assessment order. Annexure
217.
H.
Yes,
217.
217.
Correct. 217.
Now, if the DRP's direction goes, then the draft assessment order would stand.
Yes, my lord.
As against the draft assessment order, now what is the next stage?
And next again he has to approach DRP, my lord.
For fresh.
For fresh. Your Lordship can direct the AO to redo draft assessment order, and so that it will be open for them to approach the DRP if they are agreed.
Yes, we'll direct even the draft assessment order, as you had pointed out, the details were not sufficient.
Yes, my lord.
Let that be redone.
Let me just submit the entire assessment as per GE has become time barred because the DRP has 9 months to complete the assessment. In GE also, the DRP directions were without jurisdiction.
What is the time limit?
9 months, which is page number 315 minutes.
Under section?
Under section 144C is a complete scheme. 315. It's reproduced in the order of GE minutes. Your Lordship division mentioned. 315. Provision. 13. 1, 3, 12, 12. 1, 2. 315, subsection 12. Subsection 12. No direction under subsection 5 shall be issued after 9 months from the end of the month in which the draft assessment order is forwarded to the eligible assessee. So
No,
he's
correct.
but today
Yes,
the
what is-
procedure is lapsed. If it
Just
was,
one.
sorry.
Just one.
Yes.
Yes.
Your Lordship, that is for the DRP, my lord. Your Lordship, now your Lordship is Article 220. Your Lordship is remanding back to matter to the AO, my lord, to pass fresh draft order.
So the matter was the
Your Lordship may kindly have the Delhi High Court judgment per page 326. Page 322 is the starting, my lord. In the case
Before
of
we go there, can I just say one thing just to make the issue clear? There are two separate arguments here. Delhi High Court judgment is on natural justice. That is not a case where the DRP passed orders without jurisdiction. The second completely independent argument is that the DRP orders are without jurisdiction as per the judgment of the division bench of this honorable court in GE. That has nothing to do with the issue of natural justice of Delhi High Court. So my learned friend is alternatively showing this, alternatively showing that. That's not the correct thing, because there are two independent arguments. On the inherent lack of jurisdiction, there is this court in GE. On the issue of natural justice that you failed to consider CBIC data, there is Delhi High Court.
Just 1 minute.
DRP without being.
Just 1 minute. What
Yes.
I'm trying to understand, if the DRP's direction goes,
Yes.
then the draft assessment order would stand. What happens after the draft assessment order according to the procedure? I want to know.
Well, as after the draft assessment order, the assessee has an option to either go to the CIT appeal or the DRP again. So, which is why I'm saying, I'll explain first the procedure. Which your lordship, instead of going by what I say, go by 315, which is the provision itself. The entire procedure is listed out in 144. 144C, entire procedure is listed out. It's a complete code by itself, as per the revenue itself.
We'll continue at 2:30. We'll continue at 2:30.
2:30. Great.
Hello, submission.
Put it-
Thank you, madam. Tomorrow.
So,
One second, sir.
ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
One second, madam. One second. ನೀವೇ ಕೊಟ್ಬಿಡಿ ಸರ್.
ಸರ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ 2 ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ತಗೊಂಡು ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
ಬರೀ ಎರಡೇ ಮ್ಯಾಟ್ರಾ ಸೆಕೆಂಡ್? ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್
ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಬೆಳಿಗ್ಗೆ, ಆ 2 ಮ್ಯಾಟರ್ ತಗೊಂಡು ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
ಅದು ಲಿಸ್ಟ್ ಅದ್ರಲ್ಲಿ ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ತಗೊಳ್ತಾರ ಅವರು?
1 and 43.
1 and 43.
ಬೆಳಿಗ್ಗೆ ಮಾಡಿದ್ದೆ ಮೈನ್
is 29. So list 1. But list 2 we will take up only 2 matters, then we will continue with the list 1.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ತಗೊಂಡು
Mine is 67. No chance.
ಮಾಡಿ ಸರ್, ಮಧ್ಯಾಹ್ನ ಮಾಡಿ
39, 36.
ಮಾಡಿ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ತಗೊಳ್ತಾರೆ ಸರ್. ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ತಗೋತಾರೆ 20 ನಾಲ್ಕು ಸತೀಶ್ ಸತೀಶ್ ಕಂಟಿನ್ಯೂ ಆಗ್ತದೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೋಗೋಣ
ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ 3 ಸೀಟಿಂಗ್ ಇತ್ತು 11, 12, 13, 14 4 20 ಮಿನಿಟ್ ಹೌದು. ಹಾಂ
6841 of 26 ನಾಳೆ ಲಿಸ್ಟ್ ಆಗೈತೆ ಒಂದು ನಿಮಿಷ ಅರ್ಜೆಂಟ್ ಅದನ್ನೇ 6841 of 26
ನಾಳೆ 3 ದಿವಸ
ಯಾವ ಡೇಟ್ ಯಾವ್ದು ಇದೆ 6841 of 26
May I make one request? List number 2, serial number 49. There's some urgency because the interim orders are operating. Compensation are already paid to in respect of two petitioners. There are 3 writ petitions. Third writ petition, my lord, there was the direction, my lord, requested the parties to come and furnish the information. And they have not come and not furnished any information with regard to payment of compensation to them. But in respect of other 2 petitioners, my lord, is already paid. My lord. The interim order is coming in the way, my lord, so continuing the work, my lord.
Manjuna, the fresh matters list.
58.
Have it in the fresh matters list.
Tomorrow, my lord.
No.
58.
10th.
Grateful.
My lord, serial number 42, list number 2, electricity charges not paid, my lord. Interim order is operating against me. My lord, above 50 this is a private layout. They have to pay the electricity charges. Interim order is operating. 50 lakhs are due, my lord. Please. List number 2, serial number 42.
Let us see, today is difficult, but we'll see.
Today, my lord.
Today is difficult to take.
That's what I am mentioning.
Today is difficult. We'll see.
Tomorrow, day after tomorrow, in the top of the list. It is coming last from January. It is.
Let us see. No, done. Let us see.
58.
I'll see. Yes.
58 is second list.
58. Relist.
Your Lordship.
Just 1 minute. Relist at request.
Yes. Serial number 40, my lord. List 2. My lord, I request my lord some fresh matter, any other date, my lord. Before the Supreme Court in the Huchamas case, my lord, that notification was applicable. I request my lords any date, my lords.
Where is Charati?
I will intimate, I will inform my lord. 23rd, my lord.
Let us see. Relist on
27. My lord,
27.
list number 2.
Interim order may kindly be.
Interim order of
Serial number 19. Serial number 19 in list number 2, my lord.
19.
19 batch matters. List 2 only serial number 19.
Yes.
The coordinate bench has already passed an order quashing the final notification. Similar orders may be extended to us also.
Where is Vasanta?
Vasanta?
Covered, is it? Yes. The Friday, fresh. We'll have it in the fresh matters list. 10th.
My lords, list 2, serial number 2.
Just 1 minute. It's covered. Covered. Dismissed. Notice. No, who appears in that? Who appears? Who takes it?
Is which serial number, my lords? My lords, am I audible, my lords? Mr. Pai has made a mention.
Yes.
Is he making a mention of serial number 78?
Yes.
My lords, their ESG would like to appear and before any orders are passed.
No, that is there. So now
Yes.
who the yes,
Allowed only for CBDT I can take notice. Other
Arvind Chavan accepts notice for second respondent.
I
Tirumalesh
am
for
appearing for order.
third respondent. Then what about Union of India?
Sir,
Tirumalesh accepts notice for 1 and 3. So when do you want it? Relist date first.
15th, my lord.
Let us see date. 21st.
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 First time it's coming. Fresh matters.
My lords, list
They are
two.
challenging the validity, my lord. They are challenging the validity, my lord.
Correct.
Finance Act, 8 weeks time may be granted to file statement of objection, my lord. Because there is.
They have to file
no
their
urgency,
statement.
my lord.
They have to file their statement, isn't it?
8 weeks, my lord.
Not 8 weeks. Why 8 weeks?
Your lordship, because if I have to get it, latest 2026 Act, my lord, within 2 days they have filed the writ petition.
No, it was filed on the same day.
Same day of the Act.
The point is, what has happened, my lord, various high courts, including Karnataka High Court, has held that faceless assessment officers should have issued the 148 notice, my lord. Now, other high courts had also passed similar orders, which was pending before the Honorable Apex Court. Before Honorable Apex Court could decide on the matter, they have brought a retrospective amendment with effect from 1/4/21 matter. Now, there are various judgments, my lord, including the judgment of the Honorable Apex Court in Karnataka State Pawn Brokers Association, which says that unless you rectify the defect, there cannot be a retrospective amendment.
That is, we'll have it immediately after vacation. Relist the matter. List the matter in the week commencing from 1st of June.
My lord, but in this case, my lord, the assessment order is passed.
That we'll see. That we'll see. Validity has to be heard.
Yes, my lord. The recovery may be.
No, my lord, because taking advantage of this, they will.
Then on just one. No, just 1 minute. Now on the merits of the order, apart from that, if you can make out a case, on the next date you make out a case. I'll consider that. Insofar as the order, without reference to the constitution validity, you make out a case, I'll consider. That may be so, sir, but what I'm saying, if you are seeking for an interim relief, dehors the constitutional validity. If on the merits of the order there is some case, no, and then you wait.
It's restricted to the constitutional validity.
That may be so, but that's consequently you are seeking for relief of your assessment order. Then you'll have to wait.
Only to the extent of limited extent of recovery.
No, that we can't do unless you make out a case on merits, sir. If you are making out a case on the constitutional validity, then I'll hear it after they file objection.
Then I'll restrict my argument to the validity.
So next week date could it. Let us see. Relist on in the fresh matters list on.
Because AST date we have to get.
No, only on the
recovery.
On the merits of it without reference to validity. If he makes out, I'll record like that and pass some on.
My lords, list to serial number 24, my lords.
Yes.
It's been, it has to be relinked, my lords. It's been linked with 24.1, 24.2 and 3. List to serial number 24. It's a 482 matter, my lords. It has to be relinked, my lords.
See to delink. WP 4656 of 2026 from the batch of other matters, and the said matter to be listed before the roster bench forthwith.
A date may be fixed, my lords.
On 15th.
My lords,
Your Lordship,
15th.
my lord, serial number 39, list 2, my lords. Matter has not been reaching at all, my lord. Petitioner is a senior citizen who is 95 years old, my lords. Matter may kindly be taken up tomorrow on top of the list, my lords. Serial number 39.
39.
Matter has got listed many times, my lord. However, it didn't reach at all, my lords. May kindly be taken up tomorrow, my lords, on top of the list.
Just wait.
List 2, serial number 39.
27. List the matter in the fresh matters list on 27th.
Your Lordship, serial number 1.
65, my lords.
65.
List 165, my lords. There's threat of recovery, my lords. The issue is only related to consolidated show cause notice, my lords. It can be taken up out of turn.
65,
my lords.
65.
This is the matter in the fresh matters list tomorrow.
If it can be taken up today, my lords.
I don't know. You take a chance, you wait. If it doesn't reach, you make a mention to the court.
I'll take a chance.
I'll take notice, my lord. Tomorrow it can be taken.
Learned Counsel Arvind Chavan accepts notice for the
Respondents.
List the matter tomorrow in the fresh matters.
It can be taken up on the top, my lords. Top of
fresh matter. Yeah.
Much obliged.
Huh?
Your Lordship.
New word in the dictionary you use that.
Your Lordship, serial number 86 of list 1.
Just yes. Serial number?
Refund of 86, Your Lordship, list 1.
Yes.
Refund of pre-deposit matter from VAT, Your Lordship. The matter has been listed but is not coming up for the last 2 weeks, Your Lordship. The order for the refund was passed way back in 2021. This honorable court has also passed a judgment in the matter in June 2025. Fresh matter, if it may be listed tomorrow, Your Lordship.
Fresh matter. Relisted in the fresh matters list tomorrow. Yes.
Much obliged, Your Lordship.
Serial number 1, Manjunath 3.
My lords, continuing matter was there. That's serial number 20.
Just wait.
Serial number 20.
Just wait.
Yes.
Lord, as submitted, Lord, yesterday in this matter, Lord, NHI, Lord, though it is not, there is no obligation, but NHI is ready and willing to give 8 feet likeness space throughout the boundary, Lord. So for landowners to that.
Manjunath is notes. Memo. Now you have challenged.
They are against construction of boundary wall.
Annexure G is challenged.
Now you can't challenge only construction of boundary wall unless you challenge validity of the notification. You cannot challenge construction of boundary wall unless you challenge the validity of the notification.
Validity of the
Notification.
notification. Lordship kindly.
They have received compensation and they have no
Just a moment.
objection.
Lordship kindly take up. I have also challenged in respect of Annexure D also. Annexure D
the requisition made by the petitioner during the year 2019 itself.
No, no, now what right you have? You have no right.
I have a right, my honor.
What, under what provision of law you have?
Under section 32.
30?
32 of the LERR Act.
No, is that act applicable?
That is not applicable. That is
How
applicable
is it applicable?
only so far as
Applicable.
determination of compensation.
Right. One ನಿಮಿಷ.
Yes.
Lordship, LERR Act, not a National Highway Act, my lord. Not a National Highway Act, my lord. Lordship, kindly take up right to fair compensation and transparency.
How
land
is this act
acquisition.
applicable to, how is this act applicable to National Highway Act acquisition?
Lordship, kindly take up section 3B of right to fair compensation and transparency, land acquisition, rehabilitation and resettlement act, 2013 act, my lord.
Section 3?
3B and C, my lord. B and C. 2013 act. Definition, my lord. I am the affected person, affected family member. Because of acquisition of the land, I am the affected family member. Lordship, kindly see the 3B. Affected area. May I read? 3B.
Yes.
Affected area means such a area as may be notified by the appropriate government for the purpose of land acquisition.
Yes.
3C, my lord. Affected family members. Family includes a family whose land or other immovable property has been acquired. B, second, a family which does not own any land but a member of such family may be agricultural labor tenants, including any farm land or form of tenancy or holding a usufructuary right. I have an easementary right in respect of to reach my land. As per section 3B, my lord, 3B and 3C, I am the affected family members because my property has been acquired by the National NHAI.
So is this act applicable for NHAI?
Please, my lord, authority, land acquisition, it is mentioned in B, annexure, section 3B, my lord.
No. The acquisition in the present case is under what act?
Under National Highway Act, my lord. 3A.
Okay, now how is this act applicable to National Highway acquisition?
If the property is acquired under the National Highway Act, my lord, facilities has to be given under the 2013 Act, that is LERR Act.
That is rehabilitation.
Yes, please, my lord.
That is there.
That's why on this ground, my lord,
No. Rehabilitation is different from what you are seeking now. You are seeking right of way.
Right of way, it is also rehabilitation because my rights are affected. My rights are affected, my lord. Earlier, I am using the land in front of the from adjacent land.
Some authority you do research and show. Let me see.
In respect, my lord, there is a judgment also. The Supreme Court, as easementary right is concerned, the Honorable Supreme Court has also held that if the easement of necessity, my lord, it has to be given to the party. Sorry, sir. In this case, what has happened, my lord? The suit was filed before the civil court. The civil court has dismissed the suit. Subsequently, the appeal has preferred. In the appeal, my lord, they allowed the suit and stated that, my lord, easementary right has to be given to the party. And also, which has been upheld by the Honorable Supreme Court also. Para number 9 and 12, my lord. Para number 9 and 12. Please, ma'am. The High Court have considered several judgments cited before it and drew distinction between the easement of an ordinary nature in respect of which compensation could have been claimed in the land acquisition proceedings and an easement necessity like a right of passage, and held that a right of passage by way of necessity as enjoyed by the respondent plaintiff over the land Vicky Ram and now acquired by the plaintiff appellant defendant was not extinguished by reason of acquisition. The High Court relied on this observation of this made so and so judgment. Para number 12, my lord. In the peculiar facts and circumstances of the case, therefore, the distinction drawn by the High Court about non-extinguishment of the right of easement arising out of necessity appears to be justified, both in principle and precedent. In any event, we do not think that the present is fit for a case for it is necessary for us to go deeper into the larger issue of law. For we are satisfied that the judgment of the High Court under the appeal is not one which is required to be interfered with the exercise of our jurisdiction under Article 136 of the Constitution. In another judgment also, my lord, the Madras High Court has
No, but in this case, there was already a civil court proceeding regarding right of way. If you look at the facts, there was already a suit pending.
Please. But in respect of actually what has happened, my lord, in recent amendment, it cannot be challenged before the civil court in respect of acquisition of the land for the purpose of national highway is concerned.
Now the question is not of acquisition. You are claiming easementary right.
Please.
So where is that easementary right? It is to be still declared, isn't it? Where have you set up that claim of easementary right against him? Is there any adjudication? Now easementary right, you'll have to make out, establish your case for an easementary right.
Yes, please, ma'am. In respect, I have produced the photos.
How can we decide that here? How can we decide in writ proceedings your right of easementary right?
In respect, even I will file the necessary affidavit also of the adjacent owners.
That trial, we can't do it in a writ proceeding.
My lord, that
And,
clearly.
and moreover, your lordship kindly see the LERR Act in third schedule. LER Act third schedule, my lordship kindly take up third schedule. Third schedule of the Act. Before that, my lordship kindly take up section 32.
Not applicable. 32 is not applicable. You know, here. For, National Highways Act.
Provisions of infrastructural amenities in resettlement area. Lordship kindly see in every resettlement area, as defined under this Act, the collector shall ensure the provisions of all infrastructural facilities and basic minimum amenities as specified in the third schedule. Lordship kindly come to third schedule, madam.
No, but is this act applicable to NHAI acquisitions first? You let me know.
Yes, my lord. As per section 3B, it is applicable. Whatever the land acquired by the government, it is applicable. Either it is a state government or a central government.
May I submit? So far as my lord, that is well settled. Under this act, right? My apology, my lord. I didn't because nowhere in the petition or earlier also never he argued about right to fair. So I'm not carrying this book. But here, my lord, this National Highways Act earlier when this act came into effect in 2013, it was not applicable to law which are in fourth schedule. So, which includes National Highways Act. But subsequently, there was an order was issued saying that this will be applicable from 1st January 2015. So it came into effect from 1st January 2015, and that's why for this land which has been acquired from petitioner, compensation has been determined. So applicable only to the extent for determination of compensation.
So where
so,
is that? Where is
Milord, that is order was passed, 105, section 105. Lordship may see section 105, provisions of this act not to apply in certain cases or to apply with certain modifications. Lordship found it, section 105. Subject to subsection 3, the provision of this act shall not apply to the enactments relating to land acquisition specified in the 4th schedule. Now, if your Lordship look at 4th schedule, in that National Highways Act is also there. 4th schedule.
So my learned senior counsel arguing that the
No.
LER act is also not applicable.
No. What my submission is that only 4th schedule. She found it, 4th schedule. Item 7, serial number 7.
Yes.
Serial number 7 is National Highways Act 1956. So it was not applicable. But then it has come into effect, but only for, that is order. That is a right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement, removal of difficulties order 2015, which came. I mean, in this book, it is at page 163. I'm not sure there. It's a right to fair compensation and transparency in land acquisition, rehabilitation, resettlement, removal of difficulties order 2015. In that, it is made it clear that only determination of compensation will be applicable and no other provisions. So now section 24, which is the most controversial provision in this act, is not applicable. So many. Otherwise, my lord, when landowner is not satisfied with the compensation fixed by the SLO, under this act, you have to go to court. But still, under National Highways Act, you have to go to arbitrator. And still it is continued even when compensation is awarded under right to fair, because only determination is applicable. So determine under right to fair, but then you go to arbitrator to challenge that. And here, compensation was determined under this act, and that's why, my lord, 100% solatium, multiplication factor, all this. So they have got maximum compensation, my lord. My learned friend is aware.
Even
so they have got good benefits.
In respect, my lord, I'm
So
sorry.
far-
I am sorry to submit before this honorable court. They have taken rupees 1,199 ರೂಪಾಯಿ ಒಂದು ಅಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವತ್ತು 10,000 ರೂಪಾಯಿಗೆ ಒಂದು ಅಡಿ ಇದೆ.
ಇವತ್ತು, but
We can't enter into that.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳಿದ್ರು. ನಾನು ಕೊಡಕ್ಕೂ ರೆಡಿ ಇದ್ದೀನಿ, ಬೇಕಾದ್ರೆ ನನಗೆ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಲ್ಯಾಂಡ್.
My lord, so far as, my lord, excess is concerned, my lord. Now, my first question, like which I posed to myself, whether they have established that they had the inventory, right? Where they had, my lord, if we have closed their excess, my lord, then yes, we are liable to give them access. Where we have closed their access, because they didn't, if like from NH they had access, and if we have closed that by acquiring, like if their land was here, we have acquired partly portion of that survey number, and their land is here. Yes, it was our duty to give access. Here, their land is here. Where was the access? From wherever, and I have produced village map also. There is absolutely no access.
Lordship, kindly see
They
this.
were using
Sketch-
someone else's
sketch
land
produced-
to
sketch-
enter.
So that we can't decide in this proceeding. At the most, I can say you can we can make a provision. Your right to access, you can establish it, and National Highway will be bound if otherwise permissible in law.
My lord,
Have to
now
make
you
out
are
your
here for
case for access separately. In here, how we can decide such disputed questions?
My lord, we are ready to give, my lord, 8 feet
8
throughout
feet
the
is, it
boundary.
is not at all possible to move a small tractor tiller, my lord.
8 feet is
Practical difficulty, don't know.
no, tractor will move.
Other
from
side
8
advocate, you don't know the practical difficulty, my lord.
No, that's not a question. Question is how are we to determine in case of such disputes, how we can decide whether there's easementary right or not. Now the NHI is saying that earlier also you had to move through their property or you did not. You have a separate-
Someone else, I mean, someone property, and my lord, those properties are still there. We have not acquired all the properties.
Lordship,
They can still pass through
So
from
correct.
here.
So that it may not be fair this court to rely on affidavits and decide. All the neighbors must be there, and then it has to be heard and decided.
Yeah.
How we can decide easementary right in?
My lord, they can
this
still
proceeding?
use those neighbors' land, my
May
lord,
I submit?
if they want to. They still lands is available. They have the access from National Highway itself, neighbors.
I can only keep open your right to claim easementary right and leave it at.
In earlier act, my lord, there is a provision. Lordship, kindly see the schedule.
They are saying it's not applicable except for compensation.
No. That is wrong. That is wrong.
Then I'll hear you on that point.
That is wrong, my
No,
lord.
but that's what the order says.
Lordship.
Removal of difficulties order says, you repeat that what that order says, removal of difficulties.
Yes. And so at the most, they say, as your lordship rightly said, for rehabilitation, compensation.
Just read that.
Yes, my lord. Right to fair compensation and transparency in land acquisition, rehabilitation, resettlement, removal of difficulties order 2015, page 163. This notification. Whereas the right to fair compensation and transparency in land acquisition, rehabilitation, so and so came into effect 1st January 2014. So main act came into effect on 1st January 2014. And whereas subsection 3 of section 105, which I just read it out, right to fair act provided for issuing of notification to make the provision of the act relating to the determination of the compensation, rehabilitation and resettlement applicable to cases of land acquisition under the enactment specified in the 4th schedule to the right to fair act. And whereas the notification envisaged under subsection 3 of section 105 of the act was not issued, and the said amendment ordinance 2014 was promulgated on 31st December 2014, thereby inter alia amending section 105 of the right to fair act to extend the provisions of that relating to the determination of the compensation and rehabilitation and resettlement to cases of land acquisition under the enactment specified in the 4th schedule. So there was an ordinance that whereby 4th schedule act which are listed in 4th schedule, this determination of compensation and rehabilitation where applicable for acquisition under the estate is applicable. And whereas the right to fair amended ordinance, because ordinance expired, another ordinance was issued, and then they missed out issuing, by promulgated act thereby. So this order came. And whereas the right to fair amendment ordinance 2015 was promulgated on 30th May 2015 to give continuity to the provisions of the right to fair amended ordinance 2015. And whereas the replacement bill relating to the right to fair ordinance 2015 was referred to the joint committee of the House for examination and report, and the same is pending with the joint committee. And as per the provisions of Article 123 of Constitution, the right to fair amendment second ordinance 2015, ordinance number 5 of 2015 shall lapse on 31st August 2015, and thereby placing the landowners at the disadvantageous position, resulting in denial of the benefits of enhanced compensation and rehabilitation and resettlement to the cases of land acquisition under 13 Acts specified in the 4th schedule to the right to fair act as extended to the landowners under the said ordinance. And whereas the central government considers it necessary to extend the benefits available to the landowner under right to fair act to similarly place landowners whose lands are acquired under the 13 enactment specified in the 4th schedule, and accordingly the central government, keeping in view the aforesaid difficulty, has decided to extend the beneficial advantage to the landowners and uniformly apply the beneficial provision of the right to fair act relating to the determination of compensation and rehabilitation and resettlement as were made applicable to cases of land acquisition under the said enactment in the interest of the landowner.
Only
Never
rehabilitation.
stated section 3 of the act is not applicable, and also schedule 1 is not also.
It only says rehabilitation, resettlement and compensation. You do some research. If there's any case law, you come ready. I'll put on that.
Please,
before entering into the merits.
Please.
Lord, we have difficulty.
Correct. I'm
Lord.
giving immediately. I'll have it on Friday. Or we'll have it on 15th.
15th out of session.
15th.
After 17th.
Friday, my lord.
After
Friday.
17th.
My lord, Friday, my lord. Maybe kept on Friday, my lord.
From 11th
Friday.
to 11th to 17th, I am out of session.
Okay, Friday you take a chance.
Friday.
Relist
My lord, freshly. My lord.
10th in the same stage.
Interim order.
This
Now,
fresh.
yes,
First.
interim order in operation is extended till the next day. Now, unless you point out that this act is applicable, we cannot enter into it. One. Two, they are giving 8 feet. It may not be sufficient. No, that's a different matter. But you can't compel them to give anything more than that.
Milord,
Once land is acquired, unless you establish an easementary right, which is enforceable on the National Highways Authority, in this proceeding, I can't decide.
Milord, this is Milord, we have paid compensation to them under
I'm
right
ready
to
to.
sell. And that land, we are now giving them free of cost.
99 ರೂಪಾಯಿ ಕೊಟ್ಬಿಟ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
That question is not
10,000 ರೂಪಾಯಿ ಇದೆ ಒಂದು.
that we can't decide that
They
now.
can challenge,
Lordship kindly
they
see.
can approach arbitration.
Lordship kindly see.
That question cannot be reopened.
And Milord, my just,
And
I
you
have,
are- you-
Milord, I have just one submission. Milord, that land is here. So if we leave 8 feet and if they feel, I mean, as per our Milord, I mean, officer of NHI, that is sufficient. But still, because they are agriculturist, it's not like the big ones are coming there. But still, Milord, if they still feel, that is not sufficient. Because today my learned friend was telling, no, then we need 4 feet for drainage. Everything NHA will give, drainage also NHA will give. So now, whatever they want, if they want 20 feet, let them use 20 feet. But 8 feet we will give, and there they have their own land. They may use, here this side someone has done that. So they may also spend,
Land survey manual, it clearly says that cattle track road is required 7 feet road.
Yeah, there may be
7 meter road.
There may be a necessity. I'm not disputing that.
Please.
But you have no legal right against them unless you establish an easementary right. That easementary right I can't decide in this proceeding.
That is one
But to
aspect, madam.
go before the civil court.
That
it's
is
up
one
to you
aspect,
to-
my lord. Before approving the plan, my lord, they have not raised any objections from the publics because
But
it is
that- you have
and
not
moreover, my lord,
You have not challenged the acquisition, so we can't go
yes,
back.
can't go into it.
Now land is acquired. It belongs to them. If you are claiming any right of way, you can't claim under rehabilitation. You have accepted compensation, there ends the matter. For right of way, you have to make a easementary right, and that we can't decide in this proceeding.
as per my Town and Country Planning Act, my lord, section 17, my lord, if the land is converted, then the road access has to be given in view of the Karnataka Town and
You have
Country Planning
challenged-
Act also.
You should have challenged the acquisition and not accepted compensation. If that were to be so, it's a different matter. Now, having accepted compensation, though you may have a genuine difficulty, we don't dispute, but not against, not in this remedy. You'll have to seek for easementary right separately. That is kept open. You establish if NHA is a defendant and they suffer a decree, they have to bear it.
For the benefit of the NHA, my lord, I have filed the writ petition. If I file the suit before the court, my lord, it will take 10 to 15 years.
No, correct. But we
Now
can't,
also
For
it's
the
a
benefit of the
2020
NHA, my lord.
you can't stop.
2023 ex parte order is taken and
No,
then
you
we
can't
are
stop.
suffering, my lord.
You can't stop NHA once you have your land is acquired, validity of
Milord, just
notification,
Milord, for
notification is upheld. You have no legal right. Your legal right is for easement. That is not before this court.
Milord,
That you
that
decide. Either 8 feet you take, keep open your other rights.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ 10 ಫೀಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಇವತ್ತಲ್ಲ ಮತ್ತೆ ಚೇಂಜ್ 8 ಮೀಟರ್ 8 ಅಡಿ ಕೇಳಿದ್ರೆ ಕೋರ್ಟ್ನವ್ರು 10 ಮಾಡ್ತಾರೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಇವತ್ತು 8 ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ 10 ಅಂತ ಹೇಳಿದ್ದಾರೆ
Are you ready to accept 10? Then I'll ask.
ಲಾರ್ಡ್ಶಿಪ್
That's a stand that you have to take.
at least 18 feet ಮಲಾಡ then
Let us see. You make out your right, we'll see.
18 feet ಆದ್ರೆ ಗಾಡಿ ಟರ್ನ್ ಆಗಬೇಕಾದ್ರೂ ಬೇಕಾಗುತ್ತೆ
You may require that, but you have no legal right. I
and
can't enforce.
even if they left the road
Milord,
my
our
lord,
Milord,
it is the government it
house
is
gate is
the
also not-
property of the national highway, it is not ours my lord.
Milord, our house gate is also not 8 feet width, Milord. Having.
No, I
8
can't-
ಅಡಿ ಇಷ್ಟ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಏನು
I cannot, no, you may want that relief, but legally we can't enforce it against NHA.
at least 18 feet 18 feet ಕೊಟ್ರೆ ನಾವು ಗಾಡಿಗಾರ ಟರ್ನ್ ಮಾಡ್ಕೊಳಕ್ಕಾಗತ್ತೆ
That legal right you don't have against them. If they are giving 8 feet, it's up to them. They are not obliged to give.
8 feet
unless
also
you
they are coming
establish a
with
right.
some, I mean, reason that what can go, like na pass by.
I leave
So
it at
vehicles
that.
can pass by.
I leave it at that.
Tractor
You make
and
out,
everything
you
can
make
pass.
out your case, I'll rule on that. It may be a genuine request, I don't dispute, but legally you can't enforce it against NHA.
even article 300 A of the constitution also gives a
How
right
they can
Land
now
you-
seek,
Just one. Now you have, once land is acquired, you lose all your rights.
yes
You have accepted compensation.
I am not disputing my lord.
You have to file a suit for seeking right of easement, let that be decided, there ends the matter. But you can't obstruct them from using the property.
No, I am not obstructing, my lord. Just
They are.
I am
They
requesting.
are.
Just
It
I am
cannot
not request. I am not
That is
obstructing.
a stay, and how he's saying, my
I am
learned friend, that
requesting
he is not
extension of road.
That cannot
That's
be
all.
done. That cannot be done unless you show a legal right. List on 10th.
Milord,
Yes.
now, Milord, wayside amenities have been, Milord, envisaged, but Milord, which is for benefit of commuters. But now, Milord, we are not able to provide that.
10th will see.
And moreover, my lord, this land has given to lease to private person for the rent of 55 lakh per month.
All that is of no relevance. All that is of no relevance. Yes.
Item 20 was continuing, Milords.
43. Serial number 43. Ravindra. Nagaya. Please.
Not this. You find in the server.
Have you informed the other side?
We have, my lords. I called him up in the morning and I have informed him.
We'll relist it tomorrow in the fresh matters list.
2:30 minutes so that you will know. Matter will reach.
2:30 morning session. Morning session. List serial number 43 in the fresh matters list tomorrow. Yes.
This one, serial number 20.
Yes, Milords. Well, I'll keep it short now. As we have discussed internally, Lordships may remand the matter in light of the Delhi High Court without going into the question of jurisdiction. The only Milords, request I have before your Lordships is that in terms of the Delhi High Court order, they may provide me invoice-wise details so that I can be confronted with invoice-wise details. As Delhi High Court has said, I can show that. 20.
No, so now the DRP order will be set aside. EO order of the assessing the assessment order would be set aside, and then the matter remanded for fresh consideration.
Without going into the question of jurisdiction, that issue can be kept open because that is pending across the country.
May be kept open, Milord. A draft assessment order has to be redone.
Yes, but maybe the assessment order can be redone. We don't need the opportunity to go again before the draft order, then come back to the assessment order. Perhaps the assessment order can be set aside and they can give me invoice-wise details of bill of entries for me to be confronted with. The Delhi High Court specifically says so at page 319.
No, annexure, now what is in challenge is
Annexure 1, which is the assessment order.
Annexure A.
Yes, annexure A can be set aside.
The annexure A is set aside and matter remitted for fresh consideration. That's what you're saying, isn't it?
Yes.
Annexure A and J has to be set aside.
A is enough. You don't need to set aside DRP also.
If they are only assessment order, Milord, let the DRP order may be retained, Milord.
Yes, without going into the question of jurisdiction.
How can the DRP order be retained?
Your Lordship, no, they are making submission, Milord.
No, I am only saying that Lordships are not going into the question of jurisdiction. So since the only question that remains is natural justice, therefore the AO may give me an opportunity, because otherwise the DRP will have to first give me an opportunity, then the AO will have to give me an opportunity. So whichever, today if your Lordships said, your Lordships are not going into the jurisdiction issue anyway. So therefore, if it's a natural justice issue, then the AO can give me an opportunity and I can respond to it once he shows me the invoice-wise data.
No, correct. I'm not familiar with procedure. I'm just asking.
Yes, if the assessment order is set aside without going to the question of jurisdiction, only on natural justice, that should be sufficient.
Correct. But annexure J cannot stand on its own.
Yes, Milord. It cannot stand.
All right, may set aside both for only natural justice, your Lordship may set aside both of them. That's also okay.
Yes. petitioner has sought for setting aside the order under 143(3) read with 144C,
Yes.
13 read with 144B of the Income Tax Act at annexure A for the passed for the assessment year 22-23 on the premise that there has been violation of principles of natural justice. Petitioner has also sought for setting aside of the dispute resolution professional
This
direction.
we are not pressing now, Manoj, because your lordships are not going to. We are not pressing the DRP issue.
At annexure J. Full stop. At the outset, and, on behalf of the petitioners, submitted that they are not pressing the relief as regards
Annexure J.
Roman 2.
Yeah.
Full stop. The relevant facts are that the assessment order was passed on 29/1/2026, which order entailed procedure of passing of
But the order has made an addition without confronting me with the material.
it is to
Page
be noticed,
129.
That in terms of the directions of the DRP at annexure J, operative portion of J is at page.
Well, it's, J is at 277. 16.1 direction of the DRP.
The DRP had directed the EO and the SSC to reconcile the differences. Full stop. Insofar as annexure J is concerned, it is noticed that annexure J is a process whereby the draft assessment order is subject to directions by the dispute resolution professional at the instance of the SSC
panel.
Insofar as the power of the DRP to issue directions as per annexure J, it is pointed out that the DRP could not have issued directions contrary to
Well, we are not pressing this
C12.
Well, we are not pressing this issue.
So what happens to the DRP order? What
DRP
happens
order will remain same.
DRP order will remain. The assessment order can be set aside simply on the ground of natural justice.
Is that we are only challenging assessment, final assessment order.
Only on the ground of natural justice.
Of natural justice, they want one more opportunity and available material, whatever I should share with them.
So we leave it J as it is.
No, not as it is, Malak. They'll have to give me the invoice-wise details as per the judgment of the Delhi High Court at page 317. They will have to confront me with invoice-wise details of the bills of entry.
So far as the assessment order, definitely I'm giving directions.
Yes,
I want to know insofar as J. So we leave J undisturbed.
We leave J undisturbed. Grateful.
Though various contentions have been raised regarding the validity of annexure J, however, at the time of hearing of the matter, on behalf of the petitioner, it is stated that they do not wish to press their relief at Roman 2 insofar as the directions at annexure J. Full stop. Accordingly, the court refrains from entering into any adjudication as regards the direction at annexure J. Next. Insofar as the assessment order is concerned, it is pointed out that the order suffers from violation of principles of natural justice insofar as
But the Delhi High Court judgment is a 319. 317
insofar as it is
Your Lordship, data collected from CBIC, whatever available data we will share.
No. The Delhi High Court squarely
as
says it's confront invoice-wise data.
just 1 minute.
Yes.
Insofar as it is contended that the assessing officer has relied on incomplete CBIC data
Grateful.
as well as the data obtained from CBIC was not confronted to the SSC.
And plus entry-wise data. So each bill of entry, he has to show me which import is he talking about. Contention, which import are you talking about for me to reply? They have given me a month-wise data. That must be the
data. Entry-wise import details were
Yes.
not shared with the SSC to enable him to make out his case before the assessing officer. Reliance is placed on the, in support of such contention, reliance is placed on the observations in the order in original at paragraph
order in assessment order.
Assessment order.
Yeah, assessment order. Assessment order at 138. Paragraph is just what? Paragraph small b. 138, page 138, paragraph small b. Internal page is 683 of 85 of the assessment order. 138. It doesn't actually list out para-wise. It says small Roman b.
8.3.3 small b. 8.3.3
yes.
small b.
Yes.
Full stop. Insofar as such contention, it is pointed out that the authority has, though referred to data from the CBIC, the SSC had specifically raised issue by also making a submission that SSC had applied to the jurisdictional custom officer to issue monthly wise certificate relating to import purchase, which was not obtained at the relevant point of time when the assessment proceedings were on. Full stop. The assessing officer does remark that the CBIC complete invoice-wise data could not be retrieved despite efforts by the department. Full stop. The authority also observes that there was no complete data before it when completing the adjudication proceedings. Full stop. Observations at para B are extracted as below. Next. It is the case of the petitioners that when the assessing of authority itself did not have complete invoice-wise CBIC data as is made out from the observation at para B extracted above, and in the absence of entry-wise import details not being shared with the petitioner, the authority ought not to have completed adjudication proceedings. Full stop. Needless to state, the information available with the authority ought to have been shared with the petitioner.
Your Lordship, one submission. I'm sorry.
Further, just wait. Then you.
I'm sorry.
Further, if there was any lack of data, authority may have had to wait till complete data was obtained by it at its instance as noticed. Next. However, learned counsel Sanmati appearing for the revenue would contest and submit that.
Your Lordship, in page number 129, para 8.3.2.
120?
129, para 8.3.2.
Yes.
Your Lordship, consequently, notice in the section 142.1 dated 2/1/26 was issued to the assessee, whereby the CBIC data was provided through Excel sheet for reconciliation purpose. Whatever data we had shared, my lord. Now the remaining data which were not there, for that one, the assessing, my lord, at page number 138 had approached the CBIC and had tried to get the information, my lord. The same could not be produced by him because it was not made available at that point of time. Now your Lordship may direct that if the available data, if you have secured it, he can also produce it before the AO.
No, 1 second. Mulad, the Delhi High Court clearly says
just
the onus is on the department.
Page number 138.
Just wait. In the learned counsel, Sanmati submits that whatever information was available was put forward by way of an Excel sheet to the petitioner, and other material, though efforts were made, were not available. Next. However, it must be noticed that when an authority relies on certain information to complete the adjudication on a certain issue, it is necessary that all information available with the department ought to be shared with the petitioner at the first instance. Next, insofar as information which is incomplete or not available, there cannot be any presumption adverse to the interests of the petitioner. The authority can rely on only such information as is available in its custody, which is shared. If there is any other material that is incomplete, unless other information is obtained to make such information complete, same cannot be used by the department.
Very grateful.
Next, while keeping open,
We have received other information, my lord.
you can. I'll reserve it. Accordingly, in light of the above, the order at annexure A is set aside. Matter is remitted to the stage of
passing the assessment order.
Passing the final assessment order, my lord.
Stage of passing of the final assessment order. Full stop.
And after hearing the
however, it is made clear that in light of the assertion of the petitioner regarding violation of principles of natural justice, as observed above, the authority to proceed for adjudication after sharing information in their custody with the petitioner. Needless to state, if there's any additional information that has come into the hands of the revenue or the petitioner, same may be subjected to being included in the proceeding after being tested by way of opportunity to the other side. All contentions on
Great.
merits kept open.
This is exactly what the Delhi High Court has said, that invoice-wise data, without invoice-wise data, I cannot possibly reply.
Final assessment order only, my lord, because it should not amount to say that they should not say that
It's
again.
clarified that the final assessment order at annexure
And next year, A, my lord.
A set aside subject to the above directions.
Grateful. Very
And
grateful.
he has to pass fresh final assessment order.
Yes,
Because they should not say that one more draft should be there.
Authority could then proceed to pass a final assessment order.
Yes. Grateful. Grateful.
Yes.
21, Ravindra.
It's okay for the petitioners.
Lords, in this matter, my lords, two aspects, my lords. One is the order passed under section 73, and one more is the benefit of availment of 128A, my lords. My lords, insofar as the adjudication order which is passed at annexure A, my lords, at page 27, my lords. My lords, the order is dated 25/1/2024, my lords. My lord, the act prescribes that the order ought to have been passed within 3 years, my lords.
Under section
73, my lords. (73:10), my lords.
Yes.
My lords, further, my lords, in this adjudication order,
I just point out 73:10. Read.
my lords, the proper officer shall issue the order under subsection 9 within 3 years from the due date of furnishing of annual return for the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relates to or within 3 years from the date of erroneous refund.
So 3 years from?
My lords, in this case, my lords, this would be from the due date of furnishing annual return, my lords.
So what is the due date?
My lords, the due date would extinguish.
Which year? This is which year?
My lords, this is of the assessment year 2019-20.
Correct. So what is the due date?
My lords, the limitation would expire on 31/12/2023.
31/12/23.
23, my lords.
Now the order is passed on
25/1/2024.
So you're saying it's time barred.
My lords,
in the sense, order is passed beyond the period stipulated.
Please, my lords. Further, my lords, at the same page, my lords, at page 27, there's a mention about issuance of show cause notice, my lords. At references serial number 3, my lords. Show cause notice is dated 21/11/2023, my lords.
Yes.
My lords, as per 73(2) of the Act, my lord, it prescribes that show cause notice ought to have been issued 3 months prior to the expiry of the limitation, my lords. 73(2), my lords, if I may read out, my lords.
Yes.
The proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of the order.
The 3 months prior to
expiry of the limitation, my lords.
31/12/23.
Please, my lords. That would expire on 39/2023, my lords. Our show cause notice is issued on 18/11/2023, my lords. My lords, now in this particular case, what happens is, way before the show cause notice is issued, tax came to be paid, my lords. Thereafter, my lords, because of the policy change and introduction of 128A, they ought to have waived off the penalty and interest, my lords, which is not done since we have not filed an application, my lords. My lords, now what is outstanding is the interest and penalty, my lords. That may be waived off, my lords, considering that the order is not valid, my lords.
No, but then
Please, the show cause notice has to be issued within 3 years. The order has to be passed within 3 years from the date of filing of return. When they have filed the return, they have not stated so in the petition. No such averment has been made in the grounds, my lords, with regard to this order being barred by limitation or the show cause notice being barred by limitation. It is only for the first time now it is canvassed here. All the relief that they seek is, my lords, that there should be waiver of interest and penalty under section 128A on the ground that the taxes have been paid. On the last occasion, my lords, itself I demonstrated. My lords may kindly turn to page 30, my lords.
No, but now you have not raised those contentions.
Nothing.
My lords, they've taken up that contention, my lords, that they have not followed the procedural aspects in section 73, my lords, which is the ground available.
You have to be specific. If you are raising which
34, my lords. At
para?
page 22, para 34, my lords.
No, this is too vague. If you want to press that, then you raise it. It appears prima facie you have a case, but you have to raise it.
Nothing. There is no amendment in the petition also. It is only an afterthought. After the matter was listed last occasion, which I demonstrated before the court that they have not paid the taxes. And then an argument was taken up saying that the interest penalty has been wrongly calculated. That also I showed to my lords that it is correct. 10% of the tax amount that is
You
due.
see, you want to make any amendment, I'll adjourn.
And my lords, they want the benefit of 128A without even following the procedure that is prescribed under 128A. They don't even want to file the application.
My lords, due to some ill
And they
advice,
expect
my
me to
lords.
go and give them the relief of waiver of interest and penalty.
My lords, the reason why I'm pointing out this is, my lords,
No, correct. I'm
only
saying
for the reason that I have not filed the application, my lord.
correct. That's one
But
part.
for issuance of a show cause notice, my lords, time was extended till November. And for passing of an order of assessment, my lords, the time was extended till February. That I'll be able to demonstrate by way of notifications, if that is the argument that is taken. And if on that ground, my lords, if I succeed, my lords will have to dismiss the writ petition without getting into any other thing. Because prima facie, even on the last occasion, my lords, incorrect statements are being made. My lords, may kindly for a moment, turn to page 30, my lords.
No, now you decide. You want to amend and make out a better case, it's up to you. You want to argue on this, we'll see.
My lords, please, my lords, I'll file a necessary application for amendment of the grounds.
And after 2 years, they're before this court, my lords.
At request.
25th of January 2024.
My lords, in the meantime, there might be stay of the proceedings.
No, how is it? You make some deposit, we'll ask them to stay. Now, if under 128A, you're required to follow a procedure.
The entire taxes has to be paid. That is before March 2025.
So that all there, according to the revenue, you have not paid that much also. Now you pay at least the entire tax, we'll see.
My lords, tax has been paid, my lords.
No, that's it.
My lords, I will produce, my lords, the
Revenue is disputing your calculation.
My lords,
I am going by the order that is here, my lords. The observations made in the adjudication order. Page 30 and 31, my lords, may kindly say.
No, this you sort it out with them. I'll have it next week. You find out and you share whatever information you have insofar as you having paid taxes. Let them verify it.
Please.
Relist the matter in the same stage on 21st.
Please.
22. Partha yes.
Literally due with you. See here itself.
Tax is paid, interest penalty is pending. That's our contention.
When have you paid this?
Tax is paid way before the order was passed. It's mentioned in the order.
Partha
See, sir, here in the last
I'm appearing for the petition, Your
page
Lordship.
of the order.
The petition is the charitable trust, Your Lordship, claimed exemption under section 11, Your Lordship.
Tax or balance tax.
Then subsequently, intimation has been issued under section 143(1) by denying the exemption under section 11, and Your Lordship, without providing any opportunity, even intimating the petitioner, Your Lordship, they have denied the exempted amount and taken into consideration the entire gross receipt as a tax liability, which I'm challenging before Your Lordship.
Yes, Arvind.
My lord, in this matter, there is no registration as per 12A, my lord, for this particular assessment year, where there is a denial of the income which was claimed under exemption, my lord.
It's not one time, is it?
My lord, it's not. Every year there should be a registration, my lord. And either it has to be renewed or they have to apply for the registration provisional and make it a final registration, my lord. Now, as per this, your lordship can see page 3, in page 5 of the petition, my lord.
Para?
Para 3, my lord. 4 lines. The first respondent has issued the intimation under section 143(1) of the Act 23/12/2025, wherein the exemption under section 11 has claimed by the assessee has been denied with observation. However, as per the data available, no registration has been granted. My lord, if the registration is not granted or if they have not applied, my lord, the CPC or the assessing officer are duty bound to reject it, my lord. It is a mandate, my lord. There is no question of giving opportunity or anything. They should have applied. Let them produce the registration, my lord, that they had valid registration for this particular assessment year. Then we can ask the CPC to relook it into.
May I submit, Your Lordship? Lordship, the registration for this particular year got expired and we have filed the registration, Your Lordship, filed the application, Your Lordship, by Annexure A, Your Lordship, page 19. By the order of this Honorable High Court, Your Lordship, which is still pending before CIT exemption to grant the registration. But still otherwise, Your Lordship, by 143(1), Your Lordship, if any slightest adjustment also has to be made, it has to be intimated to the petitioner. Page 8, Your Lordship, of my petition, I have extracted the provision, Your Lordship. Page 8. The provision of 143(1). Shall I read? Where a return has been made under section 139 or in response to a notice under section 1 of 142, such return shall be processed in the following manner, namely, the total income or loss shall be computed after making the following adjustment, namely, any arithmetical error in the return, an incorrect claim, if such incorrect claim is apparent from any information in the return, any such inconsistency in the return with respect to the information in the return of any proceeding.
This is relevant, correct.
But provided, the provisional radiology, provided that no such as adjustment shall be made unless an intimation is given to the assessee of such as adjustment either in writing or in electronic mode, which was not provided to the petitioner, Your Lordship.
Correct, but now what if the opportunity is given? What are
Opportunity
you
was
even
not-
if the opportunity is given.
What are you going to demonstrate now if opportunity is given?
Lordship, the application of registration 12 is still pending before the CIT exemption, Your Lordship.
Correct, till it's granted, how you can claim exemption?
No, even otherwise, Your Lordship, that 143(1), if at all they have to deny my exemption, either they have to pass 143 order, 143(3) order, or they have to give me the opportunity to demonstrate. This 143 intimation, Your Lordship, they can't make the adjustment. Few times back, Your Lordship had heard the same matter, Your Lordship. Excuse me. Excuse me.
Could it? No, 143(1) is only an intimation.
Only
But it's
intimation.
intimation, my lord. My lord, even in this matter, department has already filed a vacating IA and objections, my lord.
Let
That
them
we
file.
are moving, my lord, because here the registration itself is not there, my lord. They have obtained a stay, my lord. Now I have filed and I will be moving the matter, my lord.
Let
My
me
lord,
file objection.
my lord, I have filed objections also. My lord, now only thing is that, my lord, can a assing officer or CPC, can they give a exemption when they don't have a registration itself, my lord? Forget we inquiring, scrutinizing whether the income is exempted or not. They don't have registration itself.
Then let
My
them
lord,
pass 143
lord,
order.
My lord, my learned friend is referring to Annexure A is in respect of the same assessee, where your lordship have remanded the matter to be considered by the CIT exemptions. That is for the assessment year 2021, 22 to 23, 24, my lord. This is 24, 25. For this, they have never filed application. If they have filed, let them show it, my lord.
Lordship.
If it is spent.
Now just tell me the facts. What has happened?
My lord, here they have filed return, my lord.
Yes.
Claiming exemption, seeking that it's a education institutable. They are exempted under section 11, my lord. For claiming exemptions, my lord, they have to have a registration certificate, my lord. That we are partaking. We are under the section 11 and 12. I have applied for 12-year registration. That registration is there, either provisional or final, my lord. In this petition, my lord, for this particular assessment year, they have not even demonstrated that they have even filed that registration application, where they have provisional registration at least to be considered.
No, that exemption claimed was
Under
was
section
turned
11.
down.
Oh, yes, my lord. Under section 11, 12 is very clear, my lord. Until they have filed, until they have registration certificate, my lord, their income cannot be considered, my lord.
Even otherwise, may I submit, Your Lordship?
Is there an assessment order or?
This is the intimation, my lord. It is automatic intimation. At the moment returns are filed, the CPC processes, my lord. It's automatic processing. If they have uploaded the registration certificate, my lord, automatically they will get the exemption, my lord. If there is some variation, then the matter will be sent to the jurisdictional assessing officer. He will partake scrutiny, my lord.
Correct, but under 143(1),
Please, my
at all there is, it's only for clerical or arithmetical mistakes.
Please, my lord.
Huh?
Please.
Incorrect claim also it can be considered 143.
If such incorrect claim is apparent from the information in the return.
No, correct. Now you don't have.
Lordship, even otherwise, your lordship, this intimation has been issued, your lordship, by taking the gross receipt of the whole amount, your lordship, for computing the tax liability. Page 60, your lordship, of my application.
My lord, may I make one submission, my lord? Even this honorable court, my lord, now remands back to the CPC, my lord, for reconsideration. What is the assessee is going to prove when the petitioner does not have 12-year certificate, my lord?
No, but they're saying
That
that
is on us.
the quantum.
Let them show it here, my lord. Lordship may have it tomorrow. Let them
This
let them
140
produce the certificate, my lord.
Lordship,
They're saying some
143(1).
quantum, there is some.
Lordship, if at all they are going to deny the exemption, your lordship, let them pass 143(3) order, your lordship. 143(1) order yet only is an intimation.
Lordship,
And that too for
kindly
an
go to
arithmetical
Annexure C.
adjustment.
Annexure C, page 55.
143(1). Your lordship, 143(1), your lordship is having, my lord, 143(1)(a). Roman 1 is in respect of any arithmetical error.
Just read.
Your lordship, 143, my lord, assessment. 1, my lord, where a return has been made under section 139 or in response to a notice under subsection 1 of section 142, such return shall be processed in the following manner, namely, A, the total income or loss shall be computed after making the following adjustments, namely, any arithmetical error in the return. An incorrect claim, if such incorrect claim is apparent from any information in the return. And disallowance of loss claimed if the return of the previous year for which set off of loss is claimed was furnished beyond the due date specified under subsection 1 of section 139. Disallowance of expenditure, disallowance of deduction claimed. The addition.
So you are saying under B 2, Roman 2.
Yeah, 2, my lord. 2, 3, 4, 5, 6, my lord. There are all, these are all the instances where the 143(1) can be dealt with, my lord. So it is an order. Your lordship may kindly see, this is
The
143.
proviso also can be read, your
Your
lordship.
lordship, this is 143(1) with effect from Finance Act 2008. Prior to 2008, my lord, there was, all these provisions were not there. In the Supreme Court judgment in Rajesh Javeri, my lord, it was prior to amendment. This is after amendment, my lord. This amendment will give scope of 143(1) where all these disallowances can be made.
I agree, your lordship. Provided the proviso also can be read, your lordship.
The proviso.
Proviso to that 140 beyond after 6, not after Roman 6, provided that no such adjustment shall be made unless an intimation is given to the assessee of such adjustment either in writing or in electronic mode.
So now they're claiming that there is no doubt they don't have, according to you, they don't have an exemption for the relevant year. But you redo it after giving an opportunity.
My lord, this itself is an intimation under section 143(1). If your lordship sees at page 57, my lord.
No, but the proviso says that now after they file the return, according to you, you are disallowing their claim because they don't have an exemption.
Please,
now when you're disallowing that exemption, which is wrongly claimed according to you, under the proviso you can give a notice and then close.
Your lordship, since CPC is a computerized mechanical, my lord, your lordship can direct the concerned assessing authority of the assessing, my lord, to go before him and give all the details, whatever submissions they want to make.
If your lordship sees at page 57, my lord, this is the intimation, my lord, under 140 annexure C.
No, so they are saying in the intimation they have already disallowed the exemption.
Yes, please, my lord, it is like this, my lord. If your lordship sees the annexure C as provided by the taxpayer as computed under section 143(1), my lord.
Correct. So
the moment it comes to the exemption under section 11(10)(23)(c), automatically, my lord, page 55, my lord, annexure C.
This is in response to their
returns, my
return.
Returns.
So correct. So
my lord, now if you see page 56, my lord, there serial number 1, 2, 3, and on the right hand side it is as provided by the taxpayer as computed by the this thing under section 143(1).
Yes.
Over the page, my lord.
Yes.
57 at serial number 6, my lord. Exemption they have claimed, my lord.
Yes, yes.
And they have quoted the amount, my lord. 48 crores 98 lakhs 59,566.
Now only this much is.
Now the moment what happens, my lord? The moment this amount is quoted, my lord, in the returns, the CPC automatically verifies whether they have uploaded the registration certificate, my lord. When the registration certificate is not there, automatically the amount will be zero, my lord. It is not an arithmetic error or some wrong claim of exemptions or something. It is nothing but they have never filed the registration. If it was wrong claim of registration, my lord, CPC would have issued them a intimation, or the matter would have been selected for scrutiny and it would have been transferred to the regular assessment assessing officer, my lord. Here the moment is that, my lord, they should file along with their returns the 12-way registration certificate, my lord.
Now, except for this exemption which you have disallowed,
yes, ma'am,
you have not made any adjustment.
Nothing, my lord. It is automatically disallowed.
No, your lordship.
And then subsequently, my lord.
Yes.
At next page, my lord, page 58, serial number 9, my lord. Just next page.
Yes.
Gross income after exemptions, my lord. 67 crores 94 lakhs 82,881, my lord.
You added.
Added, my lord. Yes, my lord.
Okay, so except this, there is no other adjustment.
May I submit, your lordship?
Just.
My lord, there are other interest and other adjustments, my lord. Subsequent
Lordship,
page
yes.
59 and 60.
Correct. So can we not remit it back?
My lord, all I would seek is, my lord, I'll just take my instructions by the CPC, my lord. Lordship may have it next week, my lord.
Because they
I'll say
cannot review it.
because CPC, the problem is that, my lord, once the intimation is passed, my lord, either the option is for under section 154 rectification. Here the rectification provision will not come because there is nothing mistake apparent from record, or whether the jurisdictional officer can rectify this, my lord.
Or
So
they can file an appeal to 46A.
There is a provision for appellate authority also.
Correct. But the proviso says before you make an adjustment,
Some opportunity has to be granted, but since it's a computerized order, my lord, it cannot be done practically. But therefore, your lordship can direct the concerned assessing officer to verify all this and give a report to the CPC, my lord.
You find out.
I'll find out.
Lordship, one more thing, your lordship. They have taken the gross receipts, your lordship, as a tax liability, your lordship. Page 56, your lordship. Page 56, they have taken 28 crores 63 lakhs 24,000, your lordship, as a tax liability. Whereas in page 60, your lordship,
50.
Page 56.
Yes.
56, they have taken tax liability of 28 crores 63 lakhs 24,053.
Yes.
03, column 0, serial number 03. Whereas in page 60, your lordship, the gross tax liability is 28 lakhs. Even the tax relief income tax liability also is 28 lakhs. Page 60, your lordship, serial number 6 and 7.
Net tax liability.
Yes, your lordship. They have taken my gross receipt as the tax liability. That is also error, which I am also challenging.
Let us see. Just verify.
I'll verify.
Delist the matter.
In the meantime, it can be stayed, your lordship, annexure C and D, because recovery proceeding has already been initiated.
Delist the matter in the same stage on.
Next week.
My lord, 15th, my lord. 15th or 21st, my lord.
21st. Respondent not to
Or
take
22nd, my lord.
22nd. Respondent not to take any steps for recovery till the next date. List in the same stage.
Annexure C and D, your lordship.
I've stated
Much
no.
obliged.
Serial number 24, Pradyumna.
I appear online, Your Worship.
Yes.
Worship, there was a show cause notice demanding around 25 lakhs from me. And Your Lordship, I filed my reply to the show cause notice, which is as page number 37 of the petition, Lordship. Lordship, may kindly see page number 37. There's a clear acknowledgement also, Lordship, dated acknowledgement. It was acknowledged on 7th February 2025.
The water, yes.
An order has been passed, Your Lordship, holding that I have not filed any reply. It is on page number 27, Your Lordship, bottom para.
Page?
Page number 27, Your Lordship.
Paragraph?
Paragraph 6, Your Lordship, where it says, I have carefully gone through the records of the case and the allegations made in the show cause note DRC1. I find that the taxpayer has not furnished any written reply to the show cause notice, and also none were appeared for the personal hearing.
Page.
Page number 27, Your Lordship.
27.
27.
47 is some.
27.
The last para, Your Lordship, para number 6. So where it is held that I have not filed a reply, whereas the fact of the matter is that I have filed a reply, Your Lordship, which is clearly acknowledged, which is at page number 57.
First time, is it?
Please.
Yes, Akash.
Please, my lords. It's coming for the first time, my lords. They have filed the reply, but however, in the order, the finding shows that they have not filed any reply.
Shall we remit it back?
It can be remitted back, Your Lordship.
You have to wait till he says. The petitioner has challenged the order in original dated 27/2/2025 at annexure A. Full stop. The order in original has is an ex parte order, as is made out from the observations at para 6. Full stop. It is the case of the petitioner that reply was made to the show cause notice, as is evidenced from annexure D. Full stop. Annexure D is a reply to show cause notice, which is duly acknowledged of having been filed on 7th February 2025.
Please.
The order, the ex parte order at annexure A is passed on 27/2/2025. Accordingly, it is submitted that the authority has grossly erred in proceeding ex parte without taking notice of the reply at annexure D. Next. In light of next, peruse the order at annexure C. Findings at para 6 does indicate that the authority has placed the petitioner ex parte and concluded adjudication. The authority has recorded a finding that the petitioner has not furnished any written reply to the show cause notice, nor appeared to avail of opportunity of personal hearing. However, annexure D refers to a reply made, which is duly acknowledged by the Office of the Principal Commissioner of Central Tax, Bangalore West Commissionerate, and is dated 7th February 25. If that were to be so, the order requires to be set aside for not having taken note of the reply of the petitioner. The order at annexure is set aside. Matters remitted for reconsideration. The authority may relook into the reply of the petitioner, and in light of matter being remanded, petitioner is at liberty to make out additional reply, if any, authority to follow procedure, including affording of opportunity of personal hearing, and proceed with the matter. All contentions on merits are kept open. In light of setting aside of the order and directing reconsideration, petitioner to appear before the respondent
Number 1, my lords.
Number 1, without further notice on 5th of May 2026. All contentions and merits are kept
Lordship,
open accordingly.
Lordship, there is a recovery notice as annexure B, Lordship. That too has to be quashed, Lordship.
Consequent to the setting aside of the order at annexure A, the recovery notice at annexure B is also set aside.
Grateful, Lordship.
Serial number 25, Iran Krishna Swami.
May it please your lordships. Your lordships, in this matter, the petitioner is aggrieved by the blocking of his bank account on the basis of a notice issued under section 79 1C, my lords. The notice speaks about the bank account details of the belonging to the respondent number 4, who's the taxpayer, my lords. The petitioner was a former partner of the respondent number 4 organization, and he resigned way back in 2023 before the proceedings even commenced, my lords. On the basis of this particular notice, my lords, which is enclosed as Annexure G, page 59, my lords, they have freezed my bank accounts, my lords, my personal bank account. Page 59, my lords. 60, my lords, which gives the details of the bank account details, which is ends with 482 and IFSC code 653.
Just thing last.
Please, my lords, there is no mistake on behalf of the respondent. He is issued a notice to the account pertaining to the company, the LLP. And my lords, only thing that he has done is he has mentioned the PAN number of all the directors. It is the bank who has done the mistake of.
Now this TRC 13.
Please. Dated 12/1/2026 at page 59.
Correct. It should be restricted to the account of.
It is restricted. My lords may kindly see at page 60.
Account of the entity.
Yes, at page 60, my lords will get it.
Yes.
Name of the business account, Mrs. Chisel Fitness LLP.
The 4th respondent.
The account details, IFSC details, and the name, the business account. Probably what has happened, my lords, here, there were 3 directors. Probably there were 3 directors during that time, and their PAN numbers has been mentioned in the next column, my lords. Because of that, maybe the 3rd respondent or the bank has attached the account of the petitioner based on the PAN number. It is for the 3rd respondent to come and answer, my lords.
So then we'll stay annexure G and issue notice.
No, my lord, annexure G cannot be stayed, my lords. Annexure G is a valid notice.
No, now in so far as
what should be probably stayed is, my lords, annexure K.
No, particulars of default.
Please.
Now, Chisel Fitness LLP.
Yes.
Isn't it?
Yes, my lords.
So now the account of Chisel Fitness could be attached.
That is what is done, my lords.
Now, where is the account number mentioned?
At page 60, my lords.
Page 60.
The second tabulation, account details.
This account is belonging to Chisel, is
yes.
it?
Yes.
Huh?
Yes, ma'am.
Then now it is enforced against?
What the?
Annexure K, my lords. Page 70, my lords.
Page?
Page 70, Annexure K, my lords. Account number 1145, which belongs to the petitioner in the same bank account, in the same bank, my lords. Sorry.
This is the mistake done by the 3rd respondent.
By the bank. So then we stay annexure K.
Annexure K can be stayed.
The petitioner.
Lords may clear that, make a note that annexure G will not be stayed, and there will be no bar to recover from the company.
Yes. The petitioner.
Getting shelter of the.
My lords, I myself have initiated recovery against respondent number 4, my lords.
Let us see. Petitioner has sought for setting aside of the notice. You have not sought for setting aside K.
My lords, in interim prayers,
Let us see.
In the prayer, my lords, they have not sought for setting aside K.
I sought for
Inter
setting-
prayer, G and K.
I sought for setting aside
In
of
the
the
interim
issued notice at annexure G with further relief in the nature of direction to the respondent to consider representation at annexure H and H1. The case of the petitioner that the notice to third person at annexure G refers to the defaulter, that is the fourth respondent.
yes, my lords.
Full stop. In the said notice, details of the account of the fourth respondent are also mentioned. Full stop. It's submitted that, however, in terms of the action of the bank at annexure K, the account of the petitioner, which is a personal account.
Only a statement, my lords, annexure K.
Correct.
Seems to be only a statement because the account status shows that it is active.
Correct. The account of the petitioner bearing number, the account number ending with 1145 has been attached. Attached, is it?
Yes, my lords. Attached, and they've also debited the amount, my lords. For page 69, my lords, one page before, this is the screenshot which shows that available balance was 26 lakhs 40,000. They hold 40 lakhs 34,000, and they say net available balance negative 13 lakhs 92,000.
Attached and debited.
It is only put on hold, I think.
Hold, my lords.
It is
The
only
hold.
put on hold.
Has been attached. And
It has
there's
been put on hold.
And there is a debit freeze.
Yes, my lord.
Debit freeze for the amount of 26 lakhs 40,000.
The total amount is 40 lakh 34,583. Out of which, my lords, in the petitioner's account, there seems to be 26 lakh 40,000. So that has been put on hold.
26 lakhs 40,833.02.
Yes, my lords.
Just 8.
No. Amount on hold is 40 lakhs.
40 lakhs 34,582. And there's a negative balance, my lords.
No, just one.
Probably should be a OD account.
There's a debit freeze.
Yes, my lords.
There's a debit freeze for the amount of 40 lakh 34,583. In the case of the petitioner, that though annexure G is insofar as a fourth respondent, annexure G sought to be enforced on the personal account of the petitioner, which is impermissible. In light of the contention raised, there would be a direction to the respondent
It can
number.
be disposed of itself, my lords.
No, bank must be.
Please.
That has to be released.
Third respondent.
Third respondent bank to lift its debit freeze insofar as the petitioner's personal account number so and so is concerned. Needless to state, the notice at annexure G remains undisturbed as the same is against the fourth respondent and as against the fourth respondent. Full stop. You serve on some council of Yes Bank, will dispose it of.
Yes, my lords. The standing council for Yes Bank, I will serve my.
You find in the
Yes, my lords.
DRT court.
Yes, my lords. I'll do that, my lords. I'll take it.
So and so, Xavier. Petitioner. Yes, Bank. Yes, Bank. Third council, Shri Francis Xavier, is directed to accept notice for the third respondent bank. List the matter in the same stage on
22nd.
Yes.
26.
Much obliged.
Gauri Shankar M.
Lord, I appear for the petitioner in this case. My Lord, I prefer this present petition challenging the adjudication order dated 30/12 2025, my lord.
My lord, kindly be on page number 17, my lord. Para number 12, my lord.
Yes.
Taxpayer has replied to the show cause notice, form number so and so and his entire reply is extracted, my lord. Down, my lord, the taxpayer has paid the partial tax through DRC 03 wide so and so number, so and so amount. Hence, the undersigned, he is hereby issuing order for interest under subsection 9 of the section 73.
My lord, I may make a submission. On 17/9/2025, respondent issued a DRC 01A intimation regarding the shortfall of tax between GSTR 3.1 versus 3B, GSTR 1 versus 3B, claiming for the amount of 5,31,000, including interest and the shortfall of tax.
5 lakhs?
31,322 on 17/9/2025. DRC 1A was issued to me. So on the same day, I have replied in DRC 1A Part B. I have replied that I have made the part payment to the amount of wide DRC 3 to the amount of 2,40,000. IGST and CGST are on. DRC 3 is attached in page number 3030, my lord.
2 lakhs?
Around approximately around 2,40,000 I have paid against the DRC 1A. Without considering this, the respondent have issued a press show cause notice on 22/9/2025, claiming the entire tax amount without considering the payment made under DRC 03.
Where is your reply now?
It's in page number 35, which is DRC 1A Part B. 35, my lord. DRC 1A Part B, wherein I have sent a reply that, dear sir, for the year 2021, part payment is already done. I attached the DRC 03. DRC 03 at page number 30, my lord.
Page? 30.
DRC 03, wherein I have made CGST 12,432.30 and SGST 1243 and IGST 2,14,832. The respondent has
in
not.
Page number 35, my lord, my learned friend is referring, my lord. Kindly be, if your lordship permit, that sentence may be kindly be verified, my lord. Dear sir, for the year of 2021-22, part payment already done.
Yes, that
I
only I am
attached the DRC 03. Please check and reverse the notice. Give me some more time for clear balance amount. Thank you.
It may be
We have considered his reply.
But in
We have considered and passed an order, but they have not seen the order. They have not further replied also, and they are not bothered.
He's saying that this amount.
Again, show cause notice issued for the entire amount, not for.
Where is the show cause notice?
It is in page 25, my lord. Annexure B, DRC 1A 22/9/2025. Without considering DRC 03, they have issued a fresh notice for entire claim.
They have not given credit for what you have paid.
Yes. It is there. Apart from that, my lord, the reason.
My lord, show cause notice we have issued. They have to give a reply.
I've
Then we will pass an order. They have not given any reply.
No, now order is passed, is
And
it?
they would have challenged
Yes, order,
before the
final order
appropriate
is-
authority.
Final order is passed.
Just 1 minute. So the show cause notice is 22/9.
Yes, ma'am.
Now your reply.
Same day. Again, for show cause notice also, we have made a reply. We have made the payment through DRC 03.
Where is that reply to show cause notice?
17/9/2025.
That is in the adjudication order. They have extracted the same in para 12. Taxpayer has replied SCN through FOB GST DRC 06 by DRN.
Page?
Page 17, my lord.
Good, post it.
Extracted.
Page?
17.
17.
17, my lord.
ಎಲ್ಲಿದೆ 73?
17, ma'am.
The reply is, this is the reply.
Respondent has acknowledged the reply and payment made. Lord, I'll kindly come to the para 7, my lord, wherein the respondent mentioned para 7, page 16. The above discrepancy brought notice to the taxpayer through DRC 01A issued on 17/9/2025, given opportunity to pay the amount of tax ascertained above along with the amount through DRC3, the taxpayer neither replied to the above notice nor made the payment. The observation made by the respondent.
That 79 is replied.
My lord,
That 79 is replied
Yes.
on the same date.
But
my lord, page number 17, my lord.
No, just one
Same
minute.
reply is extracted, my lord, page number 17 of the
referring to
order.
para number
No, para
7.
7,
Para 7.
you have not taken note of his reply.
Yes, my lord.
Para 7, you just see.
My lord, that
The
is the
discrepancies-
notice for DRC 01A, my lord.
He has
For
replied.
intimation.
He has replied to that.
Yes, I replied, I made a payment.
At page 35, he has replied. Page 35.
My lord, the same page 35 is recorded in page number 17 of this order only.
Para 7, madam.
Para number 12, my lord.
Para 7, you see. What is that observation? It's a wrong observation.
Your Honor, also.
My lord, para number 12, my lord.
No, just see para 7 one.
The above discrepancy brought notice to the taxpayer through DRC 01A issued on 17/9/2025 and given the opportunity to pay the amount as ascertained above, along with the amount applicable interest in full through DRC 03 in full, my lord. He has not paid the full.
Oh, just see the next sentence.
The taxpayer neither replied to the above notice nor made the repayment.
He has replied to that at page 35.
So, my lord, in page 18. Lord, page 18, interest under section 50 of KGST Act. Reason assigned for interest is that, page 18, my lord, the interest under section 50 of KGST Act, as per the fact discussed in the above mentioned para, it is clear evident that taxable person has made an undue or excess claim of input tax credit. Here the question is shortfall of tax, but the reason assigned for the interest is that claim of input tax credit which is inadmissible in accordance with law. So they are stating that I have claimed the input ITC. They have initiated the proceeding for shortfall of tax, but here the reason assigned for interest calculation is that I have claimed excess ITC. There is it's like a mechanical order, my lord. Even penalty also interest they have mentioned 1,57,351. There is no reason assigned how they have come to the conclusion of 1,57,351 in page 18 itself, my lord. Abstract. Yes, my lord. I'm paying this honorable court to remand the matter for reply to show cause notice.
Let it go back. You have a look at it.
Date may be fixed.
Remit it back. You consider his reply.
No, my lord, beyond the time he approached, my lord. 1 year delay is there, my lord.
No.
He didn't reply properly.
He has replied, madam. You have not taken note of it.
My lord, same reply is extracted in the same order, my lord. Para number 12, my
How
lord.
did you issue show cause notice for the full amount without taking credit to the amount that he has paid?
Yes, my lord.
However, you said there is a
DRC 03.
wrong ITC claimed. How do you say wrong ITC is claimed? It's only shortfall.
For entrance also, there is no calculation how they have come to the conclusion of 1,50,000, 57,000.
I subject to corrections, Malaj. DRC 1A is only an intimation. Where Malaj is intimated that you pay this tax, you will save yourself from the penalty. If they have discharged the entire amount as intimated in DRC 1A, no further adjudication is necessary, Malaj. If they don't do it, then Malaj DRC 1 is issued under section 73(1). Where Malaj it will be a show cause notice for which they have to file a reply. And if they suffer an order of adjudication, Malaj, automatically penalty also will come.
Correct. In the DRC 1, since he has made some part payment,
yes,
it should be only with respect to the remaining amount.
If he has made part payment, that has to be given credit to.
So his
But
contention,
when they show the balance of amount of tax due,
so his contention is that has not been taken note of.
for example, Malaj, the summary of the order is not here. If the summary of the order is there, my lodge will get it like this one. At page 21, my lodge may kindly see.
Page
21. In this column, Malaj, it should have reflected. That has to be verified, Malaj, whether it has been given credit to and only the remaining amounts have been taken out. Because here the tax amount is only 85,879.
Okay, find out.
Yes, my lord.
When do you want?
Next week, my lord.
My lord, there is no opportunity for personal hearing also, my lord.
Correct, let them
We have sought
verify.
for
A
opportunity.
reply has given, he didn't turn up. If he has a grievance, we'll give the opportunity.
Order is passed
When his
mechanically.
writing is given, 75(3), it will speak
correct.
specifically like that only.
So shall we remit it or you want to verify?
Order is passed mechanically. Ma. There is no reason for calculation. How 1,57,000 is calculated.
You want to verify?
The ITC claim also they're adapting.
You want to verify, madam? Then I'll have it on 15th.
Just let me verify, my lord, next week. My lord.
Relist the matter in the same stage on 15. Yes.
27.
Because in this case, credit is given already in observation, my
Just
lord.
check, just-
Remaining amount, interest and penalty has to be paid. He has not turned up at all.
Just check. But how did you say wrongful ITC? It's only shortfall.
That I will verify.
Appear for
27.
petition.
Sri Hari.
Lordship, in this, the adjudicating authority and the audit authority are one and the same. The Lordship only has given the interim stay in our own case.
Paragraph. Show me the
Audit.
Audit.
Audit observation is at page number 169, Annexure G.
one.
169. Annexure G. Ends at 178, page number 178.
Assistant Commissioner of Commercial Taxes.
Yes,
I'll-
yes, yes, Ma'am.
That is a pending malus on that ground. That is one of the grounds that is taken up. And anyway, it's against an order passed by the first appellate authority. So
Right of the. And the adjudicating order is?
Order is at page number 223, my lord, Annexure N. And the ends at 248. Ends at 248.
Light of the contention that the authority which conducted the audit has also passed the adjudicatory order amounts to violation of principles of natural justice. And noticing that such contention is pending adjudication other matters as well. There would be stay of
Annexure N and P.
annexure N and
P.
P. G accepts notice for the respondents. Respondents are at liberty to seek for modification of the interim prayer on filing the statement of objections.
8. Hariam.
right, malus, there is a specific provision under the VAT Act that any objections with regard to jurisdiction should
Must
be
be
taken
raised
up at the initial stage. Let's here in none of these cases, malus, they have taken up that objection. In every case, they have participated. And only now, malus, it's an afterthought. After 2 years, they come before this court and say, it's one and the same.
Let
Yes, he will adjudicate that in any matter.
Please.
Yes.
let appear for the petitioner, my lord.
Yes.
Petitioner being aggrieved by the impugned order
By
dated 17/2/2020, preferred this petition, my lord, seeking to quash the impugned order, adjudication order passed by the respondent. So, my lord, the show cause notice and the pre-intimation was not served on the petitioners, my lord. Due to the said reason, he could not participate in the adjudication proceedings. The respondent had passed the ex parte order. The matter is for shortfall of tax between GSTR 1 versus 3B. My lord. I may be permitted to reply to the show cause notice and may be permitted to contest the proceeding before the adjudication authority, imposing a nominal.
Yes, Him Kumar.
That's page 12, my lords.
Page?
Page 12. The order starts from page 11, my lords, which is admittedly a year back, 17/2/2025. My lords, at page 12, we'll get the references, my lords. Can you see, my lords? ASMT 10, reply not filed. DRC 1A, reply not filed. DRC 1, reply not filed. Reminder 1, reply not filed. Reminder 2, reminder 3. Then one more after reminder 3 also, there is no reply that is filed.
Yes. Upon cost, we'll remand him.
Please, my lords.
We'll ask him to pay some cost and remedy.
Nominal cost.
Tax amount tumba kammi.
Small amount.
Small amount.
That's the reason I didn't insist on 10%.
Petitioner has challenged the. But what is the reason for non-replying?
He's not communicator. He's an uneducated. Then mail ID what is given for the GST portal is not aware of the communication issued from the respondent.
Has called in question validity of the order of adjudication dated 17/2/25. It submitted that due to bona fide reasons, the petitioner was not able to make out his reply to the show cause notice, and the authority has proceeded to adjudicate the matter by treating the petitioner ex parte on the basis of material available with it. Petitioner submits that if an opportunity is granted, petitioner would make out reply to the show cause notice and meet the grounds raised insofar as discrepancy in GSTR 1 and 3B.
Yes.
Next. Taking note of the assertion of the petitioner and noticing that the order passed is an ex parte order without benefit of any reply on merits, it would be appropriate to set aside the order at annexure A and remit the matter back to the stage of reply to show cause notice. All contentions on merits are kept open. Petitioner to appear before respondent number 1 without a fresh notice on Manjuna date. Manjuna, date. 11th of May 26.
Yeah,
All
filed an appeal
contentions
against
are kept open.
We filed an appeal against this order. Then why the appellate authority is made a party? JC appeal set party ಮಾಡಿ
29. Number 29. Mohan.
Relist on
15.
Yes.
30. Siddhanandas. For the petitioners, Lord, I have challenged two show cause notices, my lord. The first show cause notice at annexure C, P23, my lord. The show cause notice is for the financial year 2017-18.
Just 1 minute. Who appears?
That's, copies have not been served. I think I'll appear for respondent number 3. The state has not been shown as a party in the cause list.
Land Council Arvind Chavan accepts notice for 1 and 2. 1 and 2.
1 and 2.
AJ Hemkumar accepts notice for the third respondent. Serve copies, let them have a look at it.
The challenge to the limitation notification, 56 at 9.
It's already pending, 59 of 2023 and 56 of 2023. There are two notifications, my lord, which extended the time limit for issuance of show cause notice for financial year 17-18 and 18-19. These show cause notices were issued by invoking that extended period of limitation. That matter is pending before the Supreme Court, my lord, because these
Some interim orders are being passed.
Yes, my lord.
Interim orders are granted. Interim orders are granted.
Which?
Relying on the Supreme Court in HCL.
Land Council for the petitioner.
This is pending before the
Submits that
Supreme
the
Court.
challenge to the validity of the
Notification 9 of 2023 and 6 of 2023. That's page 15, annexure. Page 15.
petitioner submits that they have challenged the validity of the notification of 9 of 2023 dated 31/3/2023 as well as notification number 56 of 2023
Issue notice.
dated 28/12/2023 submitted that the validity of the said notification is now pending. Pending, is it?
Pending before the Supreme Court.
Pending before the apex.
But the high courts have held in our favor, saying that it's an ultra vires.
Apex. So, in light of the submission pending in SLP 4240 of 2025.
Yes.
And WP 32883 of 2020.
One more.
In SLP 4240 of 2025. There would be an interim order of stay of
Annexure D and H, my lord. So
it is D and H.
Yes, lord.
Respondents are at liberty to seek for modification of the interim order upon filing statement of objections. Yes.
This is a writ petition challenging the proceedings which pursuant to the tribunal's order as being barred by limitation. Pursuant to filing of the writ petition, the final assessment order has been mastered. So the petition will have to be amended to that extent to bring in the final assessment order and demand notice on record. Can this be taken up next week, Manoj? But however, the similar case, it's serial number 96 for the same SSC for the previous year. On similar circumstances.
That's okay. Now you place it whatever you want.
At serial number 96, it's placed, my lords. That also IA has been placed on record.
Same order.
Same. No, the similar SSC for the previous assessment year.
Correct.
That application has been filed for
Application has
amendment.
been filed.
Assessment order, you have to place it in this matter.
This matter can be taken up next week, my lords, but 94, which is of the similar SSC, if that could require a stay in that, my lords.
94. Now this relist on.
Could it be on the 15th, my lords, because
On
the 30 days will expire and recovery proceedings may
15th.
be initiated.
15th, 94.
I will take notice for the
Six.
respondents.
ಇದರಲ್ಲಿ 31 ನಲ್ಲಿ Land Council Sanmati accepts notice for the respondents. In 94,
96, my lords,
Hmm.
for assessment year 13-14, these also the proceedings pursuant to the tribunal's order has been challenged as being barred by limitations, my lord. In terms of section 153.3 read with 153.5, the order giving effect pursuant to the tribunal's order had to be passed within 1 year from the end of the year in which the tribunal's order was passed.
153,
1 year. end of 1 year from the financial year in which the tribunal's order was passed, my lords.
153.
3. Read with 153.5. As first 153.5, my lords.
Mm. 153.
5, subsection 5.
Yes.
Well, here where an effect to an order under section 254, which is to be given by an assessing officer wholly or partly otherwise than making a fresh assessment or a reassessment, such effect shall be given within a period of 3 months in which the order under section 254 or section 260 or section 262 is received by the principal chief commissioner, principal commissioner. As the case may be, the order under section 263, so and so on. If so the second proviso, right, provided further that where an order under section 250 or 254 or 260 requires verification of any issue by way of submission of any document by an assessee or any other person, or where an opportunity of being heard is to be provided to the assessee, the order giving effect to the said order under section 250 or section 254 or section 260 or section 262 and so shall be made within the period specified in section 5, section 3, subsection 3. In terms of subsection 3, my lords, the order giving effect had to be passed within 1 year, within 12 months.
Subsection 3 says 9 months.
Notwithstanding anything contained in subsection 1(a), 2 and 1(a) and 2, an order of fresh assessment or a fresh order under section 92 CA, as the case may be, in pursuance of an order under section 250 or section 254 or section 263, so and so, setting aside or cancelling an assessment or an order under section 92 CA, as the case may be made at any time before the expiry of 9 months from the end of the financial year in which the order under section 250 or 254 is received by the PCIT and so and so.
9 months.
Yes, Lord.
Huh?
9 months.
So 9 months from when?
Now the tribunal's order has been
communication
passed.
of the order.
So your case, what are the dates?
Dates, my lord, here the tribunal's order has been passed on 1st February 2024.
Yes. Now the order is passed on what date now?
Now no order has been passed, my lords. Person order giving effect to that has not been passed. The first draft assessment order itself came, my lords, in
Your Lordship,
9/2/2026.
you are challenging the notice only.
No.
Copies I have not yet received, my lord.
My lords, pursuant to the tribunal's order, an order giving effect had to be passed.
Correct.
That has not been passed, my lords, and now
Let him have a look at it.
these my lords, in a similar situation, my lords, you're all.
Correct,
Now
madam.
give me that petition copy once again.
We'll have it tomorrow.
Your Lordship, I will just see what they are challenged.
We're challenging the draft assessment order, sir. My lords,
Your
our case
Lordship,
is no proceedings could have.
They are challenging the OGE, my lord, order giving effect on the ground that it is barred by limitation under section 153, my lord. It requires consideration.
All the subsequent proceedings which have been.
Your Lordship can say that not to precipitate till next date of hearing.
I'll just pass on
So
this.
the petitioner submits that the order giving effect to
Order giving effect to.
is passed.
It's not yet been passed, so any
It
order
cannot
giving
be
effect
passed-
ought to have been
Cannot
passed.
be passed at the present point of time as time
Time for passing OGE is
time for
already lapsed.
passing as contemplated under 153(3)
Read with 150.
has already lapsed. Matter full stop. In light of the contention raised, matter requires consideration and there would be stay of.
My lord, pursuant to the, I've filed my application for amendment.
What is the relief now? There
We have
must be
stay of further proceedings.
Proceedings.
stay of further proceedings pursuant to.
My lord,
Pursuant to the notice, my lord.
no, my lord. My lord, the thing is because subsequently I file my IA, the final,
That I'll
the
take
demand
note.
notice will have to be stayed, my lords.
Proceedings pursuant to the demand notice.
All the demand notice has to be stayed and any proceedings pursuant to the final assessment order.
Pursuant to the final assessment order, including the demand notice. Full stop. Next, IA 1 of, IA 2 of
2026.
26.
Annexure Z1 to Z3, my lords.
File seeking amendment is allowed as it is submitted that there are subsequent events that has to be brought on record. Necessary amended petition to be filed. Meeting with me.
May I please, my lord. I'm appearing BC, my lord, item 32. My lord, I'm challenging, my lord.
Just 1 minute, just 1 minute.
Yes.
Dates, all matters which have not reached dates, please collect it from the court officer. In those matters where interim relief is not granted, though notice is issued, you make a request to the court officer, it will be posted in fresh matters list on whichever the nearest day is.
To serial number
Yes.
18.
Serial number 35.
87, my lord. It's by way of the special order. The connected matters before the trial court is related to 74, 75, 50-year-old litigation. This is disposed of 97, serial number 9.
So let us see, you just make a request.
But serial number 101.
Serial number 35.
Dates will be given. Now
That's
I
one
can't-
submission.
Plus, it's a fresh matter.
January it
It's
is
a
not,
fresh
so we'll
matter.
relist it immediately.
Tomorrow it will
Lordship,
be
You
it's
make a request.
common chocus notice issue,
Kindly
my lord.
tomorrow it may be
You
listed.
make a request to the court officer. Those matters, fresh matters which have not been taken up will be repeated. Where interim order is not given, it comes lower down in the list. Also, you make a request, it will come in fresh.
28.
Malords in
But it's a
101,
common
Malords in
chocus
101,
notice,
Malords.
Sir, list one serial number 68. So 35, 39, 45.
Court officer. Court officers have.
one ನಿಮಿಷ wait ಮಾಡಿ. ಯಾವುದು 30 28 28 fresh list ಆಗುತ್ತೆ. 27 ನಮ್ಮೆಲ್ಲ ಪ್ರಕಟಿಸ್ತೀನಿ ಮೇಡಮ್.
ನೀವು ಆಮೇಲೆ ಕಳಿಸಿ ಅದು ಲಿಸ್ಟ್
ಏನಾಯ್ತು ಅಂತ ನಾನು ನೋಡ್ತೀನಿ.
ಲಿಸ್ಟ್ ಟೋಟಲ್ 40 ಮೇಲ್ ಹಾಕಿ
ಹೇಳ್ತೀನಿ. ಆಯ್ತು.
ಕ್ಲೋಸ್ ಆಗಿಲ್ವಾ ಇನ್ನ
ಓಕೆ.
ಒಂಚೂರು ಮೇಲ್ ಹಾಕಿ
28 27 30 31 32 33 34 list to do 35 34 35 36 37 27 ಎಲ್ಲ 38 39 40 ಆಗಿದೆ 41 27 42
ಈಗ ಈ ವೀಕ್
ಇಲ್ಲ
ಇಲ್ಲ ನಾವು ಜನವರಿಯಿಂದ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಜನವರಿ ಯಾವತ್ತಾಗಿದೆ?
27 43 44 45
45
next week
Sir, 16th ಇಲ್ಲ 17th.
ಆಯ್ತು
Sir, into order extend.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ 48
ಸರ್ 27th ಇಲ್ಲ ಸರ್ 27th ಬರಲ್ಲ ಸರ್
50 47 ಆಯ್ತು 47 ಆಯ್ತು 47 9th 48 49
27 4 ಆಗ್ತದೆ ಸರ್
49 ಬಂದು 10th ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಬರುತ್ತೆ 48 27 4 50 51 16th ಆಯ್ತು ಬರುತ್ತೆ ಫ್ರೆಶ್ ಲಿಸ್ಟ್ ಆಯ್ತು 52 53 54 ಸರಿ ಸರ್ ಆಯ್ತು 55 ಆಯ್ತು 55 27 56 27th 59 ಆಗೋಯ್ತು ಅದು 60 ಒಂದೇ ಡೇಟ್ ಎರಡು ಒಂದೇ ಡೇಟ್ ಲಿಸ್ಟ್ ಒನ್ ಲಿಸ್ಟ್ ಒನ್ 32
ಸರ್ 15
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಸ್ಟೇ ಇಲ್ಲ 15th ಸರ್
32
15
33 ನಾಳೆ ರಿಪೀಟ್ ಎಲ್ಲ ಲಿಸ್ಟ್ ಬಂದು ಜಾಸ್ತಿ ಇದೆ ನಾಳೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹೋಗುತ್ತೆ ಹಿಂಗೆ ಬರ್ತೀವಿ ಹಾಕಿ ಅಂದ್ರೆ ಆಯ್ತು 84 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹಾಂ 15th ಇದೆ 34
Sir, next week, 15th.
35
15th, entry ಮಾಡಿಲ್ಲ.
ಬರುತ್ತೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಬರುತ್ತೆ 36
ಅಂತ ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಸರ್
37
Sir, 21st of 27.
ಆಯ್ತು 21st ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ನೀವು ಯಾವತ್ತು ಕೇಳ್ತೀರ ಅವತ್ತು
21st.
ನಾಳೆ ಒಂದಿನ ಬಿಟ್ಟು ಬೇರೆ ದಿವಸ 38 ನಾಳೆ ಜಾಸ್ತಿ ಇದೆ ಇಲ್ಲ ರೀಚ್ ಆಗೋದಿಲ್ಲ ಸರಿ ಅಪ್ಪ ಆಯ್ತು 39 ಆಯ್ತು 40 41 42 41 15th ನೆಕ್ಸ್ಟ್ ವೀಕ್ 42 43
ಇದು ಅದು 143 ನಾಳೆ ಕೊಡುತ್ತೆ.
ಆಯ್ತು 44 ನಾಡಿದ್ದು ಟ್ಯಾಕ್ಸ್ ಅವ್ರು ಯಾರು ಬರಲ್ಲ ಬಂದ್ರೆ ನಿಮ್ಗೆ ಆಯ್ತು ನಾಡಿದ್ದು ಕೊಡ್ತೀನಿ ಬಂದ್ರೆ ನಿಮ್ ತಗೋ 45 46
ಎಂಟ್ರಿ ಮಾಡಲಿಲ್ಲ ಫ್ರೈಡೆ
ಫ್ರೈಡೇನಾ ಫ್ರೈಡೆ ಅವ್ರು ಟ್ಯಾಕ್ಸ್ ಅವ್ರು ಬರಲ್ಲ ಯಾರು
10th ಕೊಡ್ಬಿಡ್ತಾರೆ
10th ರಜಾ ಇರುತ್ತೆ
10th ಮಂಡೇ
15th 13th ರಜಾ 47 ಸರ್ 49
ಸರ್ 47 ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ?
47 15th 48 49
ನಾಳೆ
50 ಸರ್ 50 ನಾಳೆ ಸಿಗ್ಬೋದು 51
15th ಸರ್
52 53
ನಾಳೆ ಸರ್
54
ಶಾರ್ಟ್ ಡೇಟ್ ನಾಳೆ ನಾಡಿದ್ದು
ಟ್ಯಾಕ್ಸ್ ಅವ್ರು ಬರಲ್ಲ ಸರ್ ಟ್ಯೂಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ ಎರಡೇ ದಿನ
ಯಾವತ್ತು ಕೊಡ್ತೀರಾ?
15th,
ಹಾ, okay.
56, 57, 58, 59.
56 ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್? 56 ಫ್ರೈಡೆ ಕೊಡಿ ಸರ್.
ಫ್ರೈಡೆ ಅವ್ರು ಟ್ಯಾಕ್ಸ್ ಬರಲ್ಲ.
ಇಲ್ಲ 15 ಕೊಡಿ.
15 ಕೊಟ್ಟಿರ್ತೀವಿ.
56, 57
ಎಲ್ಲ 15 ಕೊಟ್ಟಿರ್ತೀವಿ.
59, 15.
60
ಸರ್ ನಾಳೆ ಆಗುತ್ತಾ?
ನಾಳೆ
ಸ್ಟೇ ಇಲ್ಲ ಮ್ಯಾಟರ್
ಜಾಸ್ತಿ ಆಯ್ತು. 61 ನೋಡೋಣ. 62, 63,
15. Sir, 62, sir.
62, 15th.
63 sir, ನಾಳೆಗೆ ಇಡಿ ಸರ್. ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸರ್.
ಸರಿ ಆಯ್ತು.
ಸರ್ 63, 15.
64, 15. 65 ನಾಳೆ. 66,
Ask him, call him.
67, 68,
ಸರ್ 68
15, 69,
70 ಫ್ರೆಶ್
ನಾಡಿದ್ದು ಅದೇ MP ಮೇಲೆ ಕೇಸ್ ಅವ್ರು ಬರಲ್ಲ. 69,
70 ಫ್ರೆಶ್ ಮಾಡಿ ನಾಳೆ.
ಆಯ್ತು. 71, 70, 22nd. 72,
15.
73, 9th. ಹಾ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. ನೀವು ಹೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಅವ್ರು ಬಂದು 74
ನಾಳೆ.
ಇವರು ಹೇಳ್ತಾರೆ. ಇನ್ನೊಂದು 75 15th ಆಗ್ತದೆ. ಅರ್ಜೆಂಟ್ 76,
15.
77, 15th. 78
already
15th ಆಗಿದೆ. 80 ಅಪ್ಡೇಷನ್ಸ್ ಇದೆ 2 weeks. 81, 82 ಆಗಿದೆ. 83, 84, 85, 85, 89,
84,
90.
Sir, 90, serial number 90.
Serial number 90, 28.
Okay, sir.
91, 92, 93.
Code officer 92.
92, 28.
Sir, 22nd ಆಗಿದೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಒಂದು ಇಟ್ ನೆವರ್ ರೀಚ್.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆಗ 15th. 15th ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 15th.
ಓಕೆ ಸರ್ 15th, ಥ್ಯಾಂಕ್ ಯು.
93 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. 93 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹೌದು ಸರ್. 94 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. 15 ಬೇಡ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 21.
ಸರ್ 94 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ 15. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ 15.
ಮಾಡಿ ಬರ್ಕೊಂಡು. 97 ಆಗಿದೆ. 98, 99, 100, 101,
101 ನಾಳೆಗೆ ಕೊಟ್ಬಿಡಿ.
ನೀವು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಮೆನ್ಷನ್ ಮಾಡದೆ ನಾನು ಅಷ್ಟು ಬೇಗ ಎದ್ರು.
ನೀವು ಮಾಡಿಲ್ಲ. ನೀವು ಮಾಡಿದ್ರೆ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ. ಅದು ಅರ್ಜೆಂಟ್ ಇತ್ತು ಇದು ಮಾಡೋದು. 102
ನಾಳೆಗೆ ಆಗ್ತಿರಲ್ಲ.
ನಾಳೆಗೆ ಬರುತ್ತೆ. 103 ಆಗಿದೆ. 104 ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿದ್ದೀರಾ? ಹಾಗಾದ್ರೆ ಯಾವತ್ತು ಬೇಕು? ಮುಂದಿನ ವಾರದಲ್ಲಿ. ಮುಂದಿನ ವಾರ ಆದ್ರೂ ಆಚೆ ವಾರ 21ಗೆ. 105, 21st. 106, 21st. 107,
12 ಅದು ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜೂನ್.
ಡೇಟ್ ಕೊಡ್ತಿದ್ದೀರಾ?
ಡೇಟ್ ಕೊಡಲ್ಲ. ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜೂನ್ ಅಂತ ಹಾಕಿದ್ರೆ ಅದು ಬರುತ್ತೆ. 108,
108, sir.
ಬಿ ಗ್ರೂಪ್ಸ್ ಎಲ್ಲ 2 weeks.
Sir, 108.
2 weeks.
Okay.
ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅವ್ರಿಗೆ ಅವ್ರು ಕರ್ಕೊಂಡು ಬರ್ತಾರೆ. 61, 65, 8 ನಾಳೆ. ಅರವಿಂದ್ ಚೌಹಾನ್ ನೋಟಿಸ್ ಆಗಿದೆ ನಾಳೆ. ಅವ್ರು ಇದ್ರು ಅವರು ಲಿಸ್ಟ್ 2 26. ಸುಪ್ರೀತ್ ನಿಮ್ದು 27. ಮೊದಲು ಯಾವ್ದು ಡೇಟ್ ಕೊಟ್ಟಿದೆ ಅದು ನಿಮ್ದು? ಇನ್ನೊಂದು 21st. ಇದು 21st. 22. List 2 22. 2 weeks. Pradeep Nayak. 13th ರಜೆ ಎಲ್ಲಿರುತ್ತೆ? ರಜೆ ಆಗುತ್ತೆ. 13 ಕೊಟ್ಟು ಡೇಟ್ ಕೊಡಲ್ಲ ನಾವು 13th. ಸೆಕ್ಷನ್. ಯಾವುದು? 13 ಆಯ್ತು ಚೇಂಜ್ ಮಾಡಿ. ಡೇಟ್ ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ.
List 44.
List 244. ಏನಂದ್ರೆ ಸರಿ ಆಯ್ತು 27. List 1. Two weeks ಅಂತ ಎಲ್ಲ ಅದೆಲ್ಲ ಪೂರ್ತಿ 2 weeks ಅಂತಂದ್ರು. 2 weeks. List 2 18 ಅದು ಇಲ್ಲ List 2 18. ಅದು ನಾಡಿದ್ದು 10th ಬರುತ್ತೆ. 10th ಶುಕ್ರವಾರ.
List 232, serial number 32.
20 19 10th ನಾಳೆ ಶುಕ್ರವಾರ ಆಗುತ್ತೆ. ಶುಕ್ರವಾರ ಆಗುತ್ತೆ. ಎಲ್ಲ 2 weeks ಸರ್. ವೀಕ್ ಗ್ರೂಪ್ಸ್ ಎಲ್ಲ 2 weeks. ಅಣ್ಣಮಲೈ 2 weeks. ಎಲ್ಲ 2 weeks.
Sir, list 2, serial number 32, sir. Court.
119 ಇಲ್ಲ ಲಿಸ್ಟ್ ಇಲ್ಲ. ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಲ್ಲೇ ಬರೋದು. ಅಲ್ಲಿ ಇರೋದೆಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆ. ಹೌದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಲ್ಲೇ ಬರೋದು. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಲ್ಲೇ ಬರುತ್ತೆ. ಎಷ್ಟು ಟು 10th ಇಲ್ಲ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರಿದ್ರು 9th 10th ಅಂತ ಕೇಳ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರು. 10th ಅಂತಾನೆ ಕೇಳಿದ್ರು ಅವರು. ಇವ್ರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇದ್ರಲ್ಲ 10th ಅಂತ ಕೇಳಿದ್ರು ಸರ್. ವಿವೇಕ್ ಸರ್ 10th ಅಂತ ಕೇಳಿದ್ರು. ನಾವು ಈಗ ಚೇಂಜ್ ಮಾಡಕ್ ಆಗಲ್ಲ. 114 ಇದೆ. ಎಲ್ಲ 2 weeks ಅಂತ ಸದ್ಯ ಈಗ ರೀಚ್ ಆಗೋದು ಮಾತ್ರ ಮುಗಿಸಿ ಬೇರೆ ಎಲ್ಲ
Sir, court officer. List 2, serial number 32.
ಸರ್ ಮಾರ್ಚ್ ಇಂದ 6 times
ಅದು ಗೊತ್ತಿಲ್ಲ ಸರ್. ಸರ್ ಹೇಳಿ ಸರ್ ವಿಸಿ.
List 2, serial number 32, sir.
Serial number 32, list 2.
Yes, sir.
ಸರ್ 2 weeks ಅಂದ್ರು ಸರ್. 2 weeks ಅಮೆಂಡ್ಮೆಂಟ್ ಎಲ್ಲ ಆಗ್ಬೇಕಂದ್ರು.
ಅದೇ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಸರ್. ಅದು ಆರ್ಡರ್ಸ್ ಇರೋದು ಅಮೆಂಡ್ಮೆಂಟ್
ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಬರುತ್ತೆ ಸರ್. ಅದು 2 weeks ಆದ್ಮೇಲೆ ಬರುತ್ತೆ.
2015 ಅಲ್ವಾ ಅದಕ್ಕೆ ಡೇಟ್.
ಹೌದು ಸರ್ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಏನು ಬೇಡ ಸರ್ ಅದೇ ಬಂದ್ಬಿಡುತ್ತೆ. 2 weeks ಆದ ತಕ್ಷಣ ಅದೇ ಬರುತ್ತೆ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ? ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 33.
33 2 weeks ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬೇಕಂತ.